accused has castigated their caste, and no details are given how an incident was taken place. Castigating the PW 1 and 6, and paragraph 56 also very clear that victims and eyewitnesses of the case have consistently deposed the offense committed by the accused, and their evidence is corroborated with each other. That is the contention of the public prosecutor. But it is the duty of the prosecution to prove the motive or the intention behind the offense, and the same is also not proved. The incident place is adjacent to the main gate of the school. If that place is the accident place, definitely the officials who are deputed to maintain the law and order were the eyewitnesses to the incident. First of non-examination of those witnesses and also non-examination of publics who gathered at the place of the incident has made fatal to the case of the prosecution. The trial court, having considered all both oral and documentary evidence, comes to the conclusion that the prosecution has not proved the case beyond reasonable doubt. And one such being the material available on record, and also the trial court appreciated the evidence available on record, considering the incriminating evidence available against the accused persons, and very incident is doubtful since the allegation is that incident was taken place in the public place, that too in the presence of public and officials who have been deputed, and no such evidence before the court, and hence we do not find any ground to admit the appeal. In view of discussions made above, we pass the following order. Appeal is dismissed.
Sahana Basvapatna, Venkatesh Somareddy.
Respondent number 5 by me.
Respondent number 3.
3, 1, 2 and 4 ಯಾರು ನೀವಾ ಯಾರು 1, 2 and 4 ಯಾರು 1, 2 and 4 ಎಲ್ಲರೂ ಇದ್ದೀರಿ ಹೇಳಿ
Hospital. We recollect, my lords, on the last date of hearing, my lords directed SPP ascertain whether the particular IO who has conducted the investigation is still in service or not, my lords, because of shady investigation.
He retired from service ಯಾವಾಗ ಲಾಂಗ್ ಬ್ಯಾಕ್ ಆಯ್ತು ಹೇಳಿ ಏನು ಅಕ್ಯೂಟಲ್ ವಾಟ್ ಇಸ್
The case where this the appeal by the victim. Or the offences are very serious, not 396 and 397, 302, 120B. Now it is the case of the prosecution. Deceased Meera Balakrishna was staying alone in her estate, and the incident took place on 2/3/2008.
Yes, sir. Records ಅಲ್ಲಿ ಅಲ್ಲ ಸರಿ ಬ್ರಾಂಚ್ನವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಜಡ್ಜ್ಗಳೇ ಒರೆಸ್ಕೊಳ್ಳಿ ಎಲ್ಲ ಡಸ್ಟ್ ಹೊಡ್ಕೊಳ್ಳಿ ಅಂತನ ಅಥವೇನು ಅದೆಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಅಷ್ಟಿದೆ ಸರಿ ನಿಮ್ ಯೂನಿಕ್ ಕೊಡಿ ಕ್ಲೀನ್ ಮಾಡ್ಲಿ ಒಂದು ಬ್ರಾಂಚ್ ಅವ್ರ ಕೆಲಸ ಅದು ಅಲ್ವಾ ಜಡ್ಜ್ಗಳಿಬ್ರು ಮಲ್ಕೊಬಿಡ್ಲಿ ಹೋಗಿ ಕೋರ್ಟಿಗೆ ಬರೋದ್ ಬೇಡ ಅಂತನ ಏನು
ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ಗಳು ಮತ್ತೆ ಆರ್ಎಸ್ಸಿಗಳ ಕಥೆ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಮತ್ತೆ ಆರ್ಎಸ್ಸಿಗಳದ್ದು ಅದು
ಡಸ್ಟ್ ಇದ್ದೇ ಇರ್ತದೆ ಆಯ್ತು ಹೇಳಿ
Not accused number 3 was working as a coolie lord in the estate of the deceased, and he was not doing rubber tapping, and was knowing that the deceased was possessing cash and gold in her house. So not it is the case of the prosecution that this accused number 3 conspired with other accused, and on 2/3/2008
ಅಡ್ಮಿಷನ್ ಏನ್ ಕೇಸು ಅಂತ ಹೇಳಿ ಯಾವ್ದನ್ನ ಬಿಟ್ಟಿದ್ದಾರೆ ಏನು ಅಂತ ಹೇಳಿ ಫಸ್ಟ್, ಆಮೇಲೆ ಅಡ್ಮಿಟ್ ಮಾಡಿರ ಆಮೇಲೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ನೋಡೋಣ.
But my first submission to lordship is investigation is perfunctory, very glaring evidence like blood, no blood relatives of the deceased are examined.
ಒಬ್ರನ್ನ ಮಾಡ್ಲೇ ಇಲ್ಲ,
Nobody is not even cited. Even the auto driver who shifted the injured PW1, but is also not cited or examined.
ಸೈಟು ಮಾಡ್ಲಿಲ್ಲ ಅವನ್ನ.
ಇಲ್ಲ.
First who shifted the injured
Yes.
to the hospital?
Yes.
Hmm.
And my lord, in my respective submission, except.
ಈಗ ಅಪಲೆಂಟ್ ಈ ಅಪೀಲ್ ಹಾಕಿದಾರಲ್ಲ ಅವ್ರೆಲ್ಲಿದ್ರು?
But she is in Bangalore.
ಬೆಂಗಳೂರು.
Yes.
ಇನ್ಸಿಡೆಂಟ್ ಅಟ್ ಮ್ಯಾಂಗ್ಳೂರ್ jurisdiction.
ಸುಳ್ಯ.
ಸುಳ್ಯ ಅದೇ ಮ್ಯಾಂಗ್ಳೂರ್ jurisdiction.
ಇದು
ಮ್ಯಾಂಗ್ಳೂರ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್
ಅಲ್ಲ,
ಸುಳ್ಯ. ಸುಳ್ಯದಲ್ಲಿ. ಹ್ಮ್.
ಐವರ್ನಾಡ್ ವಿಲೇಜ್.
ಆಯ್ತು. ನಿಮ್ಮ ಪ್ರಕಾರ while acquitting, what are the incriminating materials were not considered by the trial court? ನೀವೆಲ್ಲ ಈಗ ಹೇಳ್ತಿರೋದೆಲ್ಲ lapses on the part of the IO. ಹೌದಲ್ಲ?
ಹೌದು.
Supreme Court judgment is very clear. Even if there is any lapses, shortcomings on the part of the IO, the public prosecutor can ರಿಟ್ ಅಪೀಲ್ ಆಯ್ತು. ಅದು ಕೂಡ
ಅದು ಕನ್ಫರ್ಮ್
ಆಯ್ತು. ಅದ್ರ ಮೇಲೆ ಮತ್ತೇನಾರು ಹೋದ್ರ
ಅದ್ರ ಮೇಲೆ ಮಾಡಲಿಲ್ಲ.
ಮತ್ ನಾವ್ ಈಗ ಹೆಂಗ್ ನೀವು ಆಲ್ ಇಟ್ ಹ್ಯಾಸ್ ಅಟೈನ್ಸ್ ಇದು ಫೈನಾಲಿಟಿ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇಸ್ ಕನ್ಸರ್ನ್. ಯು ಆರ್ ಹಾರ್ಪಿಂಗ್ ಅಪಾನ್ ಓನ್ಲಿ ಆನ್ ದಿ ಶಾರ್ಟ್ ಕಮಿಂಗ್ ಆನ್ ದಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ಹೌದಾ? ಈಗ ಹೋಗ್ಲಿ ಇರೋ ಎವಿಡೆನ್ಸ್ ನ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಏನು ನಿಮ್ಮ ಇನ್ಕ್ರಿಮಿನೇಟಿಂಗ್ ಎವಿಡೆನ್ಸ್ ಯಾವ್ದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ಅಟ್ಲೀಸ್ಟ್ ಇರೋ ಎವಿಡೆನ್ಸ್ ನೇನೆ. ಯಾಕೆಂದ್ರೆ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇಸ್ ಕನ್ಸರ್ನ್, ಆಲ್ರೆಡಿ ಯು ಹ್ಯಾವ್ ನಾಕ್ಡ್ ದಿ ಡೋರ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್. This court, with regard to the lapses on the part of the investigation is concerned, dismissed the writ petition. Even writ appeal also dismissed. ಹೌದಲ್ಲ? It has attained its finality. ನೀವೀಗ ನೋಡ್ಬೇಕಾರದು ಎಲ್ಲಿ ಅಂದ್ರೆ ಇಲ್ಲಿ admission ಗೆ ಕೇಸು. What are the evidence laid upon by the prosecution? And those evidence whether it is considered or not ಅಂತ ಅಷ್ಟೇ. The scope is very limited. ಹೇಳಿ. ನಿಮ್ಮ ಪ್ರಕಾರ ಯಾರ್ಯಾರು ಸಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ಗೆ?
ನೋಡಿ, ಯಾರು ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಹುದು.
ಮತ್ತೆ
But PW1 Lord is the maid servant. But incidentally or accidentally not she went to the house of this Meera Balkrishna.
Then she found the dead body.
Accused inside. They noticed accused inside. But she was taken inside the house near the kitchen. And she was gagged. Thereafter, after gagging, she became and others, they shifted the injured to hospital, where not her statement came to be recorded. This is the story of the case of the prosecution.
ಅಂದ್ರೆ PW1 ಮಾತ್ರ.
ಹೌದು. PW1 has also not supported the case of the prosecution.
Not supported
in its entirety.
ಮತ್ತೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
But what constitutional courts, in my submission, Lord, where Lord there is a real injustice, grave injustice to the victim.
ಬಟ್ ಇನ್ಜಸ್ಟಿಸ್ ಇದೆ ರೀ. ನಿಮ್ ಕ್ರಿಮಿನಲ್ ಜೂರಿಸ್ಪ್ರುಡೆನ್ಸ್ ನಿಮ್ಗೆ ಗೊತ್ತು ಏನು ಅಂತ. ಹೌದಲ್ಲ? ದಿ ಕೋರ್ಟ್ ಕೆನಾಟ್ ಗಿವ್ ಎನಿ ಮಾರಲ್ ಕನ್ವಿಕ್ಷನ್.
No, I fully agree.
There must be some semblance of evidence before the court that these are the witnesses speaks against the accused persons. And what are the incriminating circumstances to convict an accused? What is that? Even if any evidence before the court, if it is not properly appreciated, then court can admit and re-appreciate the evidence available on record.
That is the principle.
Alva? But ಇಲ್ಲಿ ಏನಿದೆ? Even for admission.
But although Lord, there are several circumstances. Important circumstances are eyewitnesses account hostile, conspiracy not in a bar hostile, last scene hostile.
ಕಾನ್ಸ್ಪಿರಸಿಗೂ ನಾವೇನ್ ಡೈರೆಕ್ಟ್ ಎವಿಡೆನ್ಸ್ ಹುಡ್ಕಕ್ಕಾಗಲ್ಲ. but court can rely upon the circumstantial evidences with
Avru
regard to
hostile.
the conspiracy also. And also they have not supported, conspiracy ku support madilla.
PW 21, 22,
Hmm,
they have not supported.
hmm,
Coupled with that, my lord, even the jewelry for which my lord, these accused committed the offense,
hmm,
but they were intact
hmm,
because of the intervention of this PW1,
hmm,
they could not complete the work.
hmm.
Partly, my lord, they were successful in committing the murder and my lord, causing injuries to PW1. Since PW1 has turned hostile, my lord,
What are the injuries to PW1?
she had suffered grievous injuries.
ಏನ್ ಗ್ರೀವಿಯಸ್ ಏನು?
Yes, my lord, PW9.
ಈ ಕೇಸ್ ಆಫ್ ಏನು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಏನಂತ ಏನ್ರಲ್ಲಿ ಹೊಡೆದ್ರು ಅಂತ ಆಕೆಗೆ?
ಆಕಿ ಗ್ಯಾಗ್ ಮಾಡಿ ಹೊಡೆದಾರೆ ಅಂತ.
ಬರೀ ಗ್ಯಾಗ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು. PW9 ಬ್ಲಾಡ್ is the doctor.
ಹಾ.
He says but that he immediately
ರಿಗಾರ್ಡಿಂಗ್ ಇಂಜುರಿ ಅಷ್ಟೇ.
within 15 minutes.
But the very injured has not supported the case. Doctor evidence ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡೋದು?
ಅದೇ ಅಷ್ಟೇ that's the.
ಹಾ? ಮತ್ತೇನ್ ಹೇಳೋದೈತ್ರಿ? And also no recovery. And
No
also
recovery.
no recovery. Eyewitness is only a PW1. Then if no direct evidence, then court has to look into the circumstantial evidence. Circumstantial evidence ke there must be a chain. Link must be established in respect of each links. ಆ ತರದಕ್ಕೂ ಯಾವ್ದು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ.
I must, I cannot improve the case, but not I must bring to your lordship's kind consideration that not these are the circumstances available.
ಅದೇ
and
PW1
unfortunately,
ಎವಿಡೆನ್ಸ್, PW9 ಎವಿಡೆನ್ಸ್. ದೋ PW9 ಹೋಗ್ಲಿ ಏನಾರು PW1 ಹಾಸ್ಟೈಲ್ ಆದಾಗ ಏನಾರು ಎಲಿಸಿಟ್ ಮಾಡಿಸಿದೀರಾ?
ಏನ್ ಕಾಣಲಿಲ್ಲ.
Then what evidence court has to believe?
But para 62 blood is the.
ಟ್ರಯಲ್
order.
ಕೋರ್ಟ್ನವರು ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ದ ಹೋದ್ರು ಇನ್ ಡೀಟೇಲ್ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಅವ್ರೇನ್ ಡಿಸ್ಕಸ್ ಮಾಡಲ್ಲ if I may say so with respect.
ಹಾ,
But they have only referred to blood the evidence that is recorded
ಹಾ.
and ultimately blood in para 62 page 92.
62 ಇದೆ ಅದೊಂದೇ ಇರೋದು ರೀಸನಿಂಗ್.
ಹೌದು.
ಬಟ್ ಮೇನ್ ನಾನು ಅಂಡರ್ಲೈನ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ ಅದಕ್ಕೆ.
ಅಷ್ಟೇ ಅಷ್ಟೇ.
I have carefully appreciated the entire evidence of the parties laid before the court. It is the case of the prosecution that accused persons were murdered, Meera Balakrishna, and robbed the house of Meera Balakrishna. ರಾಬ್ ಮಾಡಿದ್ಕೇನಿಲ್ಲ. ಏನ್ ರಾಬ್ ಮಾಡಿದಾರೆ? ಏನು ಇಲ್ಲ ಅಲ್ಲ, ಮನೆಯಿಂದ ಏನು ಹೋಗಿಲ್ಲ. ನಿಮ್ಮ ಪ್ರಕಾರ this incident was incomplete because of PW1 ಅಂತ. ಬಟ್ ಅದನ್ನು ಕನೆಕ್ಟ್ ಮಾಡಕ್ಕಿಲ್ಲಲ್ಲ. In order to appreciate the evidence laid before the court, I have carefully looked into the entire evidence. The complainant who is the injured in the incident and eyewitness to the incident, she has been examined as PW1. She has completely turned hostile. Even in the above case, as I have already discussed, it is clear that the incident has taken place on 2/3/2008, but IO has submitted charge sheet in 2012. I have also appreciated the statement of the accused persons recorded under section 313 statement. The said submission made by the accused persons seems more probable in the facts and circumstances of the case. As I have already discussed about the manner in which the investigation has been conducted by the investigating officer, certainly casts a serious doubt. Because accused number 3 to 6 were arrested after lapse of 3.5 years. Arrest ಆಗಿರೋದೇ 3.5 ವರ್ಷದ ಮೇಲೆ.
ಹೌದೌದು.
And IO has submitted the charge sheet after lapse of 4 years from date of incident. ಈಗ ನಿಮ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಪ್ರಕಾರ if PW1 is eyewitness, why there was a delay in arresting these accused persons?
That is the lapse, but that's what I wanted to contend that.
Since
But
nothing has
admittedly,
been
but
recovered,
this
since nothing has been recovered from the custody of the accused persons in connection with the incident, and the entire investigation conducted by CID is totally incomplete one. The present accused persons are no way connected to the present case. The above said facts are going to show that the daughter of the deceased was not satisfied on the investigation conducted by IO, since they have doubt on the investigating agency and the accused persons herein. Under these circumstances, obviously serious doubt arises on the story of prosecution and the alleged involvement of the accused persons in the alleged incident. Under these circumstances, the benefit of doubt always goes in favor of the accused. Hence, in my considered opinion, contentions urged by the learned public court cannot be accepted. This is the reasoning.
Para 12 and
This is the reasoning.
ನಿಮ್ಮ appeal ground ಅಲ್ಲಿ you have taken only 5 grounds. Ground number 1, formal ground. Evidence,
As usual.
the trial court has not considered the evidence of petition witness properly. And the trial court has not properly appreciated the evidence, one. Second ground was period 29, who speaks about
exhibit P11.
settlement deed exhibit 11, executed by Sri N.B. Balakrishna, father of appellant. But the trial court failed to consider contents of exhibit 11. ಇದರಿಂದ ಏನ್ ಗೊತ್ತಾಗ್ತದೆ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ?
Exhibit P29 ಇಟ್ಕೊಂಡು ನಾವೇನ್ ಕ್ರಿಮಿನಲ್ ಜೂರಿಸ್ಪ್ರುಡೆನ್ಸ್ ಅಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡೋದು?
And
there are 3 wills. ಹೌದಾ?
ತಾವು ಇನ್ನೊಂದು ಗ್ರೌಂಡ್ಸ್ ತಗೊಂಡಿದ್ದೀರಾ? The trial court has not at all considered the contents of exhibit P 42, 43, 44, 45, 46, 47, 48. What is the evidentiary value of these documents? And the contents of these documents do not make any incriminating material against the respondents. The third ground is
ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲೂ ಕೂಡ ಯಾವ ಎವಿಡೆನ್ಸ್ ನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳೇ ಇಲ್ಲ, ಎಕ್ಸೆಪ್ಟ್ ಡಾಕ್ಯುಮೆಂಟರಿ ಎವಿಡೆನ್ಸ್. ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಕ್ರೈಮ್ ಇಸ್ ಕನ್ಸರ್ನ್, ನೋ ಇನ್ಕ್ರಿಮಿನೇಟಿಂಗ್ ಎವಿಡೆನ್ಸ್. ಹೌ ಕ್ಯಾನ್ ದಿ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಕನ್ವಿಕ್ಟ್ ದಿ ಅಕ್ಯೂಸ್ಡ್?
Or PW3, my lord, accused number 3 was working admittedly. It is accused number 3 who informed PW3 on the way, saying that one of the deceased was done to death. And my lord, this PW1 has suffered injuries. On that basis, my lord, they went back to the scene of offense, thereafter shifted the injured in an auto rickshaw, and that is how my lord, the complaint came to be registered on the basis of the statement recorded in the hospital, etc. That's how my lord, the story runs. Ultimately, my lord, complaint came to be registered against unknown accused. But my submission to lordship, my lord, when accused number 3 was working in the coffee estate of the deceased, he should have been made accused initially, and that should have been, my lord, made to trace other accused persons, and that's how, my lord, investigation should have proceeded. That is the reason why, my lord, even the evidence of the blood relatives is not recorded. The auto driver who shifted not examined. But initially, when accused number 3 was
ಆಟೋ ಡ್ರೈವರ್ ನ ಸೈಟ್ ಮಾಡಿದ್ರು
ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ರು ನಾನು ಹೇಳೋದು, he came to the spot subsequently on calling him to shift him to the injured to the hospital ಅಷ್ಟೇ. That will not claim, even examining incriminating evidence ಏನು ಬರ್ತಿರ್ಲಿಲ್ಲ ಅವನ ಕಡೆನೂ. But relatives ಕೂಡ they were not at the spot. ನಿಮ್ಮ ಪ್ರಕಾರನೇ ಈ appellant is in Bengaluru. Incident was taken place in Sulia. Even relatives examine ಮಾಡಿದ್ರು what purpose would be served? Maybe there is a lapsus on the part of the IO in non-examination of the relatives of the victim. But how it correlates to the case of the prosecution? ಅಷ್ಟೇ ಅಲ್ಲ? ಏನ್ ನೀವೇನ್ ಹೇಳೋದಿದೆಯನ್ರಿ? ಫೀಸ್ ತಗೊಂಡಿದ್ದಕ್ಕೆ ಏನಾರು ಹೇಳಂಗಿದ್ರೆ ಹೇಳಿ.
Page number 12.
The complaint, appellant counsel is not recovery with regard, and also even eyewitnesses have not supported the case of the prosecution. ಹೌದಾ? ಅಷ್ಟೇ ಅಲ್ಲ? Sole eyewitness is
turned
PW1.
PW1. Para 12 and 13, trial judges extracted the evidence also. Para 12 and 13.
ಹಾಸ್ಟೈಲ್ ಇದ್ದಾಗ ಅದನ್ನ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ ಏನ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂತಲೂ ಹೇಳಿದ್ದಾರೆ ಅವರು. ಹಾಸ್ಟೈಲ್ ಮಾತ್ರ ಅಂತ ಹೇಳಿಲ್ಲ. ಏನ್ ಎವಿಡೆನ್ಸ್ ಏನು ಅಂತಾನು ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದಾರೆ.
This matter is listed for admission. Heard the counsel appearing for the appellant and also the counsel appearing for the respondents 1, 2, 4, and also the counsel for R3 and the state public prosecutor for R6 and counsel for R5. This appeal is filed against the judgment of acquittal passed by the 5th Additional District and Session Judge D.K. Mangalore, sitting at Puttur, Dakshina Kannada. The case of prosecution is that PSI of Sulya police have registered FIR in crime number 53 of 2008 for the offence punishable under section 448, 323, 302, read with section 34 of IPC against the accused persons. In the complaint, it is alleged that Srimati Meera Balakrishna, who was living alone at her house situated at Palappadi, Ivarnadu village, and she owned a rubber and aracanut farm, within bracket estate. The accused number 3, who is working in her farm, and he knows that, she keeps more money in her house. That on 2/3/2008 at about 8 a.m., with an intention to rob the house of Meera Balakrishna, he has taken the assistance of other accused persons. Along with him, had been to the house of Meera Balakrishna. When they saw the complainant, that is Srimati Vimala, maid servant, working in the house of Meera Balakrishna, coming to the house of Meera Balakrishna, they called her to come soon. And when she went there, accused number 2 and 4 dragged her and they pressed her neck to the floor, choked her and tried to kill her, assuming her to be dead as she was unconscious, left her there. Thereafter, with an intention to rob the house of Meera Balakrishna, accused number 1, 2, 4, and 6 have trespassed into the said house, tied the hands and legs of Meera Balakrishna with the rope, who was in the kitchen, stuffed her mouth with cloths and killed her. Thereafter, when they were searching the house of money, after taking key from Meera Balakrishna, the complainant regained her consciousness and shouted. That time, accused persons fled away from there, and she went inside the house. She saw the Meera Balakrishna lying in the kitchen with her hands having been tied by a rope. And hearing her cries, workers came there, and on seeing Meera Balakrishna Gowda, they declared her dead. Hence, she lodged the complaint. On the basis of the complaint, the police, Sulya police, have registered the case. The investigating officer cited 50 witnesses to prove the case, having investigated the matter. And cognizance was taken and the case was committed to the Sessions Court, and the Sessions Court framed the charges, and the accused persons did not plead guilty and claims trial, and hence prosecution. Out of 50 witnesses, examined 30 witnesses, that is PW 1 to 30, and got marked document exhibit P 1 to 55, MO 1 to 20 also marked. During the cross examination, defense counsel got the evidence recorded the statement of accused under section 313, and accused did not choose to lead any defense evidence. The trial court, having considered both oral and documentary evidence, particularly the eyewitness PW1 who has been examined before the court and sees the complainant, and she has completely turned hostile, and her evidence is also extracted in paragraph number 12. And she says that she was a housekeeper, and she went to the house of Balakrishna Gowda at 8 a.m. and she doesn't know what was happened on that day, and she was not injured. And when she went to the work to their house, and she went to the hospital for fever, and no one has harmed her. The police also did not interrogate her and not recorded her statement, but she admits her signature in complaint, Exhibit P1, and her signature is marked also Exhibit P1A. But she says that she do not remember whether in the year 2012 the Tahsildar called her or not to Mangalore jail to identify the accused. And also she denies the seizure measure, but she admits her signature in the seizure measure, which is marked before the court. The trial court also taken note of the evidence of PW2 with regard to the inquest measure is concerned in terms of Exhibit P4, and also taken note of the evidence of PW3, who is also the inquest measure
My
witness.
lord, page number 12, last para, while conducting the.
ಯಾವ್ದ್ರಲ್ಲಿ?
Page number 12,
ಹಾ.
while conducting the inquest report of the dead body, Meera Balakrishna, he saw gold ornaments, 3 gold bangles on the left hand, gold.
ಆಯ್ತು, ಅದೆಲ್ಲ ಇರ್ಲಿ ಏನು
And it has given back to the
ಆಯ್ತು.
family.
ಹಾ. ನೆಕ್ಸ್ಟ್ ಏನಾಯ್ತು ಹೇಳಿ ಮೇಡಮ್? PW3 is also the inquest measure witness. And PW4 says that 3 months before this incident, he was working in the rubber trapping in her plantation. Accused number 3 was also doing rubber tapping work in the said plantation. But no any incriminating evidence. PW5
Caesar Master witness.
Caesar Master witness, and PW6 is the along with CID officer Langalingappa and one Lingappa visited to the agricultural cooperative society, and CID officer asked the specimen signature of the Meera Balakrishna to chief executive officer of said society and produced 2 fixed deposit cards amounting to rupees 2 lakh belongs to the Meera Balakrishna, and speaks about only the major exhibit P7. PW7 Madhava, Sulya Circle Inspector, called him to come to their office. And also police have seized the documents through exhibit P6. His signature is marked. The PW8, he was working as a CEO at Primary Agricultural Cooperative Society. And PW9 is the medical officer who conducted who examined the PW1 with regard to the assault and came to the hospital with the history of unknown person.
History of assault by unknown person.
And issued the wound certificate exhibit P12. And also the given opinion in terms of exhibit P13. And also collected the blood samples of Vimala and handed over to the police.
He also deposed
And
the
also
PM.
deposes with regard to the conducting of the PM, and he has given the PM report in terms of exhibit P14. PW10 is also the Mahajar witness, and PW11 is the scientific officer, and PW12 doing buy and sell vehicle on his auto links business, and police have examined him. The accused Shivraju, who is in the court, had brought Bajaj Discover bike to him and he sold it to someone else. The PW13, Dr. Manjunath, he was the government doctor at Surya Hospital
Who examined accused
who
number
examined the accused persons.
accused number 4.
That is accused for only 4 alla.
Third line. only.
PW14, again the seizure major witness, and PW14 identifies his signature in exhibit P19 and 23. PW16 is also the spot major witness to exhibit P25. PW18 is also the IO. He says that produce the accused number 4 before the primary health center Surya for medical examination. And PW19 served as Tahsildar. At the request of the Surya police, he conducted the identification parade in front of witness Vimala at District Prison, Mangalore. And exhibit P 26 to 27, 28 and 29 and 30 are marked through this witness. PW20 is working as a D group worker at Surya Government Hospital. PW21 is the 21, 22 and 23 working as a cleaner, and PW22 is working as a manager at Hillside Bar and Restaurant. And PW24 is the ASI at Surya. When he was in the duty, he has received the phone call from the police officer and also received the MLC as per exhibit P15
Recorded statement of PW
and recorded statement of PW1.
1. Exhibit P1.
PW15 is the Dinakara, is the photographer who had taken the photographs. And PW26 identifies the signature in the major, which is marked as exhibit P38. And 27 is the ASI of Surya police station. He has received the information that accused number 2 is in Jalsur village, and he appointed CW 26 to 28 and sent them to Jalsur, and they arrested accused number 2. And PW 28 is also
IO.
IO, who came to know that accused number 2 was arrested and directed to visit the spot and conduct the major. And exhibit P 40, 39 and 40, he identifies his signature. PW 29 is also worked as Deputy Superintendent of Police for the said period, conducting of further investigation in the matter. And so also PW 30. He was working as a circle inspector Surya. And he deposed that CID investigating officer PW29 informed him about collecting information about the accused in this case. Accordingly, he appointed his staff to trace the accused and given the information and appointed CW 25 to 30 to monitor the accused and also received the report. The trial court, having considered these evidence available on record, particularly in paragraph number 62, taken note of complainant who is the injured in the incident and eyewitness to the incident, he has turned hostile. And nothing is elicited in the cross-examination of PW1, though she was turned as hostile. And also comes to the conclusion that no material available before the court to comes to a conclusion of proving of guilt of the accused persons. The trial court also taken note of lapses on the part of the IO since accused number 3 to 6 were arrested almost after 3.5 years and charge sheet was also filed after 4 years. The present accused persons no way connected to the present case, hence there is no any incriminating evidence against the accused and acquitted. Being accrued by the acquittal of the accused persons, the counsel appearing for the appellant would vehemently contend that the appreciation made by the trial court is erroneous and fails to take note of case of prosecution, and counsel would submit that it is nothing but an injustice caused in the case on hand, not only by the IO, and also the trial court fails to appreciate the evidence in accepting the case of the prosecution. The counsel also submits that prosecution has examined PW 29 who speaks about the exhibit P11 settlement deed dated 9/11/57 executed by Sri N.M. Balakrishna, the appellant's father, wherein the ancestral properties are to be settled in favor of the appellant and any other children born to his wife, the victim in this case. It is also contended that Sessions Court failed to consider the importance and relevance of this document. And so also the evidence of PW 7 with regard to the exhibit P11 and other documents exhibit P42, 43, 44, 45, 46, 47 and 48. The counsel also submits that even though prosecution examined 30 witnesses and material witnesses is PW 9 doctor, and doctor evidence is very clear with regard to the causing of death of the victim. The PW 28 who speaks to the arrest of accused number 2, that is respond number 1, and his evidence is useful in connecting various acts committed by the accused before commission of the offense, and hence it requires the admission. Per contra, the counsel appearing for the respondents would submit that the trial court considered the star witness of prosecution, that is PW 1, who turned hostile, and in paragraph number 12 and 13 even narrated the evidence of PW 1. The counsel appearing for the respondents also vehemently contend that trial court, while acquitting the accused persons, taken note of that there was no any incriminating evidence against each of the accused persons, and they have been falsely implicated in the case. The counsel also submits that there was a false implication, and when the investigation did not find any material with regard to the crime, and these accused persons have been falsely implicated. The counsel also submits that even any documents with regard to the disposing of property is concerned, that will not help the case of prosecution, and the grounds which have been urged in the appeal doesn't inspire the confidence of this court to admit the appeal. Having heard the appellant counsel and also the counsel appearing for the respondent, and also material available on record, it is not in dispute that in view of the evidence of the doctor PW 9, it is a case of homicide, and issued the PM report. But while considering material on record, court has to look into the evidence available on record. It is the case of the prosecution also that PW 1 is the eyewitness who is working in the house of the deceased, and also she identified the accused persons, and also she was taken to even test identification period. But court has to look into the evidence of PW 1, and PW 1 evidence is very clear that she has turned hostile. It is also important to note that when the injured PW 1 was taken to the hospital, she gave the history as an assault by unknown. And when searching the case, when the same is recorded by the doctor PW 9 who examined the injured and connecting the accused persons, there must be a material before the court. None of the witnesses have supported the case of the prosecution. since except the official witnesses of police witnesses, there is no material before the court. And also there is no any recovery at the instance of the accused persons. When the PW1 eyewitness to the incident, who has been cited as eyewitness and turned hostile, and court has to look into the circumstantial evidence to connect the accused. But in the case on hand, with regard to the circumstantial evidence also, there is no any recovery. And only motive attributed is only to rob the wealth of the deceased. But with regard to the said allegation also, nothing is on record. And no material with regard to the motive is also concerned. And there is no any robbing of any articles belongs to the deceased. But no doubt counsel appearing to the complainant would submit that before completing their act, when the PW1 has regained her conscience, there was no any robbing of any articles belongs to the deceased. But when there is no connecting material, and in a case of circumstantial evidence also, there must be a link, and each link must be established. And the motive is also significant in committing the crime. And the same is also irrelevant for the circumstantial evidence. If there are any eyewitness or direct evidence, then motive is irrelevant. But in the case on hand, when the eyewitness has turned hostile and no other evidence before the court connecting the accused persons, even on the circumstantial evidence, and no such sound evidence before the court, that trial court comes to other conclusion. The trial court, having reassessed both oral and documentary evidence available on record, as well as principles laid down in the judgment which have been discussed in the judgment, particularly in paragraph number 62, comes to the conclusion that no incriminating evidence to connect the present accused persons, and they are not connected to the present case, and no material to connect the accused in respect of this crime is concerned, and also taken note of delay in arresting the accused persons as well as filing of the charge sheet. And after 3.5 years, the accused persons were arrested, and charge sheet was also filed after 4 years. The counsel during the course of argument also tried to convince this court that there was a lapses on the part of the IO, and approached this court, and this court also dismissed the writ petition as well as writ appeal. And also counsel not disputes the fact that with regard to the lapses on the part of the investigation is concerned also, the same is attained its finality. And when such being the case, only on the ground of lapses on the part of the IO, and this court cannot admit the appeal, and hence we do not find any ground to admit the case considering the material available on record. In view of the discussions made above, we pass the following order. Appeal is dismissed.
SPP,
I make one
Dilraj Rohit,
ಒಂದು ಕಡೆ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್ ಅಂತ ಬಂದು ಕಂಪ್ಲೇನೆಂಟ್ ಇವರಲ್ಲ
ಯಾರು ಕೌನ್ಸಿಲ್ ಫಾರ್ ಕಂಪ್ಲೇನೆಂಟ್?
Victim.
ಈಗ ಕಂಪ್ಲೇನೆಂಟ್ ಅಂತ ಬಂತ, ಆಯ್ತು.
ತಾವು ಡಿಕ್ಟೇಷನ್ ಕೊಡುವಾಗ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಕಂಪ್ಲೇನೆಂಟ್ ಅಂತ ಹೇಳಿ
ಹಾ,
ವಿಕ್ಟಿಮ್ ಅಂತ
ಈಗ ವಿಕ್ಟಿಮ್ ಅಪೀಲ್ ಅಂತ ಅಲ್ಲೇ ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್. ಕಂಪ್ಲೇನೆಂಟ್ ಎಲ್ಲಿ ಬಂದಿದೆ ಅದೆಲ್ಲ ವಿಕ್ಟಿಮ್ ಅಪೀಲ್ ಅಂತ ಹಾಕೊಳ್ಳಿ. ವಿಕ್ಟಿಮ್ ಇಸ್ ದಿ ಡಾಟರ್ ಆಫ್, ಅಲ್ಲ ಹಾಕ್ಬಿಡಿ, ವಿಕ್ಟಿಮ್ ಇಸ್ ದಿ ಡಾಟರ್ ಆಫ್ ದಿ ಡಿಸೀಸ್ಡ್ ಅಂತ ಹಾಕೊಳ್ಳಿ.
ಗ್ರೇಟ್ಫುಲ್ ಫಾರ್ ದಿ ಅಪೀಲ್. ಸ್ಟೇಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಪುಟ್ ಎನಿ.
ಅದೇ ಸ್ಟೇಟ್ ಏನು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ.
ಹಾ, ಅಲ್ಲ ಮೇಲ್ಗಡೆ ಹಾಕ್ಬಿಡಿ, ಅಕ್ವಿಟಲ್ ಅಪೀಲ್ ಬೈ ದಿ ಡಾಟರ್ ಆಫ್ ವಿಕ್ಟಿಮ್ ಅಂಡ್ ಸ್ಟೇಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಫೈಲ್ಡ್ ಎನಿ ಅಪೀಲ್ ಅಂತ ಫಸ್ಟ್ ಹಾಕ್ಬಿಡಿ. ಆಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಅಕ್ವಿಟಲ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. 11 SPP 376 2FN. ದಿಲ್ರಾಜ್
R1.
ನಿತಿನ್ ಗೌಡ KC ಫಾರ್ ಆಟೋ. ಆಟೋ ಯಾರು? ಮದರ್ ಆಫ್ ದಿ ವಿಕ್ಟಿಮ್. ಆಯ್ತು, ಹೇಳಿ ಏನ್ ನೋಡೋಣ. ಏನ್ ಫಸ್ಟ್ SPP. 10/9 ಇನ್ಸಿಡೆಂಟ್. ಜನವರಿ ಇಂತ 21. ಹಾ ಹಾ. But as on the date, what was her age? 14 years 11 months. ಹಾ
DNA analysis was done.
huh,
And as per the DNA report,
huh,
the accused is the father of the victim girl.
huh.
Is, the DNA report is positive with regard to
DNA
the
supports.
parental of the-
ಆಯ್ತು. ಹ್ಮ್, ಹ್ಮ್,
The victim girl, she has supported the case to the prosecution. She
Hmm.
is examined as PW1.
ಹ್ಮ್,
PW2 is the probation officer who has the child welfare and the unit in OT.
ಹ್ಮ್,
She has also supported, she is the complainant to her,
ಹ್ಮ್,
and she has lodged a complaint as per Exhibit P5.
ಹ್ಮ್,
And she has supported the case of the prosecution.
ಹ್ಮ್,
PW3 is the mother of the victim girl.
ಹ್ಮ್,
She is still partly hostile.
ಹ್ಮ್,
PW4 is the uncle of the victim girl.
ಹ್ಮ್,
He has supported the case of the prosecution.
ಹ್ಮ್,
PW5 is also is the sister of the victim girl.
ಹ್ಮ್,
She has also supported the not with regard to the incident,
ಹ್ಮ್,
which it speaks about the stay in the maternal house.
Hmm.
grandparents.
ಹ್ಮ್,
PW6 is the counselor and he has given a report as per Exhibit P7.
ಹ್ಮ್,
That is also supported. This witness is also supported the case of prosecution.
ಹ್ಮ್, ಹ್ಮ್,
PW7 also is partly supported the case of the prosecution.
ಹ್ಮ್,
PW8 is a signatory to the arrest punchnama.
ಹ್ಮ್,
And PW9 also are signatory to the spot punchnama.
ಹ್ಮ್,
They also supported. PW10 is a medical officer and has issued medical report as per Exhibit P9, but this is with regard to the accused.
ಹ್ಮ್,
PW11 is the doctor who has examined the victim girl
ಹ್ಮ್,
and he has given report as per Exhibit P10 saying that she is specifically 32 weeks and 6 days
ಹ್ಮ್,
into her pregnancy.
ಹ್ಮ್,
PW12 is the doctor who examines the victim at the first instance,
ಹ್ಮ್,
where she is first brought to the for examination. PW13 is the owner of the complex where the accused is staying
Hmm.
on rental basis. PW14 is the seizure, is the signatory to the seizure punchnama regarding the presence of the blood and urine samples accused by victim, which is the report is marked as Exhibit P11. And PW15 is the headmistress of the University College of regard to the age certificate. And she is given a study certificate along with copy of transfer certificate as per Exhibit P12.
ಹ್ಮ್,
PW16 is the chief officer of town municipality who post report
Paragraph
regarding
74 to 75. Not trustworthy.
PW17
Tutored at the instance of the uncle and
He has not discussed anything.
Yes, counsel, ಹೇಳಿ. ಯಾರು? Who appears for?
Your Lordship may kindly see, my lord, para 47
ಹಾ,
of the judgment, my lord.
ಹ್ಮ್,
As rightly argued by the learned counsel for the accused, there is no consistency in the evidence of PW1, 2 and 4. And Exhibit P10, Exhibit P10 further indicates that victim girl came to the hospital on 1/9/2021. As on the said date, the victim girl was pregnant.
ಹ್ಮ್,
If at all the accused has committed forcible sexual intercourse in the month of March 2020 or September 2020, how she was pregnant of 8 months as on 1/9/2021.
ಹ್ಮ್,
The year stated by the victim and the documentation are not consistent with each other. These material discrepancies in the evidence goes to root of the prosecution. My lord, there is no corroboration as well, my lord.
Hmm.
The mother of the
What do you say with regard to the DNA test is concerned? DNA.
DNA,
DNA
my
is
lord,
against you only.
my lord, DNA, my lord, the matched matched with the
That he is the biological father of the child.
but my lord, with regard to
Even
the
if any discrepancy in giving the evidence of PW1 that the pregnancy about 8 months as on 1/9/2021, what is your defense? And also, trial court has not discussed anything about DNA and only comes to a conclusion in paragraph number 74 The witness has given the evidence at the influence of her uncle and tutored by him, and even the complaint was lodged as per the instructions of her uncle. What is the error in even complaint is lodged at the instance of the uncle when she was become a pregnant of 8 months for the act of that is whether it goes to the very root of the case of the prosecution?
As per the mother's version, the lordship may kindly see my lord, in page number 22,
Instead of even mother evidence, court has to first look into the evidence of the PW1, who is the victim. Not given, cannot give much importance to the evidence of mother, but the victim who is, it is a case for admission. Heard both counsel and taken note of reasoning of the trial court, matter requires
Please share my
reconsideration.
record.
Admit.
Trial court records may be called.
Records bandillala?
Illa.
The registry is directed to get the records of the trial court and prepare the paper book within 2 weeks, within 2 months. And list this matter for final hearing after preparation of paper book.
Till number 12, SPP Shankarappa.
Discussing model.
Yes.
The last occasion I directed for production of address book of R6 So both are.
R6 ಯಾರ ಈಗ ಅಪಿಯರ್ ಆಗದ್ರಲ್ಲ ಹೇಮಂತ್ ಕುಮಾರ್ ಫಾರ್ R6. ಅಲ್ಲ ಆಯ್ತು, ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು. ಈಗ ಬಟ್ R6 ನೀವು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ರಿ, ವಕಾಲತ್ ಹಾಕಿದ್ರಿ, ಬೇಕಾಗಿಲ್ಲ ಈಗ. R6 ವಾಲಂಟರ್ಲಿ ಫೈಲ್ಡ್ ವಕಾಲತ್ ಅಲ್ಲ ನಾವು.
ಅದು ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೋದು.
Whether it is
Address of the victim can be recorded before.
ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ, ಆಯ್ತು.
That's what.
Sir, now she has represented through
Madam
counsel.
HGP, ನೀವು ಎಲ್ಲಾ ಕೇಸಲ್ಲೂ ಹೀಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀರಾ? ಅವ್ರದ್ದು ಅಡ್ರೆಸ್ ಎಲ್ಲಿದೆ, ಅವ್ರು ಎಲ್ಲಿದ್ದಾರೆ, ಏನ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅಂತೇಳಿ ಎಲ್ಲಾ ಮ್ಯಾಟರ್ಲ್ಲೂ ಹಿಂಗೆ ಸಬ್ಮಿಷನ್ ಕೊಡ್ತೀರಾ? When victim is represented by a particular advocate, what more is required for the court?
ಆಯ್ತು. HCGP files memo along with documents. The same is taken on record in respect of R6. Now the R6 is represented through a counsel. ಆಯ್ತು, ಹೇಳ್ರಿ ನೆಕ್ಸ್ಟ್. ಹೇಳಿ ಮೇಡಮ್, ಹೇಳಿ ಅಡ್ಮಿಷನ್. ಈಗ ಏನಿಲ್ಲ, ಅಲ್ಲಿಗೆ ಸರ್ವಿಸ್ ಎಲ್ಲ ಆದಂಗಾಯ್ತು. R125 ಶಂಕರಪ್ಪ ಇದಾರೆ, R6 ಗೆ ಅವರಿದ್ದಾರೆ. R6 is the girl. 376, 109, section 9, 10, 11 of Child Marriage Act and section 6 and 7 of POCSO.
Complaint against the father, mother, grandmother and uncle.
ಆಕೆ ಕೊಡ್ಲಿಲ್ವಾ ಕಂಪ್ಲೇಂಟ್?
ಆಕೆ ಕೊಟ್ಟಿರೋದು ಇವ್ರ ಮೇಲೆ. And this ಆಕೆ victim has given a complaint against the father, against the mother, grandmother and his son uncle and Pujari at the instigation of NGO.
At the instigation of
NGOs. And ultimately, my lord, the court has come to conclusion, she herself has admitted that she is aged about 20 years. And no marriage is, on the basis of the document available, but marriage has not taken place. It is disproved. And 376 also disproved. And marriage is also disproved. No, she is not.
DNA ಇದೆ ಅಲ್ವಾ?
DNA is not, because DNA conception ಏನ್ ಹೇಳ್ತದೆ, she has got illegal relationship with someone Chirag. The documents we have produced, mark
DNA ಯಾರ ಮೇಲೆ ಇದೆ?
DNA not tallied with the husband, ಇದು accused ಅಂತ ಹೇಳ್ತದೆ.
Not
DNA
tallies with accused.
not tallied with accused.
But paragraph number 75 ಕೊಡಿ. So on overall perusal of the oral and documentary evidence, the prosecution witnesses, it reveals that first of all, there is a delay in filing the complaint, and it is a joint complaint by the victim, PW 5 and 6, and it is in the handwritings of PW 5. Though the victim said to have stated before the principal against the accused persons that the principal has not given any complaint at the time, that time, and PW 5 and 6 have also not given the complaint immediately when they received the information from the principal with regard to the allegations against the accused person. And exhibit P 5 and 6 are not proved since the major witnesses have turned hostile. The investigating officer has not collected any documents to show that accused number 1 has worked in Tumkur and he had a house at Tumkur and the owner of Tumkur house has not examined. The victim in exhibit P4, that is the statement given before the magistrate, has stated that she informed about the alleged incident to the principal as well as the NGO. But in her evidence, she has stated that except before the doctor, she has not stated before anyone about the pregnancy. PW3 admits that in PW3 admits that in the scan report he has not mentioned about the victim's age. PW6 says the victim never met her, or PW5 while the victim was studying in college. But PW5 says the victim told her about the incident. In exhibit P4, the victim has not mentioned about the accused number 1 forcing to her to have sexual act with him. So there are lot of contradictions in the contents of the complaint, contents of exhibit P4 and that of the chief examination, and also the admissions and denial made by the victim in her cross examination. No doubt the accused number 1 to 5 counsel got marked exhibit D1 to D10 at the time of cross examination of PW1 with regard to the WhatsApp chats and statement of PW5 before the court. But the defense counsel has not examined the 3 persons mentioned by the victim in her cross examination, that is her friends, before the court. But this does not mean that the prosecution has proved its case, because first of all the prosecution has to establish its case beyond all reasonable doubt. Then only the reverse burden will be on the accused side to defense. But in the present case, as already stated, the age mentioned by the victim in exhibit P13 and that of the age shown in exhibit P19 to 12 are contradictory to each other. Huh?
As per school records, it is 17 years.
Huh?
He herself has stated 20 years before the.
But ನೀವು ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಿ? ಸ್ಕೂಲ್ ರೆಕಾರ್ಡ್ಸ್ ಗೆ ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಾ?
ಮಾಡಿಲ್ಲ.
Exhibit P9, doctor without verifying any documents has simply mentioned that victim is 2 months pregnant. So in the absence of the medical evidence, it cannot be considered that the prosecution has proved its case on the basis of inconsistency evidence and evidence of police officials. So the question of disproving the prosecution case does not arise. For this point, I would like to rely upon decision reported in writ petition so and so. In view of the ruling and also for the reasons discussed above, prosecution has miserably failed to prove the guilt of the accused beyond all reasonable doubt. DNA test ಅಲ್ಲಿ ಏನಂತಿದ್ದಾರೆ? Whether it matches with accused?
No.
Says that it is not the.
Whether now she is living with along with accused only? ಮತ್ತೆ ಯಾರು? ವರ್ಕಿಂಗ್ ಆಯ್ತ್ರಿ, ಮದುವೆ ಎಲ್ಲ ಮಾಡಿದಾರಲ್ಲ, ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಎಲ್ಲ ಇನ್ವೋಕ್ ಮಾಡಿದಾರಲ್ಲ. ವೆದರ್ ಸಿ ಇಸ್ ಲಿವಿಂಗ್ ನಾಟ್ ಪೇರೆಂಟ್ಸ್, ಬಟ್ ವಾಟ್ ಅಬೌಟ್ ಅಕ್ಯೂಸ್ ಜೊತೆ ಇದಾರಾ? ಇಲ್ಲ, ಬೇರೆ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಸಪರೇಟ್ಲಿ ರಿಸೈಡಿಂಗ್, ನಾಟ್ ಅಲಾಂಗ್ ವಿತ್ ದಿ ಹಸ್ಬೆಂಡ್.
Madam, marriage is not taken place. Marriage is.
ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಹೆಂಗ್ರಿ ಆಗ್ತದೆ?
ಗೃಹ ಪ್ರವೇಶಂ, father is not there for both for the husband, for the accused number 1.
ಅಕ್ಯೂಸ್ಡ್ ಗೂ ಇಲ್ಲ ತಂದೆ?
ಅಲ್ಲ, ವಿಕ್ಟಿಮ್ ಗಿದ್ದಾರೆ, ಅಕ್ಯೂಸ್ಡ್ ಗೆ ತಂದೆ ಇಲ್ಲ.
ಆಯ್ತು,
ಅವ್ರೇನ್ ಮಾಡಿದ್ರು, ಒಂದು ಮನೆ ತಂದೆ, ಅಕ್ಯೂಸ್ಡ್ ಮದರ್ ಇದು ಡಾಟರ್ ಆಫ್ ಮಲಾಡ್ ದಿ ಅಕ್ಯೂಸ್ಡ್ ನಂಬರ್ 2. ಅಜ್ಜಿ ತಾತ ಅಪ್ಪ ಅಮ್ಮ ಇವ್ರು ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು. ಅವರು ಗೃಹಪ್ರವೇಶ ಮಾಡಿದ್ರೆ ಆ ಗೃಹಪ್ರವೇಶದ ಫೋಟೋಗಳು ತಗೊಂಡ್ಬಂದು ಮದುವೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಸಿದ್ದಾರೆ. ಏನಕ್ಕೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಸಿದ್ದಾರೆ ಅಂದ್ರೆ, ಚಿರಾಗ್ ಅನ್ನೋ ಹುಡುಗನ ಜೊತೆ she has got affair because that all documents are produced, she has admitted. ಅದನ್ನ ಕ್ವಶನ್ ಮಾಡಿದ್ರು, ಫಾದರು ಮದರು ಮಾಮ ಎಲ್ಲ ಕ್ವಶನ್ ಮಾಡಿದ್ರು ಮನೆಯಲ್ಲಿ. ಪ್ರಶ್ನೆ ಮಾಡೋದಕ್ಕೆ ಇವಳೇನ್ ಮಾಡ್ಬಿಟ್ರು, ಪ್ರೆಗ್ನೆಂಟ್ ಬೇರೆ ಆಗ್ಬಿಟ್ಟಿದ್ಲು. ಇದೆಲ್ಲ ಮಾಡಿದ್ಯಲ್ಲ, ಇದೆಲ್ಲ ಮರ್ಯಾದೆ ಹಂಗೆ ಅಂತ ಕೇಳೋದಕ್ಕೆ ಅವಳು NGOs ಜೊತೆ ಸೇರ್ಕೊಂಡು ಆ NGOs ಮುಖಾಂತರ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಬಿಟ್ಟು ಆ ಪ್ರೆಗ್ನೆನ್ಸಿಯನ್ನ ಮುಚ್ಚಿಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇವ್ರ ಮೇಲೆ ಹಾಕ್ಬಿಟ್ರು, ಮಾವನ ಮೇಲೆ, ಸೋದರ ಮಾವನ ಮೇಲೆ. ಅದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಗೊತ್ತಾಯ್ತು. ದೆನ್ DNA test ಗೊತ್ತಾಯ್ತು, he is not the person who committed sexual assault, was the
A1 is not the biological father
biological
of
father,
the child ಅಂತ.
conception. ಆ ನಂತರ
Not
not
established.
established. ಆ ನಂತರ ಗೊತ್ತಾಯ್ತು on the basis of
blood clots on the exhibit, blood clots of the victim ಅಂತ ಇದೆ. So it was not compared to match. So it was not established in the report.
ಬಟ್ ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲೆಲ್ಲೋ ಡಿಸ್ಕಷನ್ ಇಲ್ವಲ್ಲ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು DNA ಆಲ್ಸೋ ನಾಟ್ ಸಪೋರ್ಟ್ಸ್ ದಿ ಕೇಸ್ ಆಫ್ ದಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಹೇಳ್ಬೇಕಲ್ಲ.
ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Page number 45 judgment.
Para
55.
55 and perusal of the exhibit that in DNA test if which has opined that victim is included from being the contributor of blood clots sent in item number 1 is identical and matching with DNA profile result of victim sample blood sent in item number 2. DNA profile result said to be product of conception. Blood clots sent in item number 1. Victim sample blood sent in victim item number 2 and Kumar M. Edralli so and so sent in item number 3 is shown in the enclosed table as annexure 1. Therefore, victim is included from being the contributor of blood clot sent. Hence, the identification of paternal relations of said product of conception sent in item number could not be established.
No. ಇಲ್ಲಿ not included ಅಂತ ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ.
Product of conception, blood clot sent in item number 1 could not be established. ಅಲ್ಲ whether it pertains to the accused or not ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅವರು?
ಈ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ
ಅವ್ರು ಅಡ್ಮಿಟ್ ಅಲ್ಲ, DNA ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿ.
DNA ರಿಪೋರ್ಟ್ ನಲ್ಲಿ ಬ್ಲಡ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರಲ್ಲ ಅಕ್ಯೂಸ್ಡ್, ಅದು ದಟ್ ಇಸ್ ನಾಟ್ ಟ್ಯಾಲಿಂಗ್ ವಿತ್ ದಿ ಪ್ರೆಗ್ನೆನ್ಸಿ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ?
Exhibit 34 ಅಲ್ಲಿ it is not tallied with the blood ಇದು ಅಂತ ಹೇಳ್ತಾರೆ.
ಏನ್ DNA profile result said to be product of conception. Blood clot sent in item number 1 ಅಂದ್ರೆ ಆ ಮದರ್ ತಾಯಿದು ಇದೆ.
ತಾಯಿದು ಇದೆ, ಫಾದರ್ ಇದು ಇವ್ರದ್ದು ಇದೆ, ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಇದೆ.
ಇಬ್ರದ್ದು ಕಳ್ಸಿದೆ.
ಇಬ್ರದ್ದು ಕಳ್ಸಿದ್ರೆ ಟ್ಯಾಲಿ ಆಗ್ತಾ ಇಲ್ಲ.
ಟ್ಯಾಲಿ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅಂತ
ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ Exhibit 34.
ಇವ್ರು ಎಲ್ಲಿ ಹೇಳಿ 34 ಇದೆಯಾ?
ಇದೆ
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಮೇಡಮ್?
ಇದೆ.
ರೆಕಾರ್ಡ್ಸ್ ಬರಲಿ ನೋಡಿ ವಿಲ್ ಸಿ. ನೋಡಿ
ಇದು
ರಿಜಿಸ್ಟ್ರಿ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಗೆಟ್ ದಿ ರೆಕಾರ್ಡ್ಸ್. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಕೊಡಿ. Case of Akshata. The DNA profile result said to be a product of conception blood sent in item number 1 Akshata. Kumar. Sent in item number 3 is shown in the enclosed table as annexure 1. Therefore, Akshata RK is included from being the contributor of blood clots sent in item number 1. Hence, the identification of paternal relationship of said to be a product of conception blood sent in item number 1 could not be established.
Not included ಅಂತ ಹೇಳಿಲ್ಲ. ಇದು ರಿಪೋರ್ಟ್ ಸ್ಪಷ್ಟ ಇಲ್ಲ ಸರ್.
ಅದೇ ಹೇಳಿದೆ ನಾಟ್ ಕರೆಕ್ಟ್. ಮ್ಯಾನೇಜ್ ಮಾಡಿದ್ರೆ
ಮತ್ತೆ ಈಗ ಓವರ್ ಲೋಡಿಂಗ್ ಏನಾಗುತ್ತೆ? ಓವರ್ ಲೋಡಿಂಗ್
ವಾಟ್ ಈಸ್ ಹರ್ ಎವಿಡೆನ್ಸ್? ಯಾಕೆಂದ್ರೆ ಇದು DNA ಟೆಸ್ಟ್ ರಿಪೋರ್ಟ್ ಇಸ್ ನಾಟ್ ಕನ್ಕ್ಲೂಸಿವ್. ಒಂಥರ ಅಡ್ಗೋಡೆ ಮೇಲೆ ದೀಪ ಇಟ್ಟಂಗೆ ಬರ್ದವ್ರು. ವೆದರ್ ಇಟ್ ಮ್ಯಾಚಸ್ ವಿತ್ ದಿ ಬಯಲಾಜಿಕಲ್ ಫಾದರ್ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳೋದೇ ಇಲ್ಲ.
She will say this is the third complaint, madam.
Third?
First complaint is 9/10/9. She will discuss this larger complaint before the NGOs. On 25th, my lord, they will carry a larger complaint, they will record the statement the hospital. No FIR will be registered. Even 9th also no FIR was registered. And
Ev- ev-
26th,
Evidence in the PW1 evidence ಎಲ್ಲಿದೆ ಇದು?
yes, evidence PW1 evidence will ask me.
ಅಲ್ಲ ಎಲ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್?
ಹೌದು, ಎಲ್ಲ ಡಿಸ್ಕಸ್ ಮಾಡಿ.
Victim wherein she has deposed that she know the accused number 1 to 4 but she do not know the accused number 5 and she herself gave the complaint as per exhibit P1. She further deposed that on 19/12/2000 there was Gurva Pravesh. At that time her father had also come to the said Gurva Pravesh. Thereafter she and her brother went to her uncle's house and the uncle's house is situated near her grandmother's house. And on the date of Gurva Pravesh during night hours they were discussing about her marriage and on 29th or 30th April she had her brother were brought to her grandmother's house from her uncle's house and at that time she was not keeping well. So she used to go to the hospital and come home. And on 3/5/2000 was her birthday. She came to know that her marriage was fixed at the time. Also she was not keeping well and her family members were making all arrangements to perform her marriage after 10 days from 3/5/2018 and on 13/5/2018 her marriage was performed with accused number 1 and on that day night the accused number 1 tried to have first night with her but she did not agree. So nothing was done on that day with her by the accused. She further deposed that on the next day she was sent to her father's native place at Tadahalli village and she stayed there for 3 days and her parents were forcing her to talk to accused number 1 since she was married to accused number 1 and accused number came to Bangalore and picked up her from the college since she was going to college in the month of May and June 2018 and she and accused number 1 came to house. At that time accused number 1 told her to pack her clothes to go to temple at Tumkur. Accordingly her accused number 1 went to Tumkur in the bike and reached Tumkur at 6:30 and said accused number 1 is out and after the dinner forced her to have sex with her but she did not agree as she had lost day of her periods and the accused number 1 kept quiet and after 2 hours on that day night again the accused number 1 forced her to have sex with her but she refused. At that time the accused number 1 pulled her so showed the knife to her and thereafter squeezed her neck, told her and she do not send her to parents house at Bangalore. So on that day night and also on next day morning accused and on that day both came to Bangalore to her parents house and but she did not inform about their sexual act accused and thereafter but ಅವಳೇ ಮದುವೆ ಆಗಿದ್ದೆ ಮದುವೆ ಮಾಡಿದ್ರು ಅಂತೆಲ್ಲ ಹೇಳ್ತಾಳಲ್ರಿ.
ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳ್ತಾರೆ, then it has not been proved even by the cross examination, but then further it will be elicited by the
ಆಯ್ತು ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ ನೋಡಿ ವಿಲ್ ಸಿ. Registry is directed to get the records of the trial court and list this matter on ಯಾವ ಊರಿಂದ ಇದು ಬರ್ಬೇಕು, ಯಾವ ಊರ್ದ್ರಿ ಪೇಪರ್ಸ್ ಇದು ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲಿದು?
ಬೆಂಗಳೂರು.
ಬೆಂಗಳೂರಾ?
Bangalore.
List this matter on 29/1. 13. Respondent B. Subramani. Go to paragraph number 20, 21, 25, 25, 26. ಏನಿಲ್ಲ ಕೇಸಲ್ಲಿ.
Both were married and
Now they are living together? They are not living together.
out of that, only around on this DNA is positive for his parentage.
That is the only, ಅದ್ ಬಿಟ್ರೆ ಬೇರೆ ಏನಿಲ್ಲ.
They were married, both were married and they knew married, it was not a divorce also.
But what was her ಇದು ಏಜ್ ಅವಾಗೆಲ್ಲ ಅಡಲ್ಟ್ ಅಲ್ಲ? ಅದೇ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 21, 25, 26 ಅಲ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದಾರೆ.
Marriage was not dissolved and living separately. There are contradictions from the witnesses, both the mother and brother.
Complainant shows that complainant fell in love with the accused and both wanted to marry each other. It further shows that they developed sexual relations. The complainant is silent regarding the fact that the accused committed rape on her on 29/5/2012 in her house. The complaint clearly shows that sexual relation was consensual and not forceful. The evidence in chief of PW1 is contradictory to the same. It is seen that the complainant has tried to improve her case by stating that she was raped in her house and that the accused tried Thali to her on 31/5/2012 and has assured her that he would marry her. The entire evidence in chief is in contradiction with the complaint given by the complainant. Similarly, it is contrary to the statement given by her before the medical officer on 23/12/2013, wherein she has stated that under the assurance of marriage, the accused developed physical relationship with her. Not mentioned anything about forceful sexual intercourse by the accused with her on 29/5/2012 in her house. Evidence of ಅದನ್ನು ತಗೊಂಡಿದ್ದಾಳೆ ದುಡ್ಡು 40,000 regularly coming to their house to meet their married daughter so and so. But she was married.
She was married, but she was not
But
divorced.
earlier marriage was not divorced.
Earlier marriage on the way body is
ಮಗು ಇದೆ.
ಇದು ಎರಡನೇ ಈಗ even the accused is married and he is also having a family.
She has received 40,000 from accused towards settlement after filing of the police case. Hence, it is seen that the behavior of the PW1 is also not above board in this case. PW2 in the incident case is medical officer who has given a statement that due to sexual intercourse, the baby is born. This witness has stated that he is unable to state whether the complainant had sexual intercourse with one person or more than one. Attract of the offense of rape, prosecution has to prove forceful sexual intercourse so and so. Third, heard the counsel appearing for the state, that is HCGP Srimati Rashmi Patel, and respondent those served unrepresented. This appeal is filed against the acquittal for the offense punishable under section 376 and 417. The case of the prosecution is that the factual matrix of case of the prosecution is that accused is befriended the complainant and visiting her house regularly, and their friendship turned into a love affair, and accused assured her of marriage, and under the said belief had forceful sexual intercourse with the complainant in the year 2012 against her consent, and hence invoked section 376 of IPC. And also it is the case of the prosecution that accused deceived the complainant by dishonestly representing that he would marry her and had sexual intercourse, and later on refused to marry her, and hence invoked section 417 of IPC. The police, having received the complaint, registered the case and investigated the matter and filed the charge sheet for the above offences. The accused was secured and he did not plead guilty and claims trial, and hence prosecution examined PW 129 and got marked document exhibit P 129. The accused was subjected to 313 statement and also not led any defense evidence. The trial court, having considered both oral and documentary evidence available on record, comes to a conclusion that there is no any material before the court with regard to the forceful sexual act. And the contents of exhibit P1 which are discussed clearly shows that nowhere has the complainant stated anything with regard to the complainant coming in contact with the accused on account of a loan transaction between VG and the present accused. She has nowhere stated that the said Viji, who was a driver and friend of one Dhananjay, who was a driver at the place where the complainant was working, had asked financial assistance from the complainant. It is nowhere forthcoming in the complaint that Viji had asked the complainant to pay the money to the accused from whom he would receive the money. It is seen that there is contradictions in between the complaint exhibit P1 and evidence of PW1 with regard to the year when the complainant met the accused. The complaint is specific that she met the accused in the year 2011, while the evidence of the complainant shows that she met the accused in the year 2012. And on 29/5/2012, she was raped in her house by the accused. The trial court also discussed in paragraph number 21 that the complaint is silent regarding the fact that accused committed rape on her on 29/5/2012 in her house. And considering the evidence available on record, comes to the conclusion that the evidence of PW1 is contrary to the evidence of oral evidence, and also taken note of medical evidence, wherein she has stated that under the assurance of marriage, the accused developed physical relationship with her, and when such statement was made, and the same is also contrary to the statement of given by her before the medical officer. The trial court also in detail discussed in paragraph number 25, 26, particularly in 26, evidence of PW1 shows that she has received rupees 40,000 from the accused towards settlement after filing of the police case. The PW 5 and 6 have stated that PW1 is divorced, but have not stated as to when she got the divorce, and comes to the conclusion that with regard to the divorce is also concerned, there is no any material. And also the doctor evidence is discussed in paragraph number 27 that whether she had sexual intercourse with the accused only or anybody else, no material. And in paragraph number 28 also comes to the conclusion that there was no any forceful sexual intercourse that occurred without the consent of the complainant. And hence, and comes to the conclusion the term consent means one free from any blemishes such as misrepresentation or a mistake of fact. The consent of the complainant being affected by misrepresentation is not proved by the prosecution through the medical evidence, and also taken note of evidence of PW 3, 4, 7 to 9 are basically formal in nature, and having considered both oral and documentary evidence, comes to the conclusion that prosecution fails to prove the case against the accused and acquitted the accused. The counsel also submits that exhibit DNA, exhibit D9, D9, P9, P9, DNA. DNA and positive illalla. Positive idea. DNA report is positive. And the same is not same is not given. Exhibit B9 is the DNA report, which shows the positive report. Being accrued by the acquittal, the present appeal is filed before this court. The main contention of the counsel appearing for the appellant state that the acquittal order passed by the trial court is erroneous when the DNA report is positive and the evidence available before the court is consistent, and minor discrepancies in the evidence of PW1 cannot be magnified by the trial court. The trial court committed an error in concluding that there was no deception on the part of the accused is also erroneous. The counsel also would submit that subjecting her for sexual act resulting in pregnancy and the undeniable birth of a child confirmed by DNA report, coupled with the accused's subsequent refusal to marry, strongly indicates a dishonest inducement from the outset. These are the materials were not considered by the trial court. Is also a married. Accused is not the biological father, does not necessarily disclose the rape. Courts have ruled that paternity is not always central. Corrupted, not determinative.
Advisory still.
Advisory. Double evidence is not really found on the sort of.
ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟಿರಲ್ಲ.
The council also would vehemently contend that the trial court ought not to have extended the benefit of doubt in favor of the accused when DNA test is available before the court and wrongfully discarded the evidence of the prosecution witnesses in minor contradictions and discrepancies which do not affect the case of the prosecution, even though prosecution has proved the guilt of the accused, and hence this matter requires admission. This court also made it clear that in spite of accused responded, Saruda did not choose to appear and engage the counsel. Having heard the counsel appearing for the state and also considering the material available on record, particularly the evidence available on record, the evidence of PW1, it is very clear that she is a married lady. And also no material is placed before the court that she was divorced from earlier husband. It is also important to note that accused is also a married person. And in order to come to a conclusion that there was a forceful sexual act is concerned, and nothing is disclosed in the complaint. And particular date is also not given, though it is stated that it was a sexual act, but the evidence given by the PW1 is contrary. In one breath, she says that she met with accused in the year 2011. But in the evidence, she says that she met with the accused in the year 2012. But he raped her on 29/5/2012. And the same is taken note of in paragraph number 20 by the trial court. And in paragraph number 21 also court taken note of that complainant fell in love with the accused and both wanted to marry each other. And also taking into note of the complaint is silent regarding the fact that accused committed rape on her on 29/5/2012 in her house. And there is an improvement. The complainant clearly shows that sexual relation was consensual and not forceful. The evidence in chief of PW1 is contradictory to the same. It is seen that complainant has tried to improve her case by stating that she was raped in her house and that the accused tied Tali to her on 31/5/2012 and assured her that he would marry her. The entire evidence of chief is contradiction with the complaint given by the complainant. Similarly, it is contrary to the statement given by her before the medical officer on 23/12/2013, wherein she has stated that under the assurance of marriage, the accused developed physical relationship with her. She has not mentioned anything about forceful sexual intercourse by the accused with her on 29/5/2012 in her house when the statement was made before the doctor. The trial court also, even considering the evidence of PW1, it is clear that she was earlier married and she has a son from her first marriage. She has also admitted that when she developed sexual relationship with the accused, her marriage was not legally dissolved. Until date, the same is in existence. The aforesaid evidence of the complainant clearly negates the fact that under the misconception of a marriage and a future date, the accused had sexual intercourse with her. The complainant, being a married woman with a child, clearly had the knowledge that she was married to another man and said marriage was not dissolved, and hence she could not legally enter into a marriage with the accused. This being the case, the question of say being deceived by the accused or consent not being a free consent does not arise. The trial court, having considered this matter as well as the ingredients of section 375, as well as with regard to the offence under section 417 of IPC, in detail discussed the same, and also taken note of the evidence of PW 1 as well as evidence of PW 5 and 6. And their evidence is very clear that accused was regularly coming to their house to meet their married daughter, sister. These witnesses took no action against him to question as to why he was coming to their house or whether he was really unmarried as contended by him. But PW 5 and 6 made an attempt to falsify their evidence that PW1 is divorced, but have not stated as to when she got divorced. But PW1 herself has admitted that she was not divorced and still the marriage is in existence. And having taken note of the evidence of PW1, PW5 and PW6, which are contradictory to each other, and apart from that, there was an admission on the part of PW1 that she had received an amount of rupees 40,000 from the accused towards settlement after filing of the case. And even medical evidence also taken note of in paragraph number 27 and also in paragraph number 28 with regard to the forceful sexual act. And considering the evidence of PW1, PW3, 4, PW7 to 9, taken note of their evidence will not comes to the aid of the prosecution to prove the ingredients of offence section 317, 375 and 417. And all this discussion was made by the trial court while acquitting the accused, and having taken note of the evidentiary value of the PW1 and also the other material available on record, when the complainant has not stated the date of committing the forceful act of sexual act on 29/5/2012 in the complaint, and the evidence of PW1 during the course of evidence, it is an improvement. And all these factors were taken note of by the trial court while considering the case of the prosecution, and rightly comes to the conclusion that offence under section 375 and 417 have not been proved, since the ingredients of those offences are not attracts in the case on hand, considering the evidence, particularly the evidence of PW1. In view of the discussions made above, we pass the following order. Appeal is dismissed.
14, Ramakrishna AV.
My lord, appellant convicted. The first matter, my lord, appellant is an accused.
First second ನೀವೇನೆ
Admit ಆಗಿದೆ. Other two matters already admitted.
ಎರಡು ಅಡ್ಮಿಟ್ ಆಗಿದೆ, ನಿಮ್ದು ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ.
On 3 counts convicted, 302.
ನಿಮ್ಮ ಅಪೀಲು A4
Also.
A4 ಅಲ್ವಾ?
A2 ಮೇಲೆ ಫಸ್ಟ್ ಮ್ಯಾಟರ್
A2 ಅಡ್ಮಿಟ್ ಆಗ್ಬೇಕು.
ಆಗ್ಬೇಕು.
A3 ಇದು
A1 and 3 ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
Based on last in theory ಏನಾಗಿದೆ? 1 2 3 120B 202 converted and thoroughly. This appeal is filed by A2, and this court already admitted the appeal filed by A1 and A3 in criminal appeal number 1866 of 25 and criminal appeal number 2116 of 2025. And having considered the admission already in respect of A1 and A3, and A2 is the present appellant, and this court has to reappreciate the same along with other appeal, and hence matter is admitted. Paper book ಆಗಿದೆಯಾ? Paper book ಆಗಿದೆಯಲ್ಲ? Paper book already, paper book is ready, and hence this matter for final hearing on 2/2/26.
For further hearing, 15, Shankarappa AV.
Your Lordship, in this matter, Your Lordship, the trial court has convicted the accused of offence under section 324 and has imposed fine of rupees 5,000 on each of the accused, Your Lordship. There are totally 3 accused. And the question in this appeal, Your Lordship, is regarding 307, Your Lordship, IPC. And
307 ಏನು evidence ಇದೆ ಮೇಡಮ್?
Your Lordship, for 307, Your Lordship, to prove the intention or knowledge that the accused possessed.
Intention will be in the inside the mind. ಹೌದಾ?
ಹೌದು your
Hmm.
lordship. For-
Mens rea. You have to prove the mens rea.
ಹೌದು your lordship.
To
For not-
attract section 307.
Yes, your lordship.
ಏನ್ evidence ಇದೆ ಹೇಳಿ?
First, your lordship, the evidence of PW1.
Maybe you have a case for 326. 307 ಗೆ ಏನಿದೆ?
Your lordship, PW1 who is the injured, your lordship, PW2, 3 and 5 were the
Injured
eyewitnesses.
ಆಯ್ತು ಮೇಡಮ್, intention ಬಗ್ಗೆ ಹೇಳಿ.
Yes, your lordship. One, your lordship, all of these eyewitness and the injured state about the civil dispute that existed between the accused and the
ಆಯ್ತು, ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ದ ತಕ್ಷಣ intention to kill.
lordship and the nature of weapon that has been.
ಎವಿಡೆನ್ಸ್ ಏನಿದೆ ಹೇಳಿ ಮೇಡಮ್, intention ಬಗ್ಗೆ.
Your lordship.
Speaks about.
ಆಮೇಲೆ ಸರ್ 19 days ಒಳಗಡೆ ಇರ್ತಾರೆ. ಸೆಕ್ಷನ್ 320 ಕೂಡ ಕನ್ಸಿಡರ್ ಗ್ರೀವಿಯಸ್ ಅಫೆನ್ಸ್ ಅಂತ ಬರುತ್ತದೆ.
326.
20 days.
Who is on the head?
Wait a lot.
That way parietal reason. 20 days labor to avoid English injury is concerned, that is correct. Until here is an injury on the parietal reason. Depressed fracture. 326. ಮಾಡಿಲ್ಲ. ಸರಿ ಅದನ್ನು ಸರಿ ಕೈನ ಹಾಕ್ಬಿಟ್ಟವನೇ ನೋಡ್ಬೇಕಾರೆ. ಹಾ.
Your lordship, PW1, your lordship, in his evidence states about the civil dispute, the nature of the weapon used, the assault being on a vital part, which is the head.
Depressed fracture.
Yes, your
Depressed
lordship.
fracture
Depressed
on the
fracture.
head, parietal.
Head, parieto-temporal region, your lordship.
Doctor evidence
Weapon,
PW7.
PW7, PW11,
Intention
PW12.
ಬಗ್ಗೆ, intention to take, do away his life ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ನೀವು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿ.
Yes, your lordship. Your lordship, PW1's chief, your lordship. Your lordship, from the second paragraph.
ಹಾ. Page
Page number 48, your lordship.
48. ಹಾ.
26/10/2011 ರ ಬೆಳಗ್ಗೆ 9:45 ಸಮಯದಲ್ಲಿ ನಮ್ಮ ಕಾಂಪೌಂಡ್ ನಲ್ಲಿರುವ ಪಾರ್ಥಿನಿಯಂ ಕಸವನ್ನು ತೆಗೆದು ತಿಪ್ಪೆಗೆ ಹಾಕಲು ಹೋಗಿದ್ದೆ. ತಿಪ್ಪೆಯ ಹತ್ತಿರವೂ ಇದ್ದ ಕಸದ
ತಲೆ ಮೇಲೆ ಎರಡೆರಡು ಹೊಡೆದ, ಬಲಪಕ್ಕೆ ಮೇಲೆ ಬೆನ್ ಮೇಲೆ ಸಹ ಹೊಡೆದ. ಗುರಪ್ಪ ಬೀಸಿ ಒಗೆದನು. ಕೃಷ್ಣಪ್ಪ ಕಾಲಿಂದ ಒದೆಯುತ್ತಿದ್ದ. ನಾನು ಅವರನ್ನು ತಪ್ಪಿಸಿಕೊಳ್ಳಲು ಕಿರ್ಚಿಕೊಳ್ಳುತ್ತಿದ್ದ. ಕೃಷ್ಣಪ್ಪ, ಮಂಜುನಾಥ್, ಅರುಣ್ ಕುಮಾರ್ ಬಂದು ನನ್ನನ್ನು ಬಿಡಿಸಿದರು. ಅದೇ ವೇಳೆಗೆ ನನ್ನ ತಂದೆ ತಾಯಿ ಸಹ ಅಲ್ಲಿಗೆ ಬಂದರು. ಎಲ್ಲಿದೆ ಇದ್ರಲ್ಲಿ?
Yes, your lordship.
ಟೇಕ್ ಅವೇ ದಿ ಲೈಫ್ ಅಂತ ಹೊಡೆದ್ರು ಅಂತ.
ಅದು ನಂತರ ಮೂವರ
PW1 ನಲ್ಲಿ
ಕತ್ತನ್ನು ನೆಲಕ್ಕೆ ಬಗ್ಗಿಸಿ ಇವತ್ತೇ ಸಿಕ್ಕಿದ್ದಾನೆ, ಸಾಯಿಸಿ ಬಿಡೋಣ ಎನ್ನುತ್ತಿದ್ದರು. ಅವರು ನನ್ನನ್ನು
ಎನ್ನುತ್ತಿದ್ದರು ಅಂದ್ರೆ ಯಾರು?
ಎನ್ನುತ್ತಿದ್ದರು.
ಏನ್ 3 ಜನ ಒಟ್ಟಿಗೆ ಹೇಳ್ತಾರ ಸಾಯಿಸುತ್ತಿದ್ದರು ಅಂತ?
Your lordship,
You have to specifically say that who is attributing the word to take away the life ಅಂತ. 3 ಜನ ಒಟ್ಟಿಗೆ ಹೇಳಕ್ಕಾಗಲ್ಲ. That is an omnibus statement. ಹೌದಿಲ್ಲ?
Yes, your lordship. Your lordship, before that he says accused number 1 ಗುರ್ರಪ್ಪ ಇಟ್ಟಿಗೆಯಿಂದ ಬೀಸಿ ಒಗೆದನು.
ಯಾರು ಅಂತ ನೀವು ನೋಡಿ, ಇದ್ರಲ್ಲಿ ಯಾರು ಅಂತ ಅವ್ನು ಹೇಳೋದಿಲ್ಲ. PW1 3 ಆರೋಪಿಗಳು ನನ್ನನ್ನು ಹಿಡಿದು ಕತ್ತನ್ನು ನೆಲಕ್ಕೆ ಬಗ್ಗಿಸಿ ಇವತ್ತೇ ಸಿಕ್ಕಿದ್ದಾನೆ, ಸಾಯಿಸಿ ಬಿಡೋಣ ಎನ್ನುತ್ತಿದ್ದರು. ಅಂದ್ರೆ ಅವರೇ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ.
Yes, your lordship. Your lordship, even in the complaint, your lordship, it is stated that A1 Gurrappa, your lordship, he was instigating A2 and A3 of the sons of A1.
ಆಯ್ತು, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದಾನೆ? ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟದು, ಎಲ್ಲಿದೆ ಪೇಜ್?
1, your lordship, page number 84.
ಪೇಜ್ ನಂಬರ್
84.
84. ಏನಿದೆ ಅದರಲ್ಲಿ? ದೊಣ್ಣೆ ತಲೆ ಸೈಕಲ್ ಪಂಪ್ ನಲ್ಲಿ ತಲೆ ಭಾಗಕ್ಕೆ ಹೊಡೆದು ರಕ್ತಗಾಯ ಮಾಡಿದನು. ಉಳಿದವರು ಇಟ್ಟಿಗೆ ದೊಣ್ಣೆಗಳಿಂದ ನನ್ನ ಬಲಪಕ್ಕೆಗೆ ಬೆನ್ನಿಗೆ ಹೊಡೆದು ಮೂಗೇಟುಗಳು ಮಾಡಿರುತ್ತಾರೆ. ಹಾಗೂ ಗುರಪ್ಪ ಕತ್ತಿಗೆ ಹೊಡೆಯೋ ಎಂದು ಹೇಳಿದ್ದು, ಇಲ್ಲಿ ನೋಡಿ, ಗುರಪ್ಪ ಕತ್ತಿಗೆ ಹೊಡೆಯೋ ಎಂದು ಹೇಳಿದ್ದು, ನನ್ನನ್ನು ಬೋಳಿ ಮಗನೇ ಇತ್ಯಾದಿ ಕೆಟ್ಟ ಮಾತುಗಳಿಂದ ಬೈದು ಸಾಯಿಸುವುದಾಗಿ ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿದರು. That means there is an improvement in the evidence of PW1 that all of them were discussing to take away his life ಅಂತ. ಬಟ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಗುರಪ್ಪ ಕತ್ತಿಗೆ ಹೊಡೆಯೋ ಎಂದು ಹೇಳಿದ್ದು ಅಷ್ಟೇ ಇರೋದು. ಹೌದಾ? ಇವರಿಗೂ ನಮಗೂ ಜಾಗ ಒತ್ತುವರಿ ಸಂಬಂಧ ಅದೆಲ್ಲ ಇದೆ, ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ. ನೋ. ನೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P1 is contrary to the evidence of PW1 with regard to the intention is concerned. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್.
Your lordship, ಕತ್ತಿಗೆ ಹೊಡೆಯೋ ಅಂತ ಅಂದ್ರೆ neck is a vital part.
ಕತ್ತಿಗೆ ಹೊಡೆಯೋ ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಒಬ್ಬ ಹೇಳಿದಾನೆ.
Yes,
Is it your evidence before the court while examining you? ನಿಮ್ ಎವಿಡೆನ್ಸ್ ಏನ್ PW ನಾವೀಗ ಓದಿದ್ವಲ್ಲ,
ಹೌದು.
ಅವ್ರಿಗೆ ಮಾತಾಡ್ಕೊಳ್ತಾ ಇದ್ರು 3 ಜನ
ಸಾಯಿಸಿರೋ.
ಸಾಯಿಸ್ಬಿಡೋಣ ಅಂತ ಮಾತಾಡ್ಕೋತಾ ಇದ್ರು ಅಂತ.
ಹೌದು your lordship.
ನೀವ್ ಹೇಳಿಲ್ಲ, ಈ ಗುರಪ್ಪ ಹೇಳ್ದ ಅವ್ನ್ ಕತ್ತಿ ಕೊಡಿ ಅಂತ ಹೇಳ್ದ ಅಂತ PW1 ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದಿರಾ? ಆಯ್ತು, ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ಇನ್ಯಾರ ಎವಿಡೆನ್ಸ್?
PW2 also your lordship.
PW2 ಅವನೇನ್ ಹೇಳ್ತಾನೆ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಇಂಟೆನ್ಷನ್ ಇಸ್ ಕನ್ಸರ್ನ್?
1 minute.
ಯಾಕೆಂದ್ರೆ ಈ ಕಂಪ್ಲೇಂಟ್ ಎಕ್ಸಿಬಿಟ್ P1 is given by PW1 only.
PW1 your lordship.
ಆಯ್ತು,
That
ನೆಕ್ಸ್ಟ್
is in the hospital.
PW2 ನಲ್ಲಿ ಏನು?
PW2 your
ಅದೇ
lordship.
ಬೈತಾ ಇದ್ರು ಆಗ್ಲಿ ಅಂತ ಹೇಳಿದ್ರು, ಹರೀಶ್ ಏನಾದ್ರು ಆಗ್ಲಿ ಸಾಯಿಸಿ ಬಿಡುತ್ತೆ. ಇಲ್ಲಿ 3 ಆರೋಪಿಗಳನ್ನು ಫಿರ್ಯಾದಿಯನ್ನು ಕೆಳಗೆ ಕತ್ತು ಹಿಡಿದು ಅಮುಕಿ ಏನಾದ್ರೂ ಆಗ್ಲಿ ಸಾಯಿಸಿ ಬಿಡುತ್ತೇವೆ ಎನ್ನುತ್ತಿದ್ದರು. ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ ದಿ
It is corroborates PW1.
3 ಜನನ 307 ಗೆ ತರಬೇಕು ಅಂತ ಹೇಳ್ಸಿರೋದು. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್
ಅದು ಬಿಟ್ರೆ there is a medical evidence your lordship which shows-
ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಇಂಜುರೀಸ್ ಇದೆ.
and he was continuously hospitalized for 19 days your lordship.
ಹೌದು, ಆಯ್ತು. ಅವನ ಅವತ್ತೇ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಹೋದ, ಅಲ್ಗೆ ಹೋದ, ವಿಕ್ಟೋರಿಯಾಕ್ ಹೋದ ಅಂಡ್ ಆಲ್ಸೋ ನಿಮಾನ್ಸ್ಗೆ ಹೋದ ಆನ್ ದ ಸೇಮ್ ಡೇ.
Yes sir.
Incident in the early morning.
Yes your lordship.
First he went to one hospital.
Yes your
Then they have referred the patient to the Victoria
Victoria
Hospital.
Hospital.
He went to Victoria Hospital at 4:30
Yes sir.
and then he went to the Nimans at 7:30.
Please your lordship.
But trial court comes to the conclusion that these documents were not collected by the IO and
Yeah.
these documents are produced at the time of the evidence and hence it cannot be believed anta. That is the reasoning by the trial
That
court.
is the reason given. Your lordship, it was the witnesses
ಆಯ್ತು,
PW11
ಈಗ
and
307 ಹೋಯ್ತು. 326 ಗೆ ಏನ್ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್?
your lordship 306.
324 ಗೆ ಕನ್ವಿಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು your lordship.
ಬಟ್ ಪನಿಷ್ಮೆಂಟ್ ಅನ್ನು ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಿಮ್ ಪ್ರಕಾರ ಓನ್ಲಿ ಫೈನ್ ಹಾಕಿದ್ದಾರೆ.
For 5,000.
ಆಯ್ತು, ದಟ್ ಡಿಫ್ರೆಕ್ಟ್ಸ್ ಫ್ರಾಕ್ಚರ್ ಆನ್ ದಿ ಪೆರೈಟಲ್ ರೀಜನ್ ಆಫ್ ದಿ ಇಂಜೂರ್ಡ್. ಹೌದಲ್ಲ? 326 ಗೆ.
And even prolonged hospitalization for 19 days.
ಹೌದು.
Your lordship, the acquittal for 326 was based that CT scan report is not produced, your lordship. When we read 326, your lordship, it says, "326, your lordship, is grievous hurt, your lordship, is defined under section 320. Your lordship, 326 is for grievous hurt, your lordship, which is defined in section 320, your lordship. Grievous hurt under 7th, it says fracture or dislocation for which CT scan report is not produced. 8th point, your lordship, it says any hurt which endangers life or which causes the sufferer to be during the space of 20 days in severe bodily pain or unable to follow his ordinary pursuits, your lordship. Here there is prolonged hospitalization which is proved in exhibit P7, your lordship, which is a discharge summary, which says for almost about 19 days he was in hospital, your lordship. He was hospitalized. And here it says for space of 20 days in severely body pain or unable to follow his ordinary pursuits, your lordship. And even the doctors have opined that it is the injury is grievous in nature and it may be caused with MOs 1 to 3, your lordship. All doctors PW 7, 11 and 12 have opined that, your lordship.
Yes.
Your lordship, and for 307, your lordship, the knowledge can can be seen from the circumstances. Here, the circumstance is also the nature of the weapon that is used and the body of the part that is chosen to assault, your lordship. Nature of weapon admittedly is a bicycle pump, your lordship, and a club and a brick. And the body part which is chosen is the head, your lordship.
ಅಂದ್ರೆ ವೈಟಲ್ ಪಾರ್ಟ್ ಅಂತ
Vital part,
ನಿಮ್ಮ
your
ಆರ್ಗ್ಯುಮೆಂಟ್.
lordship. Vital part, and there has been hurt caused, that is hurt caused, your lordship, and it is the his admission is for a prolonged period of 90
Even
days.
considering the nature of injury, even on the vital part of the injured also, intention must be gathered. Here is a discrepancy with regard to the evidence is concerned to invoke section 307. Intention ಎಲ್ಲಿದೆ ನಿಮ್ಮ intention prove ಮಾಡಕ್ಕೆ?
Your lordship, intention is to be gathered through the
ಆಯ್ತು,
circumstances.
326 ಕೇಳಿದ್ದೆ ನಾನು ಆಗ್ಲೇ we are not on 307.
326, your lordship,
We are
yes,
not
for
three-
fracture, CT scan is not.
Fracture ಇದೆ ಅಂತ.
Fracture ಇದೆ ಅಂತ.
Depressed fracture,
Yes, your
doctor has
lordship.
opined
Yes, your
that there is a depressed fracture,
It is-
that too on a vital part,
Yes, your lordship.
that is on the head, parietal region, he had sustained the injury.
And
Next.
prolonged hospitalization.
ಆಯ್ತು, 19 days ಇದನ್ನ.
ಹೌದು, 19 days.
Fracture with 19 days treatment.
Yes, your lordship.
That's
So,
all. Yes.
yes, grievous hurt comes, your lordship.
Huh?
Because of prolonged hospitalization, even if we say that CT scan report is not.
ಆಯ್ತು, 326 are ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು ಕೊಡ್ಬೇಕು? If it is a case for 326.
Yes.
ಲೈಫು ಇದೆ, 10 years ಇದೆ, ಎಷ್ಟು ಕೊಡ್ಬೇಕು? That was a civil dispute between the parties.
Yes, your lordship.
ಅಲ್ವಾ, ಹೌದಾ? ಯಾವ್ದ್ರಲ್ಲಿ? ಇನ್ನೊಂದ್ರಲ್ಲಿ ಅದೇ ಅದು ಇನ್ನೊಂದು ಬೇರೆದು
ಅದು ಬೇರೆದು.
ಅಲ್ಲ, ಅದನ್ನ ಇದನ್ನ ನಾವು ಕ್ಲಬ್ ಮಾಡಕ್ಕಲ್ಲ. When the medical evidence and also the evidence of witnesses. ಆಯ್ತು, ನೀವ್ ಹೇಳಿ ನಿಮ್ ಗ್ರೌಂಡ್ಸ್ ಏನ್ ಹೇಳಿ.
As far as 326 is concerned, whether in the absence of X-ray, whether the fracture can be assumed or not, one aspect, and that has been dealt by the trial court lot in paragraph 24 of the judgment.
Para?
Paragraph number 24.
24.
Yes.
But doctor is examined.
Doctor is examined.
Who is the doctor? Who is the doctor noticed that there was a fracture on the parietal region? PW 11 and 12. PW 7 only first injury PW 7. 7, 11, 12. But 11 and 12 speaks about the fracture. Victoria Hospital ಮತ್ತೆ ಇದರಲ್ಲಿ ಹಾ. ಹಾ.
Fracture cannot be seen. That is the evaluation made by the trial court, and there is absolutely no reason why it should be said. Also, can you see?
Learned counsel for the accused has not denied the nature of injuries sustained by PW1. However, it is well settled that in the bounden duty on the part of the prosecution to prove X-ray or CT scan report to confirm that injury sustained by PW1 was grievous in nature. Failure on the part of the prosecution, the benefit of doubt can be extended to the accused. As such, the prosecution has also failed to prove that accused have committed the offence under 326 of IPC. This is with regard to the observation in taking into note of this judgment.
Paragraph number 18 of the judgment.
Para 18.
Yes.
Oh, e-judgment.
Therefore, the question for determination is limited to find out whether the said injury person is proved to be grievous injury sustained by the accused. Well settled that in other cases, the burden of proof is always on the prosecution, and that burden unless there is a presumption or defense as enumerated in the criminal code 1860 is taken by the accused. In this case, the defense taken by the accused is one of mine. It is clear from the evidence of one that he has given a description of the injury from physical examination of him and has come to the conclusion that the posterior of the middle pharynx. It is well settled that when the cause, it is necessary for prosecution to prove the same beyond reasonable doubt. Evidence of PW1 could only show that there was injury as described in the when PW1 suspected such a fracture, he ought to have referred to the injury to the report or taking X-ray to confirm. To confirm the finding that there is a fracture of human health. It is not acceptable that unless the prosecution reduces the X-ray for I cannot be said that the accused have caused grievous injury to the fracture. To show that in cross-examination of the learned counsel appearing for accused has not disputed the nature of injuries spoken by PW. However,
The same, ಅದು he ಅಲ್ಲ, the same would not have of X-ray by the prosecution.
Sustained fracture of middle pharynx, which is an opinion given by clinical doctor only on the clinical examination of PW. The injuries, here that the finding of the learned sentence, holding that the prosecution has failed to prove that the accused of one and five confirm the offense committed by the was to the justified. Whether it is denied or not, it's a bounded duty on the prosecution to present the case. In this case, also not a working agency. If you see the facts and circumstances of the case, it would be necessary that unless the evidence of case is corroborated by the medical evidence, by producing X-ray, in my humble opinion, not the grievous injury cannot be. Working agency, evidence of clear of zone of weeks of 48.
PW,
PW1 injured.
PW1 evidence.
Yes.
Ah.
Number 48.
Ah.
ಇನ್ನೊಂದು ಒತ್ತುವರಿ ಸಹ
ಅದೇ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ, ಸೂಟು ಇದೆ. ಆಯ್ತು.
ನಮ್ಮ ನಮ್ಮ ಹಾಗೂ ಆರೋಪಿಗಳ ಮಧ್ಯೆ ಎರಡು ಸಿವಿಲ್ ಹಾಗೂ ಇನ್ನೊಂದು ಸಿಂಗಲ್ ಕೇಸ್ ಆಗಿದೆ. ಇನ್ನೊಂದು ಸಿಸಿ ನಂಬರ್ 2 ಮಾಲೂರು ವಿಷಯದಲ್ಲಿ ಆಗಿದೆ. ಅದರಲ್ಲಿ ಆರೋಪಿಗಳು ಬಿಡುಗಡೆಯಾಗಿಲ್ಲ. ಸಿವಿಲ್ ಕೇಸ್ filing false complaints against him. Also, the lordship also kindly see. Then the lordship kindly come to paragraph page 51. ಆರೋಪಿ ನಂಬರ್ 2 ಹರೀಶ್ ಕಾಲೇಜ್ ವಿದ್ಯಾರ್ಥಿ. ನಮಗೂ ಅರ್ಜಿ ನಂಬರ್ ಪ್ರಸ್ತುತ ವಿಷಯದ ಆಸ್ತಿ ವಿಷಯವಾಗಿ 20 ವರ್ಷದ ವಯಸ್ಸು. ನಾನು ಮುಂಚೆ ಜಿಲ್ಲಾಧಿಕಾರಿಯು ಶ್ರೀ ಕೃಷ್ಣಪ್ಪ ಸಾಕ್ಷಿಗಳನ್ನು ತೋರಿಸಿದ್ದೇನೆ. ನಾನು very relevant, but I feel like appropriate to last paragraph. ನನ್ನ ಅಣ್ಣ ನರ್ಸಿಂಗ್ ಪ್ರಸಾದ್ ವಿಲೇಜ್ ಆಫೀಸರ್ ಇದ್ದಾರೆ.
ಏನ?
ಲಾಸ್ಟ್ ಲೈನ್ paragraph 51. ನನ್ನ ಅಣ್ಣ ನರ್ಸಿಂಗ್ ಪ್ರಸಾದ್ ವಿಲೇಜ್ ಆಫೀಸರ್ ಇದ್ದಾರೆ. What I am trying to say is there is a possibility.
ನರ್ಸಿಂಗ್ ಪ್ರಸಾದ್.
Because I have made suggestions to the doctor that false evidence, false reports have been.
ಜಡ್ಜ್ ಆದ ತಕ್ಷಣ ಫಾಲ್ಸ್ ಕೇಸ್ ಕೊಡಿಸ್ತಾರೆ ಅಂತ ಬಿಲೀವ್ ಮಾಡಕ್ಕಲ್ಲ. Court has to see the nature of injuries and whether there is a, here there is no delay. Immediately after the incident, complaint is lodged, injured is shifted to the hospital, not only one hospital, he was taken to the 3 hospital on account of. Hmm.
The witness in earlier case also.
PW2, ಹೇಳಿ.
Please, my lord, you have admitted in the prosecution, this is not that he was.
ಹಾ.
A witness in the earlier criminal case filed by everyone.
ಕೃಷ್ಣಪ್ಪ.
Yes.
ಆಯ್ತು.
So, Prosecutor kindly said he also do not belong to that village.
Hmm.
He comes from a different village. He is a chance witness.
ಆಯ್ತು, even assuming that evidence of PW2 will not comes to the aid of the prosecution.
Also, PW.
What about the evidence of PW1 injured witness evidence?
The prosecutor kindly see he is the habit of finding false complaint against me.
But false andre, there are material documents,
Then the prosecutor kindly.
injuries,
No,
immediate hospital.
he has stated that
Ah.
he has not selected the scan report or anything that you see PW10.
And you have also not challenged the
No, I have challenged.
324?
I have suggested to the doctor.
ಅಲ್ಲ 324 ಗೆ ನಿಮಗೆ ಕನ್ವಿಕ್ಷನ್ ಮಾಡಿದಾರಲ್ಲ, ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರ ನೀವು? ಬಟ್ ನೀವು ಮಾಡಿದೀರಾ ಅಂತ ನಾ ಕೇಳಿದೆ, ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ ಆನ್ಸರ್. ಹಾ ಹಾ ಆಯ್ತು. ಯು ಕ್ಯಾನ್ ಆರ್ಗ್ಯೂ ಬಟ್ ಇಫ್ ನೋ ಮೆಟೀರಿಯಲ್. ಹಾ ಹಾ.
This is case of 2012. Accused number 1 was 62 years at that time.
Accused number?
Accused number 1 was aged about 62 years at that time.
ಹಾ.
What I feel, Lord, it would be in the interest of justice that the section 324 is confirmed and the substantial compensation is given. The injured person, that would meet the ends of justice.
ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಯಾವ್ದು ಅಂತ ನೀವು ಹೇಳೋದು?
Compensation is limited.
ಹಾ.
Any amount you want,
ಹ್ಮ್. ಹ್ಮ್.
compensation ಮಾಡಬಹುದು. That appears to be just concern. As far as doctors are concerned, Lord, can you see?
PW7 ಇಲ್ಲ ಬಿಡಿ, ಅವನು ಬರೀ ಓನ್ಲಿ ಇನಿಷಿಯಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಅಷ್ಟೇ. ಅವನು PW7 ಓನ್ಲಿ ಅನ್ ಇನಿಷಿಯಲ್ ಟ್ರೀಟ್ಮೆಂಟ್. ಅಲ್ಲ, ಒಪಿನಿಯನ್ ಅವ್ರು ಕೊಟ್ರು, ಬಟ್ he referred the patient to the higher up. ಹಾ. ಗಾಯಾಳು ನನಗೆ ವಿಕ್ಟೋರಿಯಾ ಮತ್ತು
ವಿಕ್ಟೋರಿಯಾ ಮತ್ತು ನಿಮಾನ್ಸ್ ಆಸ್ಪತ್ರೆ ಡಿಸ್ಚಾರ್ಜ್ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ರು. ಆ ಆಧಾರದ ಮೇಲೆ ನಾನು ಗಾಯ ಪ್ರಮಾಣ ಪತ್ರ.
ಹಾ.
How influential the injured is. IO does not collect the injury certificate. Or the discharge certificate.
Whether these doctors denies that they have not given that wound certificate.
Pardon me?
Whether the doctors who have been examined, Victoria Hospital doctor and also the Nimans.
Yes, they give them the false.
Right.
Then PW11 order can you see? According to the
PW11 ನಾ?
PW11.
ಹಾ. ಇವರು ವಿಕ್ಟೋರಿಯಾ.
Victoria.
ಅಲ್ಲ ಇವರು 11 is ಹಾ ವಿಕ್ಟೋರಿಯಾ ಹಾಸ್ಪಿಟಲ್ ಡಾಕ್ಟರ್.
Here now PW81.
81.
Yes, I have.
CT brain. Patient was advised for following investigation CT brain.
Then you will also be going to see. This appears to be very important in my submission.
Maybe not produced, but. PW ಅಲ್ಲ 11 ಅಲ್ಲಿ ಏನು? Wound certificate he has not issued. ಆಯ್ತು.
Then you will also be going to come to evidence of PW12. On 2610, page number 82. On 2610, The patient by name Hari Prakash was referred from Victoria.
PW 12 alla? 26/10/2012.
Yes, it was a doctor.
Ah,
On 26/10/2012, the patient by name so was referred from Victoria Hospital. He was referred to history of birth by Gurappa using bicycle form. Actually, if not Gurappa is accused number 1. According to prosecution, it is accused number 2 were sorted with form. Then I have examined PW of Hari Prakash at about 7:15 PM on that. Then the lordship may kindly come to cross-examination. No, admittedly, you not, according to the case of prosecution, not on 26/10/2012, the incident has taken place at about 9:45 AM in the morning. This witness examined.
ಕ್ರಾಸ್ ಅಲ್ಲಿ ಏನಿದೆ ಈ ಕ್ರಾಸ್ ಅಲ್ಲಿ ಏನೂ ಇಲ್ಲಲ್ಲ.
Then the lordship may kindly come.
Patient was sound and fit. I have mentioned the age of injury, which is around 3 hours.
3 hours.
If a stone or a brick falls,
Yes, this injury
in this head injury are likely to happen. ಆಯ್ತು.
if this evidence is taken, then the injury was caused to the PW to when we see all the evidence of PW 7, 11 and 12, the suggestion made by the prosecution, the defense that all the records have been obtained appears to be protected.
ಇವ್ರು ಹೇಳ್ತಾರೆ ಸರ್ ಡಿಪ್ರೆಸ್ಡ್
ಫ್ರಾಕ್ಚರ್ CT ಇದೆ ನೋಡಿ ಇಲ್ಲಿ patient. Further was evaluated a CT scan of his head. Injury reaches the layer of durameter of brain. No evidence of perineal injury. No blood clot in brain. The patient was treated with analgesic and authorities ಅವತ್ತೆ ರಾತ್ರಿ 10:00 ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡ್ತಾರೆ. 7:30 ಹೊತ್ತಾನೆ 10:00 ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡ್ತಾರೆ ಆಫ್ಟರ್ CT scan.
All these lachunas are considered, trial court has rightly come to the conclusion that 376 is wrong, 326 is wrong. And I submitted to Lord into the Minister of Justice. Instead of sending accused jail of 30 years, we confirmed in the 324 and have the substantial compensation to lordship. In default, the lordship may kind of post.
What do you say, madam, with regard to the compensation, substantial compensation is concerned?
Your lordship, that is left up to the discretion of the court, your lordship.
ಎಷ್ಟು ಖರ್ಚಾಗಿದೆ ನಿಮ್ಗೆ ಇದೆಲ್ಲ ಟ್ರೀಟ್ಮೆಂಟ್ಗೆ?
3 ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಹೋದ್ರಲ್ಲ.
More hospital. I do not have instruction with regards to how much money is spent on the treatment, your lordship. But I will leave it to the discretion of the court, your lordship.
326 involved ಮಾಡಿದ್ರೆ compensation ಜಾಸ್ತಿ ಮಾಡಿದ್ರು. Without sentence. But ಇದ್ರಲ್ಲಿ ಮಾತ್ರ ಹಂಗಿದೆ ಅಷ್ಟೇ 324 ಇದೆ. 326 ಇದೆಯಲ್ಲ ಪನಿಷ್ಮೆಂಟ್ ನೋಡಿ. By means of any name shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. ಎರಡು ಮಾಡಬೇಕು 324 ಹಂಗಿಲ್ಲ. Body to another to swallow or receive the blood or by means of any name shall be punished with imprisonment of
Your lordship,
either description for a term which may extend to 3 years or with fine or with both.
ಸೆಂಟೆನ್ಸ್
ಇಲ್ಲಿ
ಸೆಂಟೆನ್ಸ್ ಮಾಡಿಲ್ಲ.
sentence Sentence ಇಲ್ಲಿ extend to 3 years. Or with fine. Or with both. ಎರಡು ಇರುತ್ತೆ. But ಇಲ್ಲಿ ಇದೆ. Discussion term which may extend to 3 years.
It is a Q case of 326.
326.
As far as the 8 of section 320 is concerned, only is admission of the injured to hospital, length of admission is not important. There should be evidence to show that you are not able to attend to this gate work during that time.
But 327th ಅಲ್ಲಿ ಬರುತ್ತೆ ನೋಡಿ fracture. Fracture. 7th ಇದೆಯಲ್ಲ 7th ingredient grievous hurt.
Fracture is health report, that is without any.
Yes, sir, doctors are examined before the court and they say, comes and says that CT scan was also made. We'll consider it, this also. He law laid down by this division bench. We'll consider it. Paragraph number 18 also, that is your argument. We will distinguish it. Material in this case and also material in the present case.
Said in other cases that another division bench has laid down a law saying that the protection of the state is not necessary. After law would be done. Maybe in this case, you know, take any view of this.
But in this case,
X-ray was not taken, I understand.
but here is a case, not only X-ray, even taken CT scan of the brain. That is deposed before the court by the doctor, PW 11 and 12. 11 and 12.
Yes, X-ray is produced before the court. This scan is produced before the court. I have a right to cross-examine. Lordship is aware that in some cases.
ಈ ಪ್ಯಾರಾ 18 ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಹೇಳಿ? ಪ್ಯಾರಾ 18 ಅಲ್ಲಿ however the same would not dispense with the production of X-ray by the prosecution to prove beyond reasonable doubt that the injured had sustained fracture of middle phalanx, which is an opinion given by PW1 doctor only on clinical examination ಅಂತ ಹೇಳ್ತಾರೆ. Here is not a clinical examination opinion. Here is a case of CT brain was taken and found that is.
In reality, whether that CT scan exists or not, we don't know. That is one. Because
Have you suggested to the witness that CT scan brain was not taken anta? These two witnesses? But their evidence here now disputed. CT ನೋಡಿ ಇಲ್ಲಿ ಹೇಳ್ತಾನೆ. Patient was advised the following investigations. CT brain ಗೆ ಅಂದ್ರೆ head injury ಇದೆ, parietal ಗೆ injury ಇದೆ, CT brain. And also his evidence is very clear. First one, investigation wise, CT brain, right temporal depression fracture with species specks of pneumocephaly. No evidence of perennial injury. They have taken CT scan also.
it's what he's saying. I have denied it. I have denied it.
ಏನಂತ?
Lordship can come to page number 81.
ಆಯ್ತು 81.
Last 5 lines. It is false to state that PW1 Hari Prakash and collusion with police officers have created reports regarding the injuries. I have denied it.
CT scan brain ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳಿದೆ. ಆಯ್ತು.
One is whether CT scan is taken or not.
But when the witness comes and deposes before the court that he had advised.
When a witness states that a CT scan is taken, the prosecution has to show that in fact CT scan was taken. One. And secondly, your lordship can see when X-ray and CT scans are not produced, accused is denied an opportunity of cross-examining witness on the basis of those documents.
Right.
Because the lordship can see which experience your lordship knows that when the cases are filed, saying that there is a fracture of leg, when the experience are produced to property of the fracture of hands. And therefore, your lordship can see when the CT scan is taken, whether in fact it indicates there was a fracture or not is a matter to be cross-examined by the prosecution. Because if some instrument or some hair is kept on the glass of that CT scan, it could indicate, it will show that there is a fracture. has said that even if he is not denied by the accused, the production of X-rays, that appears to be the law laid down by the honorable.
Yes.
ಸೊ ತಾವು ಎಕ್ಸ್ರೇ ರಿಪೋರ್ಟ್ ಹಾಕಿಲ್ಲ, CT ಸ್ಕ್ಯಾನ್ ರಿಪೋರ್ಟ್ ಹಾಕಿಲ್ಲ.
Lordship, illa, your lordship. CT scan and X-ray report is not produced, your lordship. Lordship, even the trial court, your lordship, when hearing regarding the sentence, your lordship, page number 40, page number 40 of the judge, of the paper book, your lordship, last 3 lines, what they say, what the trial court opines is, moreover, the accused have been acquitted for the offence punishable under section 326 due to the lacuna on the part of the IO for not securing X-ray and CT scan report of PW1. Hence, the court would like to, that is the observation, your lordship. It is a lacuna on the IA, lordship. It should not affect the complainant, your lordship. And PW1, your lordship, to say that it is false reports created, your lordship, PW1's cross-examination, your lordship, page number 51. Second line, your lordship, it is suggested that 14/11/2012 randu maru helike kottiddene. And your lordship, fifth line from the below, your lordship, it is again suggested nanna moole muridu hoda bagge maru helikeyalli ಹೇಳಿದ್ದೇನೆ. It is just one day after his discharge, your lordship. 14/11, 13/11 he was discharged. One day after, on 14/11 he is given further
This appeal
statement
is filed by victim,
by the victim complainant.
not by state.
Yes, your lordship.
The trial court has clearly referred the accused have been acquitted for the offence punishable section 326 IPC due to lacuna on the part of the IO for not securing X-ray report or CT scan.
Yes, your lordship.
Now the bound on duty on the part of the victim to furnish the same before the appellate court. Have you furnished these documents?
At least you can invoke section 391 and produce the X-ray and CT scan in respect of the brain is concerned. Have you produced?
It's not produced. Your lordship.
Then now you are arguing only with regard to,
First time.
Of justice, substantial compensation for the
I may be permitted
ಆಯ್ತು,
to seek
ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಅಂದ್ರೆ ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು?
13 ಆಗಿರೋ ಸರ್ ಆಗ್ಬಿಡಿ ಡೀಲಿಂಗ್ ವಿತ್
ಒಂದಲ್ಲ ಎರಡಲ್ಲ 3 ಕಡೆ ಗೊತ್ತಿಲ್ಲ.
I may be permitted to seek instructions with regards to the expenses that has been incurred in the, permitted to seek instruction with regards to the expenses incurred in the treatment, your lordship, and my further submission.
You make mention at 2:30.
Cognizable offenses.
324.
This sentence matters. Sentence.
ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಇದೆಲ್ಲ ಹೇಳೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಯಾಕೆ ಹೇಳೋದು? ದಟ್ ಈಸ್ ಓನ್ಲಿ ಫಾರ್ 326. ಸೆಂಟೆನ್ಸ್ ಬಂದಾಗ 324 ಮೇಲೆ ಮಾತ್ರ ಡಿಸ್ಕಸ್.
ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ರು ಇವ್ರು ಏನು ಹಾಕಿಲ್ಲ ಸರ್. ಈ ಅನೌನ್ಸ್ಮೆಂಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
326 ಡಾಕ್ಟರ್ಸ್ ಇದು ನೋಡಿ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ. ಈ ಸೈಟೇಷನ್ ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ ಒಂದು ಕ್ಲಿನಿಕಲ್ ಅಬ್ಸರ್ವೇಷನ್ ಇವು ಸೈಟೇಷನ್ ನೋಡಿ ಏನು ನೋಡಿದೆ ಪ್ಯಾರಾಲಿಟಿ ನೋಡಿ ಒಂದು ಕ್ಲಿನಿಕಲ್ fracture liver cancer, which is an opinion given by doctor only on clinical examination of PW4. It will not the clinical examination.
ಇಲ್ಲಿ ಎಕ್ಸಾಮ್ನೇ ಮಾಡಿದ್ದಾರೆ.
CT brain
ಎಲ್ಲ ಮಾಡ್ಯಾರ. ರಿಪೋರ್ಟ್ ಇಲ್ಲ.
He comes and reposes report. Specific ಆಗಿ ಹೇಳ್ತಾನೆ ಏನಂತ CT PW11 evidence ಅಲ್ಲಿ CT brain analysis not on clinical opinion. PW11 ನೋಡಿ
On examination, he found the following injuries.
Investigation is CT death, right temporal depressed fracture with suspects of conscious also. Okay. At least prosecution, one thing get it section.
ಇಲ್ಲ ಇವರಾದ್ರೂ ನೋಡು ಸಂಬಂಧ ನೋಡ್ಬೋದು ಇಲ್ಲಿ ಈ ಅಪೀಲಲ್ಲಾದ್ರೂ ಪ್ರಯತ್ನ ಮಾಡಿ.
You make submission at 1:30, 2:30.
Please do.
Appeal is pending since 2017. 9 years.
Huh?
Very same doctor show that the injury has been sustained about 415 in the age.
Huh?
Age of injury of PW noted. According to the evidence, the injury must have sustained at 415 the injury. How they were that very anyhow I will give it to you.
Right, no, we'll see. 324, ನಿಮ್ ಪ್ರಕಾರ 324 is correct ಅಂತ.
Your Lordship, just one more submission, Your Lordship. 307, Your Lordship, it talks about intention.
307 ಮತ್ತೆ ಎಷ್ಟು ಸರಿ
Or
ಹೇಳ್ತೀರಿ?
knowledge also, Your
Don't
Lordship.
waste the time of the court. Not a case for 307. I made you to read the evidence of PW1 and PW2 and also the complaint, exhibit P1. In exhibit P1, you says that so and so says like that. But in your evidence, PW1 and 2 says that all of them were discussing. How can court can invoke section 307, intention to do away with the life.
ಅವನ್ನ ಕೊಲೆ ಮಾಡೋ ಸಂಬಂಧ ಈ ರೀತಿ ಹಲ್ಲೆ ಮಾಡಿದ್ರು ಅಂತ ಎಲ್ಲೂ ಬಂದಿಲ್ಲ.
ಅದನ್ನು ಹೇಳ್ಬೇಕು. ಜೀವ ತೆಗೆಯುವ ಉದ್ದೇಶವನ್ನು ಇಟ್ಕೊಂಡು ಬೈಸಿಕಲ್ ಪಂಪ್ನಿಂದ ವೈಟಲ್ ಪಾರ್ಟ್ ಆಫ್ ತಲೆಗೆ ಹೊಡೆದ್ರು ಅಂತ ಹೇಳ್ಬೇಕು. ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್? ದೇವರ್ ಡಿಸ್ಕಸಿಂಗ್ ಅಂತ ಅಷ್ಟೇ ಬಿಟ್ರೆ their intention was to do away with the life ಅಂತ. ಅದಕ್ಕೆ I made you to read the evidence of PW1 and 2. Once again you are arguing for 307.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಲ್ಲ P1 ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಅಂತ ಹೇಳಿಲ್ಲ.
Next submission at 2.
Please do.
Final hearing matter 16. Prasanna Kumar P.
ಯಾರು? ಪ್ರಸನ್ನ ಕುಮಾರ್ ಪಿ.
Case of Lord's divergent findings.
So
I'm preparing the synopsis in this matter, Lords. Voluminous ಇದೆ. If your Lordships could have it, Lords, on Monday or Lords Wednesday.
ಮನೇನ ಕೇಳಿದ್ರಲ್ರಿ ನೀವೇ?
Correct, Lords.
ಪೇಪರ್ ಬುಕ್ ವಾಲ್ಯೂಮಿನಸ್ ಇದೆ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, correct, Lords. I've gone through the paper book synopsis. Lords, short question.
We read the papers and came with ready 120 ಎಲ್ಲದಕ್ಕೂ ಫೈನ್ 2000, punishment only 6 months, 1 year, 6 months, 1 year maximum punishment ಇರೋದು. ಹೌದಾ?
Please. Lords, my only request is, Lords,
3 months, 1 year maximum.
Lords, ಏನಂದ್ರೆ
Customs Act
divergent findings. Lords, the only aspect on which, Lords, they've been acquitted is, Lords, procedural lapse. The learned magistrate, Lords, would opine that, Lords, there is no lapse on the part of, Lords, the investigating officer. In fact, Lords, their own test report would say it is, Lords, in fact, the restricted item that was tried to be exported. ಅದರಲ್ಲಿ ಕೆಲವೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮಾತ್ರ ರಿಲೆವೆಂಟ್ ಇದೆ. I'll just, Lords, make a short synopsis because, Lords, all these documents may not be, Lords, required. At the most, Lords, 4 witnesses and, Lords, some 10 to 12, Lords, exhibits are required. I'll just make a short synopsis, Lords. If your Lordships could have it, Lords, on Monday or, Lords, Wednesday. And, Lords, assist.
So appellant counsel seeks time once again on the ground that he is going to prepare the synopsis and point out the relevant exhibits to be relied upon since voluminous documents are available to consider the same, and hence list this matter on next week. Other on date kodi madam. 22.
Please.
70. Amshit Hegde.
ಇಲ್ಲೇನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಸೆಕೆಂಡ್ ಸೆಟ್ ಆಫ್ ಅಪೀಲ್ ಪೇಪರ್ಸ್. ವಂಶಿ ಯಾರು ಇವ್ರು ಬರ್ತಾನೆ ಇಲ್ಲ ಮೇಡಮ್? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಏನೋ ಬರ್ದಿದೀವಿ ನೋಡಿ. ಅಂಶಿತ್ ಹೆಗಡೆ
ಕನ್ವಿಕ್ಷನ್ ಅಪೀಲ್ಸ್.
ಕನ್ವಿಕ್ಷನ್
ಬರಲ್ಲ ಅಂದ್ರೆ ನಾವು ಬೇಕಾದ್ರೆ DLS ಇಲ್ಲ ಅಮಿಕಸ್ ಕುರಿ
ಯಾರು ಅಮಿಕಸ್ ಕುರಿ ಮಾಡೋಣ ಮಧ್ಯಾಹ್ನ. ಯಾರು ನೆನ್ನೆ ಯಾರೋ ವಿನಾಯಕ್ ಅಂತ ಯಾರೋ ಬಂದಿದ್ರು ಹೇಳ್ಕೊಂಡು. ಮತ್ತಿನ್ಯಾರು ಮತ್ತಾರು ಯಾರು ಇದ್ದಾರೆ? ಎಷ್ಟು ಜನಕ್ಕೆ ಮಾಡಿದೀವಿ ಈಗ? ನೋಡಿ ಮಧ್ಯಾಹ್ನ ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ 2:30ಗೆ. ಯಾಕಂದ್ರೆ ದಟ್ ಈಸ್ ಕನ್ವಿಕ್ಷನ್ ಅಪೀಲು. ಇನ್ನೊಂದು ಸ್ಟೇಟ್ ಅಪೀಲು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಓನ್ಲಿ 498A 2 years with 10,000 ಕೊಟ್ಟವ್ರೆ. 307ಗೆ and 3 and 4 of DP Actಗೆ ಅಕ್ವಿಟಲ್ ಅಂತ ನಿಮ್ ಕೇಸ್. ಹೌದಾ? ಆಯ್ತು ಮಧ್ಯಾಹ್ನ. ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಅಟ್ 2:30.
ಡಬ್ಬ ಮಡಗಿದ್ದೀನಿ. ಆಯ್ತು ಫೈಲ್ ನಮ್ಸಮ್ಮ ಅಲ್ಲಿ ಕೊಟ್ವಲ್ಲ ನೆನ್ನೆ ಅಲ್ಲಿ ತಗೊಂಡು ಕೊಟ್ನಲ್ಲ ವಾಪಸ್ ಕೊಟ್ರ?
I am for the appellant in this matter. I am for the appellant in this case, my lord.
The appeal is allowed. The judgment of conviction dated 27th August 2018 and the order of sentence dated 31st August 2018 in SC number 137 of 14 on the file of 9th additional district and session judge Bengaluru Rural District, Bengaluru is hereby set aside. The appellant is acquitted of the charge for the offence pursuant to section 302 of IPC. He shall be set at liberty forthwith if his detention is not required in any other case. Order of the trial court with regard to disposal of the property is maintained. Communicate a copy of this order to the trial court along with its record and the concerned prison forthwith.
Oblige, my lord. Oblige.
This one, passed over matter, seal number 1.
ಚಾಮರಾಜಪೇಟೆಗೆ.
ಅದರಲ್ಲಿ ಚೆನ್ನಮ್ಮನ ಕೆರೆ ಪೊಲೀಸ್ ಠಾಣೆ ಎಂದು ನಮೂದು ಮಾಡುವ ಬದಲು ಚಾಮರಾಜಪೇಟೆ ಪೊಲೀಸ್ ಠಾಣೆ ಎಂದು ನಮೂದಾಗಿರುತ್ತದೆ. ಅದಕ್ಕಾಗಿ ಸರ್ವಿಸ್
ಯಾರು ಕಳ್ಸಿರೋದು ಯಾರು?
ಅವರಿಗೆ in respect of R1 ಇದೆ ಇದರಲ್ಲಿ. In respect of R2 is
De facto complaint.
R2 is de facto complaint.
Yes.
ಅಲ್ಲ, ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ನಾಟ್ ರಿಸೀವ್ಡ್ ಅಂತ. ಆಯ್ತು ಮೇಡಮ್, R1 ನಲ್ಲಿ ಏನು?
ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಅಲ್ಲೂ ಹೋಗ್ಬಿಟ್ಟು ಓನರ್ ಕಡೆಯಿಂದ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ. stating that they were there as for rent for only 3 months.
And thereafter they vacated the premises.
They're not there in that residence. What is happening is they're supposed to go to another police station.
Other police station. Other police station ಹೋಗಬೇಕಾದ್ರೆ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದಾರ? New address is furnished?
ಎರಡು ಒಂದೇ ಅಡ್ರೆಸ್ ಇದೆ ಸರ್. ಎರಡು ಒಂದೇ ಅಡ್ರೆಸ್ ಇದೆ. MK ಮೋಹನ್ ಕೃಷ್ಣಪ್ಪ ನಾಯ್ಡ, resident of number 33 6th main road 6 cross ಲಕ್ಷ್ಮಣಪ್ಪ ಗಾರ್ಡನ್
BSK third stage.
ಇಲ್ಲಿ ಇದು ಅಷ್ಟೇ ಸರ್. ನಂಬರ್ 33 6th ಮನೆಯಪ್ಪ 6th ಕ್ರಾಸ್
ಇಬ್ಬರದನ್ನು ಒಂದೇ
ಸೇಮ್ ಒಂದೇ ಅಡ್ರೆಸ್.
ಇವರ ಕಳಿಸಿದ್ದಾರೆ
ಅಲ್ಲ ಇಲ್ಲ ಅಪೀಲ್ ಮೊದಲೇ ಸೇಮ್ ಅಡ್ರೆಸ್ ಇದೆ ಸರ್.
ಅಲ್ಲ, 1 and 2 ಗೆ ಒಂದೇ ಅಡ್ರೆಸ್. ನಂಬರ್ 33 ನೇ
ಸರ್. ಇವನು A1 ಅವನು A3 ಅಪೀಲ್ ನಂಬರ್ 1
ಅಪೀಲ್ ನಂಬರ್ 3 ನೇ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ. ಎರಡು ಅಡ್ರೆಸ್ ಸೇಮ್ ಇದೆ ಮೇಡಮ್.
ಗಂಡ ಹೆಂಡತಿ
ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್. ಹೌದು, BSK. ಹಾ,
ಅದಕ್ಕೆ ಹೋಗೋದು ಬದಲು ಚಾಮರಾಜಪೇಟೆ ಪೊಲೀಸ್ ಹೋಗಿರೋದ್ರಿಂದ ಸರ್ವ್ ಆಗಿಲ್ಲ.
ಸರಿ. ಕಳ್ಸಿದ್ದ ಯಾರು ಇಲ್ಲಿ ಚಾಮರಾಜಪೇಟೆಗೆ?
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕಳಿಸಿದ್ದಾರೆ.
ಯಾವ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ? ಎಲ್ಲಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಹೋಗಿದೆ? ನಮ್ಮವ್ರು ಕಳಿಸುವಾಗ ಎಲ್ಲಿಗೆ ಕಳಿಸಿದ್ರು?
ಇಲ್ಲಿ ಚಾಮರಾಜಪೇಟೆ ಪೊಲೀಸ್ ಅಂತ ಇದೆ. ಇಲ್ಲಿ ಚಾಮರಾಜಪೇಟೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಂತ ಇದೆ. ಸ್ಟೇಟ್ ಬೇಸ್ಡ್ ಚಾಮರಾಜಪೇಟೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್
ಕಂಪ್ಲೇಂಟ್
ಚಾಮರಾಜಪೇಟೆ
ಚಾಮರಾಜಪೇಟೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಇದೆಯಲ್ಲ. ಅಲ್ಲ ಮೇಡಮ್, ಅಪೀಲ್ ಹಾಕಿರೋರು ಯಾರು ಮೇಡಮ್? ಸ್ಟೇಟ್ ತಾನೆ. ಆ ಸ್ಟೇಟ್ ಪೊಲೀಸ್ ಕನ್ಸರ್ನ್ ಪೊಲೀಸ್ ಎಲ್ಲವ್ರೆ ಅಂತ ಶುರು ಮಾಡ್ಬೇಕು. ಅವ್ರಂಗೆ
This belongs to the concern. Come comes under Chennamma care.
ಅಡ್ರೆಸ್ ಯಾವ್ದಾದ್ರು ಬರ್ಲಿ ಮೇಡಮ್, ನಾವು ಕಳಿಸ್ಬೇಕಾಗಿರೋದು ನೀವು ಕಂಪ್ಲೇಂಟ್ ನೀವೇ ಶುರು ಮಾಡಬೇಕು ಸ್ಟೇಟ್. ಹೌದಲ್ವಾ? ಕರೆಕ್ಟ್ ಆಗಿ ಚಾಮರಾಜನಗರಕ್ಕೆ ಚಾಮರಾಜಪೇಟೆಗೆ ಹೋಗಿದೆ. ದಟ್ ಯು ಹ್ಯಾವ್ ಟು ಸರ್ವ್ ವೇರ್ ದಿ ಅಕ್ಯೂಸ್ಡ್ ಇಸ್ ರಿಸೈಡಿಂಗ್. ಆಯ್ತು, ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಯಾರು ಅಸರ್ಟೈನ್ ಮಾಡ್ಬೇಕು ಅವ್ನು ಎಲ್ಲಿದ್ದಾನೆ ಅಂತ? ಕೋರ್ಟ್ನವ್ರು ಮಾಡ್ಬೇಕಾ ನಿಮ್ ಪೊಲೀಸ್ ಮಾಡ್ಬೇಕಾ? ಮತ್ತೆ SVP seeks time to ascertain the correct address where the accused PSK ಅಲ್ಲೂ ಇಲ್ವಂತವ್ರು. ಅವ್ರು ಹಾಗಂತ ಬರ್ದಿಲ್ಲ. ನಿಮ್ ರಿಪೋರ್ಟ್ ಹಾಕಿರೋದು ಏನಂತಂದ್ರೆ ಚಾಮರಾಜಪೇಟ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕಳ್ಸಿದಿರಿ, ಚೆನ್ನಮ್ಮನ ಕೆರೆ ಕಳ್ಸಿಲ್ಲ, ಅದರಿಂದ ನಾವು ಜಾರಿ ಮಾಡಕ್ ಆಗಿಲ್ಲ ಅಂತ ರಿಪೋರ್ಟ್. ಹೌದಾ ಮೇಡಮ್? ಮತ್ತೆ ಓಕೆ ಅಂತ ಫೈಲ್ ಸಚ್ ರಿಪೋರ್ಟ್. ನಿಮಗೊಂದು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅವರು?
ಸರ್ ಇಲ್ಲ, ಅವ್ರು ಸರ್ ಬದಲು ನಾವು ಏನು ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಚಾಮರಾಜ್ ಅವ್ನು ರಿಪೋರ್ಟ್ ಕೊಡ್ತಾನೆ. ಯಾಕಂದ್ರೆ ಅವನು ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಕೇಸ್ ಇದೆ.
ಏನ್ ಮೇಡಮ್, ಹೌ ಕ್ಯಾನ್ ಯು ಗಿವ್ ಸಚ್ ರಿಪೋರ್ಟ್? ಅದಿದೆಯಾ ಮೇಡಮ್? ಹೋಗಿದ್ವಿ ಅಂತ BSK ಥರ್ಡ್ ಸ್ಟೇಜ್ ಹೋಗಿದ್ವಿ ಅಂತ ಫೋಟೋ ಕೊಡಿ ಮೇಡಮ್, ರಿಪೋರ್ಟ್ ಕೊಡಿ. ಗಣನಾಯಕದ ಅಂತಿಮ ತೀರ್ಪನ್ನೇ ಚೆನ್ನಮ್ಮನ ಕೆರೆ ಪೊಲೀಸ್ ಠಾಣೆ ಎಂದು ನಮೂದು ಮಾಡುವ ಬದಲು ಚಾಮರಾಜ್ ಅಂದ್ರೆ ಇವ್ರು ಹೇಳೋದು ಏನು ಅಂತಂದ್ರೆ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಮಾಡುವಾಗ್ಲೇನೆ, ಬಟ್ ಪೊಲೀಸ್ ಇವರೇ ಚಾಮರಾಜಪೇಟೆ. ಒಳಪಟ್ಟಿರುತ್ತದೆ. ಆರೋಪಿಯ ವಿಳಾಸವು ಚೆನ್ನಮ್ಮನ ಕೆರೆ ಅಚ್ಚುಕಟ್ಟು ಪೊಲೀಸ್ ಠಾಣೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ. ಸದರಿ ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ನೀಡಿ ವಿಚಾರಿಸಿದ ಬಗೆಗಿನ ಭಾವಚಿತ್ರಗಳನ್ನು ಮನೆ ಮಾಲೀಕರಾದ ಶ್ರೀ ಆನಂದ್ ಅಸಲು ಕೃತಿಯನ್ನು ಇದರೊಂದಿಗೆ ಲಗತ್ತಿಸಿರುವುದು. ಸಮನ್ ಮಾಡಿ ನಿಮ್ ಆಫೀಸರ್ ಗೊತ್ತಾಗ್ತದ ವೈ ಸೆಂಟರ್ ದಿಸ್ ರಿಪೋರ್ಟ್.
ಇಲ್ಲಾಂದ್ರೆ ನಿಮ್ಮ ಅಪೀಲ್ ಕಾಸ್ಟ್ ಡೇಟ್ ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ನಿಮ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಏನು? ಯಾರು ಪೊಲೀಸ್, ಯಾರು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದವರು? ಪೊಲೀಸು ಚೆನ್ನಮ್ಮನ ಕೆರೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಂತ ಇದೆಯಲ್ಲ,
ಒರಿಜಿನಲ್ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಒರಿಜಿನಲ್ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಚೆನ್ನಮ್ಮನ ಕೆರೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಂತ. ನೀವ್ ಯಾಕೆ ಚಾಮರಾಜಪೇಟೆ ಅಂತ ಹಾಕಿದ್ವಿ ಅಪೀಲ್ ಹಾಕುವಾಗ?
ಅವಸರದಲ್ಲಿ
ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ತಾನೆ. ನೀವು ನಿಮ್ದೇ ತಪ್ಪು. SVP ಆಫೀಸಲ್ಲಿ ತಾನೆ ಅಪೀಲ್ ಹಾಕಿರೋದು. ಸ್ಟೇಟ್ ಬೈ ಚಾಮರಾಜಪೇಟೆ ಅಂತ ಹಾಕಿದ್ರಿ. ಚಾಮರಾಜಪೇಟೆಗೂ ಚೆನ್ನಮ್ಮನ ಕೆರೆಗೂ ವ್ಯತ್ಯಾಸ ಇಲ್ವಾ? ಇದು ಚಾಮರಾಜಪೇಟೆ ಅಂತಲೇ ಇದೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಮೇಡಮ್ ಇದು. ಅಕ್ಯೂಸ್ಡ್ ಸ್ಟೇಟ್ ಬೈ ಕರ್ನಾಟಕ. ಇದು
ಸರ್ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ ಸರ್. The present case emanates from the first information
intervening
crime number 144 of
144 of Channamanakere police station
by the Channa
cast title ಹಾಕುವಾಗ ಇವರೇ ತಪ್ಪು ಮಾಡೋದು. ಇದು ಹೆಂಗ್ರಿ ಅಕ್ಯೂಸ್ ಹಾಕ್ತಾರೆ? ಸ್ಟೇಟ್ ಹಾಕ್ಬಿಡುವ. ಸ್ಟೇಟ್ ಫಸ್ಟ್ ಬರ್ಬೇಕು, ಅಕ್ಯೂಸ್ ಕೆಳಗೆ ಬರ್ಬೇಕು. ಆಕ್ಚುಲಿ ಕೇಸ್ ಯಾರ್ದು? ಚಾಮರಾಜಪೇಟೆದ ಅಥವಾ ಚೆನ್ನಮ್ಮನ ಕೆರೆದ? ಮತ್ತೆ ಇಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅವ್ರು ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ. ಸ್ಟೇಟ್ ಬೈ ಕರ್ನಾಟಕ ಚಾಮರಾಜಪೇಟೆ ಪೊಲೀಸ್ ಅಂತ. ನೀವು ಅದು ಕರೆಕ್ಷನ್ ಮಾಡಿಸ್ಕೋಬೇಕಿತ್ತಲ್ಲ ಅಪೀಲ್ ಹಾಕೋಕ್ಕಿಂತ ಮುಂಚೆ. ಅಂಡ್ ಆಲ್ಸೋ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ಮಿಸ್ಟೇಕ್ ಮೇಡಮ್. ಫಸ್ಟ್ ಸ್ಟೇಟ್ ಬರ್ಬೇಕು, ಆಮೇಲೆ ಅಕ್ಯೂಸ್ ಬರ್ಬೇಕು. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರೈಸ್ ಮಾಡಿಲ್ಲ ಆಫೀಸ್ನವರು ಅಂತ. ಅಲ್ಲ ಮೇಡಮ್, ಇಲ್ಲಿ ಹಾಕದಾಗ ನೋಡ್ಬೇಕಲ್ಲ, ನಮ್ಮವ್ರು ಸ್ಕ್ರೂಟಿನಿ ಮಾಡುವಾಗ. ಕಾಸ್ಟ್ ಟೈಟ್ಲು ಸರಿ ಇಲ್ಲ, ಸರಿ ಮಾಡಿಸ್ಕೊ ಬನ್ನಿ ಬರಿಬೇಕಲ್ಲ ಇವರು. ಒಂದು ಸರ್ಕಾರದಲ್ಲ, ಯಾರು ಹೋಗಲ್ಲ ಗೊತ್ತಿಲ್ಲ.
ಇದು ಕಮಿಟಿಲಿ ಹೀಗೆ ಒಂದು ಡೆಲಿಬ್ರೇಷನ್ ಆಯ್ತು ಸರ್. ಲಾಸ್ಟ್ ಬರೆಯಲ್ಲ, ಡೇಟ್ ಆಫ್ ರಿಮಾಂಡು, ಆಮೇಲೆ ಕನ್ವಿಕ್ಷನ್ ಡೇಟ್ ಬರೆಯಲ್ಲ ಅಂತ ಹೇಳಿ. ಈಗ ಅದೇ ಸರ್ ಫೋಟೋ ಡೇಟ್ ಸೇರ್ಸ್ ಬೇರೆನೆ. ಬೇರೆನೆ ಆಯ್ತು.
ಏನ್ ಮಾಡ್ತೀರಿ ನೋಡಿ ಮೇಡಮ್, ಯು ಶುಡ್ ಗೆಟ್ ಇಟ್ ರೆಕ್ಟಿಫೈ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ and also your appeal. Third, additional SPP 6 time to clarify regarding the appeal by the concerned police. In order to serve the notice against the accused number 102, accused appeal respond number 102. This matter on yaವಾಗ ಮಾಡ್ತೀರಿ ನೋಡಿ? 2 weeks, 29/1. Next.
15.
Madam?
15.
15, ಅದೇ ಆವಾಗ argument. ಏನಾಯ್ತು ಮೇಡಮ್?
Unfortunately, I was unable to contact the victim during the break, Your Lordship.
ಆಯ್ತು, ಯಾವಾಗ ಹೇಳ್ತೀರಿ?
Your Lordship,
Monday or Tuesday? Tuesday ಹೊತ್ತಿಗೆ ಚೆಕ್ ಮಾಡಿ ಹೇಳಿ. Heard the matter and counsel appearing for the appellant seeks time to make further submission with regard to the sentence is concerned. This matter on next madam,
21.
Monday or Tuesday?
Tuesday 21. 17. SPP Amshit Hegde.
ಬರೀ ಬರ್ತಾನೆ ಇಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಇಲ್ಲ.
We can appoint a nominee.
The counsel who filed the appeal on behalf of appellant number 1 to 5 was absent in the previous occasion when the matter was called twice, and also not complied with the office objections regarding second set. Even this court has directed to furnish the second set of appeal papers within 1 week. In spite of it, the same is not furnished, and also made it clear that if counsel doesn't appear on the next date of hearing, appeal will be dismissed for non-production of second set of appeal papers. But on perusal of the paper, this appeal is filed by the convicted accused persons, and the same cannot be dismissed, and hence we felt that amicus curiae could be appointed in the case versus the court, and hence counsel yaar madam amicus curiae yaar haagtira? Vinayaka BS alla, and hence Vinayaka BS is appointed as amicus curiae to assist the court. The registry is directed to furnish all the papers to the amicus curiae and list this matter on. ಅದರಲ್ಲೂ ಅಲ್ಲೂ R1 to 5 amicus curiae is appointed in both the appeals, criminal appeal number 13 of 2018 for R1 to 5, and also for appellant number 1 to 5 in criminal appeal number 1721 of 2017, and hence the registry is directed to furnish the papers in both the appeals to the amicus curiae. This matter on 30th, 31.
18. SPP Chandrasekhar L. Kiran Kumar.
Acquittal
ಇಲ್ಲ, acquittal.
498 ಗೆ 2 years 5,000 ಹಾಕಿದ್ದಾರೆ. 307 ಗೆ acquittal ಇದೆ. 326 ಗೆ 3 years with 30,000. ನಿಮ್ದೇನು 307 ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನಿಮ್ಮ ಅಪೀಲ್ ಹೌದಲ್ಲ? ಎಗನೆಸ್ಟ್ ದಿ acquittal 307 ಗೆ ಆಯ್ತು. ನಿಮ್ದು ಕನ್ವಿಕ್ಷನ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ erroneous.
ಹೌದು.
ಹೇಳಿ.
ಈಗ ಆಲ್ಮೋಸ್ಟ್ 1.5 years ಒಳಗಿದ್ದಾರೆ.
ಇನ್ನು ಅವರು
ಇಲ್ಲ, he is now on bail. Before getting the bail, he was
earlier 1.5 years.
he was almost 1.5 years he was in prison.
Almost ಅಲ್ಲ, ಎಷ್ಟು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು.
1 year.
7 ಏನಿದೆ ಮೇಡಮ್ ಇಂಟೆನ್ಷನ್ ಗೆ?
PW5 is the victim, sir, evidence ಅಲ್ಲಿ. Blade ಇಂದ ಹೊಡೆದು ಆಮೇಲೆ
Blade ಇಂದ?
Blade ಇಂದ ಹೊಡೆದು attack ಮಾಡ್ತಾರೆ.
ಹಾ.
And the lady tries to escape and she goes out of the house, much more capable.
ಹಾ? ಕತ್ತಿಗೆ ಹೊಡಿತಾರ? ಹಾ. ಬ್ಲೇಡ್?
Blade ಇಂದ ಕಣ್ಣ ಹತ್ರ ಎಲ್ಲ injury ಮಾಡಿದ್ದಾರೆ.
ಕಣ್ಣ ಹತ್ರ?
There are 7 injuries,
ಹಾ.
of which the 7 injuries which has affected the eye.
ಹಾ.
With regard to that, there is no certificate, but apart from no certificate, there is no other material. No other documents that is there. Case history ಏನು ಇಲ್ಲ. What period she has undergone for treatment and the injury. The doctor's opinion with regard to that is very clear. She's undergone 7.
But how long she was in the hospital? ಏನು ಇಲ್ಲ. ಕೇಸ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ, ಬಟ್ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಹೇಳ್ತಾರ ವಿಟ್ನೆಸ್.
Doctor ಬರೀ with regard to the injury, regarding the treatment.
ಎಷ್ಟು ದಿವಸ ಇದ್ರು ಅಂತ ಏನಾರು ಹೇಳ್ತಾರ? ಇಲ್ಲ. ಆಯ್ತು, ಈ ಮಚ್ಚ ಏನೋ ಚಾಪರ್ ತಗೊಂಡು ಹೊಡೆದ್ರು ಅಂದ್ರಲ್ಲ, ಅದನ್ನ ಕುತ್ತಿಗೆಗೆ ಅಂತ ಆ ಇಂಜುರಿ ಆಗಿದೆಯಾ? ಏನ್ ಇಂಜುರಿ?
ಎಲ್ಲ ಕುತ್ತಿಗೆಗೆ ಇಂಜುರಿ ಆಗಿಲ್ಲ, ಇಲ್ಲಿಗೆ ಬೀಳುತ್ತೆ ಬೆನ್ಗೆ.
ಶೋಲ್ಡರ್
ಕುತ್ತಿಗೆಗೆ ಹೊಡಿಯಕ್ ಹೋಗ್ತಾ ಇದ್ರು ಅಂತ ಕೇಸ್.
ಅವ್ರ ಕೇಸ್ ಶೋಲ್ಡರ್ ಏನಾಗಿದೆ? ಕಟ್ ಇಂಜುರಿನಾ?
ಸಿಂಪಲ್ ಇಂಜುರಿ.
Cut lacerated wound over left mandible region, cut lacerated wound over left maxillary area.
Maxillary ಮುಖದ ಹೋಗಿದ್ದೀವಿ.
Cut lacerated wound over right cheek, lateral angle and the right.
ಎಲ್ಲ ಕಟ್ ಇಂಜುರಿ
over anterior neck left, anterior left neck.
ಆಯ್ತು, ಎವಿಡೆನ್ಸ್ ಏನಿದೆ? With an intention to do away the life, these injuries are inflicted ಅಂತ ಹೇಳಿದಾರ?
ಇಲ್ಲ ಸರ್.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಆತರ ಏನಿಲ್ಲ. 307 ಹೆಂಗ್ ಅಟ್ರಾಕ್ಟ್ ಆಗ್ತದೆ? ಸರಿ ಮೇಡಮ್, ನೈಫ್ ತಗೊಂಡ್ ಬಂದಿದ್ದಾರೆ, ಮಚ್ಚು ತಗೋ ಬಂದಿದ್ದಾರೆ. ಇಂಟೆನ್ಷನ್ ಅನ್ನು ಯಾರು ಹೇಳ್ಬೇಕು? Who has to depose that with that intention only he came and inflicted injury ಅಂತ ನಮ್ಗೆ ಯಾರು ಹೇಳ್ಬೇಕು? Whether the court can presume this intention? Mens rea inside the mind. ಹೌದಾ? Who has to speak? ಅದಕ್ಕೆ 326 ಇನ್ವೋಕ್ ಮಾಡಿದ್ದಾರೆ. ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ, ಹೇಳ್ಬೇಕಿತ್ತಲ್ಲ. PW1 ಎವಿಡೆನ್ಸ್ ನೋಡಿ. ಯಾರು ಇಂಜೂರ್ಡ್? ಯಾರು?
ಮಂಜುಳಾ.
ಮೀನ್ ಅದೇನೆ 307 ಇನ್ವೋಕ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಇಂಟೆನ್ಷನ್ ಬಗ್ಗೆ ಎವಿಡೆನ್ಸ್ ಕೊಡ್ಬೇಕು. ಎಲ್ಲಿದೆ?
ಬೈದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. ಪ್ಯಾರಾ 2 ಅಲ್ಲಿ
ನನ್ನ ಮಕ್ಕಳು ಕಾಲೇಜಿಗೆ ಹೋಗಿದ್ರು, ನಾನೊಬ್ಳೆ ಮನೆಯಲ್ಲಿ ಇದ್ದೇನೆ. ಆಗ ಆರೋಪಿ ತಕ್ಷಣ ಮನೆಯ ಒಳಕ್ಕೆ ಬಂದಿದ್ದು. ಆತನ ಕೈಯಲ್ಲಿ ಒಂದು ರೇಜರ್ ಬ್ಲೇಡ್ ಮತ್ತು ಒಂದು ಮಚ್ಚು ಇತ್ತು. ಆತನನ್ನು ಉದ್ದೇಶಿಸಿ ಯಾವನ ಜೊತೆ ನೋಡ್ಕೊಂಡಿದ್ದೆ ಎಂದು ಅವಾಚ್ಯದಿಂದ ಬೈದ ತಕ್ಷಣವೇ ರೇಜರ್ ಬ್ಲೇಡ್ ಇಂದ ನನ್ನ ಎಡಕಿವಿ ಕೆಳಭಾಗದಲ್ಲಿ ಇವ್ರಿಬ್ರಿಗೂ ಏನು
ಗಂಡ ಹೆಂಡತಿ ಮೆಟ್ರೋಮೋಲಿಯನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲ, ಅವನು ಸಸ್ಪೆಕ್ಟ್ ಇರುತ್ತೆ ಗಂಡನ್ಗೆ.
ಗಾಯದ
ನಾಟ್ ಲಿವಿಂಗ್ ಆಲ್ಸೋ 2 ವರ್ಷದಿಂದ ಬೇರೆ
ಓಡಿ ಹೋಗುವ ಪ್ರಯತ್ನ ಮಾಡಿದ್ರೆ ನಾನು ಮುಂದಿನ ಬಾಗಿಲು ಹತ್ತಿರ ಓಡಿ ಹೋಗುತ್ತಿದ್ದಾಗ ಆರೋಪಿ ತನ್ನ ತಲೆ ಜುಟ್ಟನ್ನು ಹಿಡಿದುಕೊಂಡು ಕಣ್ಣಿನ ಮೇಲ್ಭಾಗಕ್ಕೆ, ಕುತ್ತಿಗೆಗೆ ಹಾಗೂ ಗಲ್ಲಕ್ಕೆ, ಕೈಗೆ ರೇಜರ್ ಬ್ಲೇಡ್ ಇಂದ ಎಳೆದಿದ್ದು ಎಲ್ಲ ಗಾಯಗಳಿಂದ ರಕ್ತ ಬರುತ್ತಿತ್ತು ಎಂದು ಸಾಕ್ಷಿದಾರರು ಗಾಯದ ಗುರುತುಗಳನ್ನು ತೋರಿಸುತ್ತಾರೆ. ಸಾಕ್ಷಿಯ ಮೈ ಮೇಲೆ ಗಾಯದ ಗುರುತುಗಳು ಕಾಣಿಸುತ್ತಿವೆ. ನಂತರ ಮಚ್ಚಿನಿಂದ ನನ್ನ ಕುತ್ತಿಗೆಯ ಮೇಲ್ಭಾಗಕ್ಕೆ ಹಾಗೂ ತಲೆಯ ಹಿಂಭಾಗಕ್ಕೆ ಹಾಗೂ ಭುಜಕ್ಕೆ ಹೊಡೆದಿರುತ್ತಾನೆ. ತಕ್ಷಣ ನಮ್ಮ ಅಕ್ಕಪಕ್ಕದ ಮನೆಯವರಾದ ಸೋನ್ಸೋ ಆಟೋದಲ್ಲಿ ಕಳಿಸಿದರು, ಬರೆಯುವ ಸರ್ಕಾರಿ ಕಳಿಸಿದರು. ಇದೇ ಎವಿಡೆನ್ಸ್ ಹೌದಲ್ಲ?
ಅಷ್ಟೇ.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನಾರು ಇದೆಯಾ? ಹೋಗ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P1 ನಲ್ಲಿ
ಅದು ಅವ್ರ ಅಣ್ಣ ಕೊಟ್ಟರು.
ಅಣ್ಣ ಕೊಟ್ಟರು. ಫೋಟೋಸ್ ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್ ಇದ್ರಲ್ಲಿ? ಕಣ್ಣೆ ಹೋಗಿದೆಯಲ್ರಿ? ಕಣ್ಣೆ ಹೋಗಿದೆಯಲ್ಲ ಅಂದೆ.
ಕಣ್ಣು ಒಂದ್ ಸ್ವಲ್ಪ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ ಸರ್.
ಈ ಘಟನೆಯ ಸಮಯದಲ್ಲಿ ಆರೋಪಿ ನನ್ನ ಬಲಗಣ್ಣಿಗೆ ಮಚ್ಚಿನಿಂದ ಹೊಡೆದಿದ್ದು, ಇದರಿಂದ ನನ್ನ ಬಲಗಣ್ಣು ಪೂರ್ತಿ ಕಾಣಿಸುತ್ತಿಲ್ಲ. ಸಾಕ್ಷಿಯು ಸದರಿ ಬಲಗಣ್ಣನ್ನು ತೋರಿಸಿ ಹೇಳಿದ್ದು, ಕಣ್ಣಿನಲ್ಲಿ ಕಪ್ಪು ಗುಡ್ಡೆ ಪೂರ್ಣ ಬಿಳಿಚಿಕೊಂಡು ಎಡಗಣ್ಣಿನ ರೀತಿ ಇಲ್ಲ. ದಿಸ್ ಇಸ್ ನೋಟಿಸ್ ಬೈ ದಿ ಕೋರ್ಟ್. ನೀವೇನೋ 1.5 ವರ್ಷ ಇದ್ದ ಅಂತ ಏನೋ ಹೇಳ್ತೀರಲ್ಲ.
ಅಲ್ಲ, ಇಟ್ಸ್ ಮೆಟ್ರೋಮೋನಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್.
ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗ್ಲಿ ರೀ, ಏನೇ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗ್ಲಿ, ಈವನ್ ಇಫ್ ಸಿ ಇಸ್ ನಾಟ್ ಮೇಂಟೈನಿಂಗ್ ಹರ್ ಚಾಸ್ಟಿಟಿ ಇದ್ಲೆ ಅನ್ಕೊಳ್ಳಿ, ಹೌ ಕ್ಯಾನ್ ಯು ಟೇಕ್ ದಿ ಲೈಫ್ ಆಫ್ ಎ ವೈಫ್?
ಅಲ್ಲ, the intention was never.
ಇಲ್ಲ ಅಂದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಡೈವರ್ಸ್ ಹೋಗ್ಬೇಕು, ಇಲ್ಲ ಬಿಟ್ಟು ಕಳಿಸ್ಬೇಕು, ಏನೋ ಒಂದು ಮಾಡ್ಬೇಕು ಅಲ್ವಾ? ಹೌ ಕ್ಯಾನ್ ಯು ಟೇಕ್ ದಿ ಲೈಫ್ ಆಫ್ ಎ ವೈಫ್?
ತಾವು ಹೇಳ್ದಂಗೆ intention of ಏನು taking the life was not there. That is.
ಆಯ್ತು, 326 ಒಂದ್ ಕಣ್ಣು ಹೋದಾಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ನಾವು
ಲೈಫ್ ಇದೆ 326ಗೆ, ಹೌದಾ ಇಲ್ಲ?
ಹೌದು.
ಮತ್ತೆ ಮಿನಿಮಮ್ ಸೆಂಟೆನ್ಸ್ 1 year ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಲೈಫ್ ಆಲ್ಸೋ 10 years
ಅಪ್ ಟು ಲೈಫ್.
ಮತ್ತೆ ಪಾಪ ಅವ್ಳು ಹೆಂಗೆ ಒಂದ್ ಕಣ್ಣಿಲ್ದಾರ ಲೈಫ್ ಹೆಂಗ್ ಲೀಡ್ ಮಾಡ್ಬೇಕ್ರಿ?
ಆಮೇಲೆ ಸರ್ ಲೇಡೀಸ್ ಟೈಲರ್ ಕೆಲಸ ಮಾಡ್ತಾಳೆ.
ಪಾಪ ಅವಳೇನೋ ಟೈಲರ್ ಕೆಲಸನ ಮಾಡ್ತಾಳೆ ಅಂತ ಕಾಣುತ್ತೆ.
ಅಲ್ಲ, ಇಬ್ರು ಟೈಲರ್ ಕೆಲಸನೇ ಮಾಡ್ತಾರೆ. ಹಸ್ಬೆಂಡ್ ವಾಸ್ ಡೂಯಿಂಗ್ ದಿಸ್. ಇನ್ಫ್ಯಾಕ್ಟ್ ಅವರೇ ಹೇಳ್ಕೊಟ್ಟಿದ್ದು ಕೂಡ.
ರಿಕವರಿ
ಫೋಟೋ ಇಲ್ಲ ಸರ್, ಸಿಡಿ ಇದೆ.
ಅವಳು ಫೋಟೋ ಹಾಕ್ಲಿಲ್ಲ ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ, ಕಣ್ಣಿಂದು ಕೋರ್ಟ್ ನೋಟಿಸ್ ಮಾಡಿದ್ದಾರೆ.
ಫೋಟೋ ಹಾಕಿ, ಫೋಟೋ ಹಾಕಿಲ್ಲ.
ರಿಕವರಿ ನೈಫ್ ಮಚ್ಚು,
ಎರಡು
ಚಾಪರ್ ಆಲ್ಸೋ ಫ್ರಮ್ ದಿ ಅಕ್ಯೂಸ್ಡ್. ಅಥವಾ ಬರೀ ಓನ್ಲಿ 307 ವಾಸ್ ನಾಟ್ ಅಟ್ರಾಕ್ಟ್? 307 ಮೇಲೆ ಸೆಂಟೆನ್ಸ್ ಬಗ್ಗೆ
ಏನ್ ಹೇಳಿ?
ಗ್ರಾಂಟ್ ಲೀವ್ ಒಂದು ಅಪೀಲ್ ಸೋನ್ಸೋ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮಾಡಿಫೈ ಇದೆ ಹೇಳ್ರಿ. Statement and sentence and passed by government and significant acquitting him for the offense punishment of section 307. Sentence ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ. Sentence accused for the section 307 ಎಲ್ಲ 307ಗೆ ಇದೆ.
ಶ್ರೀದೇವಿ ಪಿಟಿಜೆ ನವನಗರ.
ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಏನಾದ್ರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಹೇಳ್ಸಿದ್ದೀರಾ? ಕಣ್ಣಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಡಾಕ್ಟರ್ ಯಾರು ಇದರಲ್ಲಿ?
ಡಾಕ್ಟರ್ PW1 11
ಪತ್ರ, ಪ್ರಾಸ ವೈದ್ಯರ ಅಭಿಪ್ರಾಯ ವರದಿ, ನಿಶಾನೆ P11. ಕಣ್ಣನ್ನು ಕಾಣಕ್ಕೆ
ಹೇಳ್ತಾರೆ ಸರ್.
ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ?
ಪೇಜ್ 109 ಇದೆ ಸರ್.
109
ತರತ್ರಿ.
ಕಣ್ಣ ಹೋಗ್ಬಿಟ್ಟಿದೆಯಲ್ರಿ. ಗಾಯಾಳುವಿನ ಬಲಗಣ್ಣಿನ ದೃಷ್ಟಿ ಹೋಗಿರುತ್ತದೆಂದು ಇದ್ದು ಅದೇ ಪ್ರಕರಣ ನಾನು ದಾಖಲಿಸುತ್ತೇನೆ. ದಾಖಲೆ ಮತ್ತು ಅಭಿಪ್ರಾಯದ ಆಧಾರದ ಮೇಲೆ ಗಾಯದ ಪ್ರಮಾಣವನ್ನು ನಮೂದು ಮಾಡಿ 7ನೇ ಗಾಯವು ಅದರ ಬಲಗಣ್ಣಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು. ನನ್ನ ಅಭಿಪ್ರಾಯದ ಪ್ರಕಾರ ಮೇಲೆ ನಮೂದಿಸಿರುವ 1ರಿಂದ 6ನೇ ಗಾಯಗಳು ಸಾಮಾನ್ಯ ಸೂಕ್ತವಾಗಿದೆ. 7ನೇ ಗಾಯ ತೀವ್ರ ಸ್ವರೂಪದ್ದಾಗಿರುತ್ತದೆ. ಸಂಬಂಧಪಟ್ಟ ಗಾಯಗಳು ರೇಜರ್ ಬ್ಲೇಡ್ ಮತ್ತು ಮಚ್ಚಿನಿಂದ ಹಲ್ಲೆ ಮಾಡಿದರೆ ಉಂಟಾಗುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ ಎಂದು ಎಲ್ಲ ಕಟ್ ಲ್ಯಾಸರೇಟೆಡ್ ಉಂಡ್ರಿ. Hmm. Sentence ಕಡಿಮೆ ಆಯ್ತು ಅಂತ appeal ಹಾಕಿಲ್ಲ. 307 307 material ಇದೆ. Much injuries ಇದೆ. 307 ತರಬೇಕು ಅಷ್ಟೇ. ಐದು ವರ್ಷ ಮಾಡೋಕ್ಕೆ ನಾವು 307 ಬರ್ಬೇಕು. ಅವ್ರು 100% ಬಂದಿಲ್ಲ. Whether they are living together afterwards?
ಇಲ್ಲ
ಇಲ್ಲ.
ನಮ್ಮ ಮೊದ್ಲೇ ಇರ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ಮುಂಚೆನೆ 2 ವರ್ಷದಿಂದಾನೇ ಬೇರೆ ಇದ್ರು ಅವರು.
was living with her brother. Or rented money from Badi money to.
ಫುಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ನೋಡಿ ಎಲ್ಲ ಕಟ್ಲಾಸಿರೇಟೆಡ್
ನೋಡಿದೆ ಸರ್.
ಮುಖಕ್ಕೆಲ್ಲ ಮ್ಯಾಂಡಿಬಲ್ maxillary area right cheek cut lateral angle ಸಿಕ್ಕದಲ್ಲೆಲ್ಲ ಹೊಡೆದವನು ಅವನು. That itself shows that it is an intention to take away her life. Anterior neck left side 3 number ಕುತ್ತಿಗೆಗೂ ಏಟ್ ಬಿದ್ದಿದೆ ಅಲ್ರಿ. ಚೀಕು ನೆಕ್ palm ಯಾವಾಗ ಅಂತಂದ್ರೆ when she tried to ward off the injury, she has sustained injury to the palm also. Cut lacerated wound over right hand 4 centimeter in size, 2 in at palmar aspect. Cut lacerated wound over left hand over palm, ಎಡಗೈ ಬಲಗೈ ಎಲ್ಲ ತಪ್ಪಿಸ್ಕೊಂಡಿರೋದು ಅದು. These are the injuries clearly discloses that she tried to ward off the blows given by the accused. That itself invoke section 307. According to feedback from CCR, open globe injury type number 2 on June 2 grade 5 right eye. Even not spoken. Court has to take note of the manner in which he assaulted. If he has not stated. Medical evidence, injured evidence, that itself is enough. PW 11 evidence and injured is PW 5. ನನ್ನ ಮದುವೆಯಾಗಿ ಇಲ್ಲಿಗೆ ಸುಮಾರು 23 ವರ್ಷಗಳಾಯ್ತು. ನಾನು ಇಬ್ಬರು ಮಕ್ಕಳಿದ್ದಾರೆ. ಅವರುಗಳು ಸಂಸ್ಥೆ ನಾನು ಈಗ 3 ವರ್ಷದಿಂದ ನನ್ನ ತಮ್ಮ ಮಂಜುನಾಥನ ಮನೆಯಲ್ಲಿ ಹರಿಹರದ ವಿದ್ಯಾನಗರದಲ್ಲಿ ಪ್ರತ್ಯೇಕವಾಗಿ ಮಕ್ಕಳ ಜೊತೆ ವಾಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಆರೋಪಿ ಯಾವಾಗಲೂ ಅವರ ಜೊತೆ ನಾನಿದ್ದಾಗ ಅವಶ್ಯಕತೆಗಳನ್ನು ಬಯಸಿ ನೋಡುತ್ತಿದ್ದರು. ಈ ಘಟನೆ ಆದಾಗ ನಾನು ಹೊಲಿಗೆ ಕೆಲಸ ಮಾಡುತ್ತಿಲ್ಲ. ನನಗೆ ಹೊಲಿಗೆ ಕೆಲಸ ಮಾಡಲು ಆಗುತ್ತಿಲ್ಲ. ಕಣ್ಣು ಆದ್ಮೇಲೆ ಇನ್ನಂಗೆ ಹೊಲಿಗೆ ಕೆಲಸ ಮಾಡ್ತಾಳ್ರಿ. ನನ್ನ ಮಕ್ಕಳು ಕಾಲೇಜಿಗೆ ಹೋಗಿದ್ದರು. ನಾನು ಒಬ್ಬಳೇ ಮನೆಯಲ್ಲಿದ್ದನು. ಆಗ ಆರೋಪಿಯ ತಕ್ಷಣ ಮನೆಯ ಒಳಕ್ಕೆ ಬಂದಿದ್ದು ಆತನ ಕೈಯಲ್ಲಿ ಒಂದು ಬ್ಲೇಡು ಮುಚ್ಚು ಎಳೆದಿರುತ್ತಾನೆಂದು ಸಾಕ್ಷಿ ಸದರಿ ಭಾಗವನ್ನು ತೋರಿಸಿದ್ದು ಗಾಯದಸರು ಎಲ್ಲ ಇವನ್ ವಿಟ್ನೆಸ್. ಘಟನೆಯಾದ 15 ದಿನಗಳ ನಂತರ ನಾನು ಪೊಲೀಸರನ್ನು ಭೇಟಿ ಮಾಡಿ ನಾನು ಹೇಳಿಕೆ ನೀಡಿ ಸಂಶಯವಾಗಿ ನನ್ನ ಕಂಡ ಆರೋಪಿ ನನ್ನ ಗೋಡೆಗೆ ಹೋಗಿಸಿದ ಮುಚ್ಚು ಮತ್ತು ಬೇಜಾರನ್ನು ಗುರುತಿಸುತ್ತೇನೆ. Except eliciting that both are residing separately from last 2.5 years. With regard to the incident is concerned, nothing is elicited. ಮನೆ ಒಳಕ್ಕೆ ನುಗ್ಗಿ ಅವನ ಜೊತೆ ಹೋದಂಗಿತ್ತು ನೀನು ಅಂತ ಹೇಳಿ ರೇಜರ್ ಬ್ಲೇಡ್ ಇಂದ ನನ್ನ ಕಿವಿಯ ಪಕ್ಕದಿಂದ ಗೀರಿದನು. ಜುಟ್ಟನ್ನು ಹಿಡಿದುಕೊಂಡು ಕುತ್ತಿಗೆ ಮೇಲೆ ಕೈ ಮೇಲೆ ಅದೇ ಬ್ಲೇಡ್ ನಿಂದ ಹಲ್ಲೆ ಮಾಡಿರುತ್ತಾರೆ.
ಅಲ್ಲ ಈ ತರ ಇನ್ಸಿಡೆಂಟ್ಸ್ ಅಲ್ಲಿ ಜನರಲ್ ಆಗಿ ಅವ್ರನ್ನ ನೀನು ಸಾಯಿಸ್ಬಿಡ್ತೀನಿ ಅಂತೆಲ್ಲ ಹೇಳ್ತಾರೆ. ಹಿ ನೆವರ್ ಸೇಸ್ ದಟ್. Case of it.
Yes, but ಏನಿದೆ ಏನು ನಥಿಂಗ್. ಮೇಕಿಂಗ್ ಸಚ್ ಸಜೆಷನ್ ಟು ದಿ ವಿಟ್ನೆಸ್ ವಿತೌಟ್ ಮೆಟೀರಿಯಲ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್.
ನಮ್ಗೆ ಅದೇ ಡೌಟ್ ಇರ್ದಿತ್ತು. ದಟ್ ಈಸ್ ದಿ ಹೋಲ್ ಎಂಟೈರ್ ಮ್ಯಾರೈಟಲ್.
ಆಯ್ತ್ರಿ, ಡೌಟ್ ಇದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ ನೆಕ್ಸ್ಟ್? ವಾಟ್ ಈಸ್ ದ ಕೋರ್ಸ್ ಓಪನ್ ಟು ಹಿಮ್ ಟು ಟೇಕ್ ಅವೇ ಹಿಸ್ ಲೈಫ್?
ಅಲ್ಲ, ಹಿಸ್ ಇಂಟೆನ್ಷನ್ ವಾಸ್ ನೆವರ್ ಟು ಟೇಕ್ ಅಪ್ ದ ಲೈಫ್. ಅವ್ನು ಎಲ್ಲೂ ಹೇಳೋದು ಇಲ್ಲ ನಾನು ನಿನ್ನ ಸಾಯಿಸ್ಬಿಡ್ತೀನಿ ಅಂತ.
ಬ್ಲೇಡ್ ಇಂದ ರೇಸರ್ ಬ್ಲೇಡ್ ಇಂದ ಹೋಗಿ ಹೊಡಿತೀರಿ ಅಂದ್ರೆ ಇನ್ನೇನ್ರಿ? ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲಿ PW5 ಎವಿಡೆನ್ಸ್ ದಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ಎನಫ್. ಬೇರೆ ಎನಿ ಅದರ್ ವಿಟ್ನೆಸಸ್ ಮೇಡಮ್? ಐ ವಿಟ್ನೆಸಸ್ ಯಾರು ಇಲ್ವಲ್ಲ ಅವಾಗ?
ಅಲ್ಲ, ಅವರೇ
ಆಕೆನ ಹೇಳ್ತಾಳೆ ನಾನು ಆ ಸ್ವಲ್ಪ ಸುತ್ತಮುತ್ತ ಯಾರು ಇರ್ಲಿಲ್ಲ ಅವಾಗ ಅಂತ. ಹೊರಗಡೆ ಬಂದಾಗ ಅದ್ಯಾರು ನೋಡಿದಾರೆ? ಅದ್ಯಾರು ನೋಡಿರೋದು? ಮನೆಯಲ್ಲಿ ಯಾರು ಇರ್ಲಿಲ್ಲ ಅಂತ. Who is the witness? Four. ಏನ್ ಹೇಳ್ತಾರೆ ಅವರು?
He's hearsay ಬಿಟ್ಟಿದ್ದು.
ಮಕ್ಕಳಿದ್ದಾರೆ,
He's owner of rented house.
ನಮ್ಮ ಅಕ್ಕ ಜಗಳ ಮಾಡೋದಕ್ಕೆ ಬರ್ತಾ ಇದ್ದ, ಆಕೆ ಜೊತೆ ಜಗಳ ಮಾಡಿ
PW1 ಬಂದು ಹೇಳಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ನಾಗರಾಜಸ್ವಾಮಿ ಹೇಳಿದ್ರು ಅಂತ. PW6.
ನಾನು ಒಯ್ದಿರುತ್ತಾರೆ ಎಂದು ನನಗೆ ತಿಳಿಸಿ ತಕ್ಷಣ ಬರುವಂತೆ ಹೇಳಿದನು ನಾಗರಾಜಸ್ವಾಮಿ. PW6 ಏನಂತ? 6 and 8 ಏಟಾಗಿ ರಕ್ತ ಬರುತ್ತಿತ್ತು. ಏನೋ ಆರೋಪಿಯ ಮೇಲೆ ಹೇಳಿದ ಮಂಜುಳಾಗಿ ಮಚ್ಚಿನಿಂದ ಹೊಡೆಯುತ್ತಿದ್ದು, ಆಕೆ ಚೀರಿಕೊಂಡಿದ್ದು. ಆಕೆ ಚೀರಾಟ ಕೇಳಿ ನಾನು ಅಲ್ಲಿಗೆ ಹೋದಾಗ ಆಕೆಯು ಮನೆಯಿಂದ ಹೊರಕ್ಕೆ ಬಂದು ರಸ್ತೆಯ ಮೇಲೆ ಬಿದ್ದಳು. ರಕ್ತ ಏಟಾಗಿತ್ತು. ಮನೆಯ ಆರೋಪಿಯಲ್ಲಿ ಒಂದು ಮಚ್ಚು ಮತ್ತು ರೇಜರ್ ಬ್ಲೇಡ್ ಇತ್ತು. ಆಕೆ ಕಣ್ಣು, ಕುತ್ತಿಗೆ, ಮುಖ ಎಲ್ಲರ ಕಡೆ ಏಟಾಗಿ ರಕ್ತ ಬರುತ್ತಿತ್ತು. ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿದ್ದನ್ನು ನೋಡಿ ಆರೋಪಿ ಅಲ್ಲಿಂದ ಓಡಿ ಹೋದನು. ತಕ್ಷಣ ನಾನು ಸದರಿ ಮಂಜುಳನ್ನು ಯಾವುದೋ ಒಂದು ಆಟೋ ರಿಕ್ಷಾದಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿ ದಾಖಲು ಮಾಡಿದೆವು. ಈ ಓನ್ಲಿ ಕಾಟ್ ಅಡ್ಮಿಟೆಡ್ ಅವರು ಆಸ್ಪತ್ರೆಗೆ ದಾಖಲು ತಿಳಿಸಿದನು, ಹೇಳಿದನು, ಹೋಗಿ ಕೃತ್ಯವನ್ನು ತೋರಿಸಿದನು. ಅಲ್ಲಿ ರಕ್ತ ಬಿದ್ದಿದ್ದು ಕಲೆ ಇತ್ತು. ಪೊಲೀಸರು ಎಲ್ಲ ರಸ್ತೆಗೆ ಓಡಿ ಬಂದಿದ್ದು ಆರೋಪಿ ಆಕೆಗೆ ಮಚ್ಚಿನಿಂದ ಹೊಡೆಯುತ್ತಿದ್ದಾಗ ನಾನು ಬಂದು ಬಿಡಿಸಿದೆನು. ಆರೋಪಿ ತನ್ನ ಬಲಗೈನಲ್ಲಿ ಹಿಡಿದಿದ್ದ ಮಚ್ಚಿನಿಂದಲೇ ಹೊಡೆದಿರುತ್ತಾರೆ. ಘಟನೆಯ ಸಮಯದಲ್ಲಿ ಆರೋಪಿಯ ಕೈಯಲ್ಲಿ ಮಚ್ಚು ಇದ್ದು ಅದು ಯಾವ ಕೈಯಲ್ಲಿ ಇತ್ತೆಂದು ನನಗೆ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ನಾನು ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ಕಿರಿಸಿಕೊಂಡೆ. ಓಡಿ ಹೋದಾಗ ಆರೋಪಿ ನನ್ನನ್ನು ನೋಡಿ ಓಡಿ ಹೋದನು. ನಾನು ಕೂಗಿದ ತಕ್ಷಣ ಹಿಂದೆ ಆಟೋ ಸ್ಟ್ಯಾಂಡ್ ನಲ್ಲಿದ್ದ ಜನ ಸಹ ಬಂದಿರುತ್ತಾರೆ. ಅವ್ರು 2-3 ಜನ ಅಲ್ಲಿಗೆ ಬಂದಿರುತ್ತಾರೆ. ಅಲ್ಲಿ ಬಂದಿದ್ದವರ ಹೆಸರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆದರೆ ಆಟೋ ಬಂದವರ ಹೆಸರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಅಕ್ಕಪಕ್ಕದ ಮನೆಯವರು ಅಲ್ಲಿಗೆ ಬಂದಿದ್ದು ಅವರ ಹೆಸರು ಹೇಳಲು ನನಗೆ ಗೊತ್ತಿರುತ್ತದೆ. ಆರೋಪಿ ಅಲ್ಲಿಂದ ಓಡಿ ಹೋಗುವಾಗ ನಾವುಗಳು ಅದರ ಅಂತ ಹಿಡಿಯುವ ಪ್ರಯತ್ನ ಮಾಡಿಲ್ಲ. ನಾನು ಗಾಯಾಳು ಮಂಜುನಾಥನ ಆಟೋದಲ್ಲಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದೆನು. ಕರೆದುಕೊಂಡು ಹೋದಾಗ ಸುಮಾರು 11:30 ಗಂಟೆ ಆಗಿತ್ತು. ಈ ಗಂಟೆ ಬೆಳಗ್ಗೆ ಏನಾಯ್ತು? ಸಂಜೆನ?
ಬೆಳಿಗ್ಗೆ
ಮಾರ್ನಿಂಗ್. ಟೋಟಲ್ ದಿನೇ ಏನು PW 8
ಪ್ರಭಾವತಿ
ಗಲಾಟೆ ಆಗುತ್ತಿದ್ದು ಮಂಜುಳಾ ಚೀರುತ್ತ ಮನೆಯಿಂದ ಹೊರಗಡೆ ಬಂದಳು. ನಾವುಗಳು ಅಂದ್ರೆ ನಾನು, ನಮ್ಮ ಪಕ್ಕದ ಮನೆಯ ನಾಗರಾಜ ಸ್ವಾಮಿ ಯಾರು PW 6 ನಾಗರಾಜ ಸ್ವಾಮಿ ಮತ್ತೆ ಬಸವರಾಜು, ಲೀಲಮ್ಮ ಮನೆಯಿಂದ ಹೊರಗಡೆ ಬಂದೆವು. ಆಗ ಮಂಜುಳಮ್ಮನನ್ನು ನಾವು ನೋಡಿದಾಗ ಆಕೆಯ ಕಿವಿ ಬಳಿ ಕುತ್ತಿಗೆ ಹತ್ತಿರ ಬ್ಲೇಡ್ ನಿಂದ ಕೊಯ್ದಿದ್ದು ರಕ್ತ ಬರುತ್ತಿದ್ದು ಆಕೆ ನೆಲಕ್ಕೆ ಹಾಕಿ ಆರೋಪಿ ಮಚ್ಚಿನಿಂದ ಕುತ್ತಿಗೆಗೆ ಹೊಡೆಯುತ್ತಿದ್ದನು. ಕುತ್ತಿಗೆಯಲ್ಲಿ ರಾಗವಾದ ರಕ್ತ ಬರುತ್ತಿತ್ತು. ನಾಗರಸ್ವಾಮಿ ಸದರಿ ಮಂಜುಳಮ್ಮನ ಆಟೋದಲ್ಲಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದರು. ನಾನು ಆರೋಪಿ ಮಂಜುಳಮ್ಮನಿಗೆ ಹೊಡೆಯುವ ಬ್ಲೇಡ್ ಅನ್ನು ನೋಡಿ ಗುರುತಿಸುತ್ತೇನೆ. ರೇಜರ್ ಬ್ಲೇಡ್ ಅನ್ನು ನೋಡಿ ಗಮನಿಸುತ್ತ ಪಟ್ಟಿಸಬಾರದು. ಮಂಜುಳಮ್ಮನ ಮನೆಯ ನಂತರ ನಮ್ಮ ಮನೆ ಇದ್ದು, ನಮ್ಮ ಮನೆಯ ಪಕ್ಕದಲ್ಲೇ ನಾಗರಾಜ ಸ್ವಾಮಿರವರ ಮನೆ ಇದೆ. ಇಬ್ರು ನೈಬರ್ಸ್. ಜಗತ್ತಾಗಿ ಅಂದ್ರೆ ಅಂಟಿಕೊಂಡ್ರೆ ಬೇರೆ ವಾಸದ ಮನೆ ಇದೆ. ನಮ್ಮ ಮನೆಯ ರಸ್ತೆ ಜನಸಂದಣಿ ರಸ್ತೆ ಸರಿಯಿಲ್ಲ. ಮಂಜುಳಮ್ಮನ ಮನೆಯಿಂದ ಸ್ವಲ್ಪ ದೂರದ ಆಟೋ ನಿಲ್ದಾಣ ಇದೆ. ಮಂಜುಳಮ್ಮನ ಮನೆಯಿಂದ ಸುಮಾರು 1/2 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ ಹರಿಹರದ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆ ಇದೆ. ಮನೆಯ ಪಕ್ಕದಲ್ಲಿ ಆಟೋ ಚಾಲಕರು ಇರುತ್ತಾರೆ ಅನ್ನೋದು ಸರಿ ಇದೆ. ಏನಾದರೂ ಸ್ವಲ್ಪ ಗಲಾಟೆ ಆದರೆ ಸಾಮಾನ್ಯವಾಗಿ ಜನ ಸೇರ್ತಾರೆ, ಸರಿ ಇದೆ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದಾದರೆ ಹೆಚ್ಚು ಜನರು ಇರಲಿಲ್ಲ ಎಂದು ನೋಡಿಬಿಡುತ್ತಾರೆ. ಮಾತ್ರ ಮನೆಯಿಂದ ಹೊರಗಡೆ ಬಂದಿರುತ್ತೇವೆ. ಮಂಜುಳಮ್ಮ ನನಗೆ ಯಾವ ಜನರು ಹೋಗುತ್ತಾರೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ. ಬೇರೆ ಯಾರು ಬರುತ್ತಿದ್ದು ನೋಡುತ್ತಾರೆ. ಘಟನೆ ನಡೆದಿದ್ದು ಮೊದಲ ಬಾರಿಗೆ ನೋಡಿರುತ್ತೇನೆ. ಇದೇ ಮೊದಲ ಬಾರಿಗೆ ನೋಡುತ್ತಿದ್ದೇನೆ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ಇವ್ರಿಗೂ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ರು, ಯಾರೋ ಇಬ್ರು ಪುಟ್ಟಪ್ಪ ಶಿವು ಬರ್ತಾ ಇದ್ರು. ಅದೆಲ್ಲ ಸರಿಯಲ್ಲ ಅಂತ ಅವ್ರು ಡಿನೇ ಮಾಡಿದ್ರು. ಮಂಜುಳಮ್ಮನ ಜೊತೆ ಮಾತನಾಡಿರುತ್ತೇನೆ. ರಾತ್ರಿ 11 ಗಂಟೆವರೆಗೆ ಎಷ್ಟೋ ಬಾರಿ ನಾನು ಮತ್ತು ಮಂಜುಳಮ್ಮ ಮಾತನಾಡಿರುತ್ತೇವೆ. ಸರಿ, ಮಂಜುಳಮ್ಮ ಆಕೆ ಕಷ್ಟ ನನ್ನ ಬಳಿ ಹೇಳುತ್ತಾರೆ ಅಂದ್ರೆ ಸರಿ ಇದೆ. ಮೊಕದ್ದಮೆಗಳನ್ನು ಸಹ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಡೆಯುತ್ತಿರುವ ಕೇಸನ್ನು ಸಹ ಆಕೆ ಹೇಳಿದ್ದರು. ನಾನು ಯಾವ ರೀತಿ ಸಾಕ್ಷ್ಯ ನುಡಿಬೇಕು ಸಹ ಆಕೆ ನನಗೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ ಅನ್ನೋದು ಸರಿ ಇಲ್ಲ. ಬೇರೆ ನಿಮ್ಮ ಉದ್ದೇಶ ನೀವು ಏನನ್ನು ಕಂಡಿದ್ದೀರೋ ಅದನ್ನೇ ನೋಡಿದ್ದೇನೆ ಅಂತ ಹೇಳಿ ಎಂದು ಹೇಳಿದರು. ನಾನು ಚಿಕ್ಕ ಮನಸ್ಸಿ ಮಗಳನ್ನು ಕೂಡ ಏನೋ ಸಪೋರ್ಟ್ ಮಾಡೋರಲ್ಲ. PW 9
ಅವ್ರು ಏನು ಹೇಳ ಸಂಬಂಧ
ನಮ್ಮ ಅಮ್ಮ ಅಡುಗೆ ಮಾಡಿದ ಸಾರಿಗೆ ಸ್ವಲ್ಪ ಉಪ್ಪು ಕಡಿಮೆ ಆದರೂ ನಮ್ಮ ತಂದೆ ಅದರ ಆರೋಪಿ ನಮ್ಮ ತಾಯಿಗೆ ಮನೆಯಿಂದ ಹೊರಗಡೆ ರಾತ್ರಿ ವೇಳೆಯಲ್ಲಿ ನಿಲ್ಲಿಸುತ್ತಿದ್ದರು.
492 ಇದೆ. 498
ಮನೆಯಿಂದ ಹೊರಗಡೆ ನಿಲ್ಲಿಸ್ತಿದ್ದ ಅಂತ. ನಾನು ಮನೆ ಹತ್ರ ಹೋದಾಗ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಸೇರಿದ್ರು. ರಕ್ತ ಬಿದ್ದಿತ್ತು. ಅಲ್ಲಿ ಜನ ನಿಮ್ಮ ಅಪ್ಪ ಕೊಡಸಾಯಿಸುವ ಪ್ರಯತ್ನ ಮಾಡಿದ್ದು, ಆಕೆಯನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಸಿರುತ್ತೇವೆ ಎಂದು ತಿಳಿಸಿದರು. ನನ್ನ ತಾಯಿಗೆ ರಕ್ತ ಬಂದಿತ್ತು. ಕುತ್ತಿಗೆ ಬಳಿ, ಕಿವಿ ಹತ್ತಿರ, ಕಣ್ಣಿನ ಭಾಗದಲ್ಲಿ, 2 ಕೈಗಳಲ್ಲಿ ಎಲ್ಲ ಕೊಯ್ದ ಗಾಯಗಳಿತ್ತು. ರಕ್ತ ಬಂದಿತ್ತು. ನಾನು ನನ್ನ ಮಾಮ ಮಂಜುನಾಥನ್ನು ವಿಚಾರಿಸಿದೆ. ಆತ ನಿಮ್ಮ ಅಪ್ಪ ನಿಮ್ಮ ಅಮ್ಮನಿಗೆ ಕೊಲೆ ಮಾಡಲು ಈ ರೀತಿ ಹೊಡೆದಿದ್ದು, ಆಕೆ ಏನೋ ದೇವರ ದಯೆಯಿಂದ ಉಳಿದುಕೊಂಡಿದ್ದಾಳೆ ಎಂದು ತಿಳಿಸಿದರು. PW 7 to 9, 6, 8. ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್ ಏನಿದೆ? PW 6 evidence, PW 8 evidence, PW 9 evidence,
Yes, ma'am.
PW 11 evidence.
The injury is there.
Huh?
With regard to the income that they earn, page number 102 ದಲ್ಲಿ ನನ್ನ ತಾಯಿ ಬಟ್ಟೆ ಹೊಲಿಯುವ ಕೆಲಸವನ್ನು ಮಾಡುತ್ತಿರಲಿಲ್ಲ ಅನ್ನೋ
ಸರಿ ಅಲ್ಲ ಅಂತ ಡಿನೈ ಮಾಡಿದೆ.
ಬಟ್ಟೆ ಹೊಲಿಯುವ ಆ ದಿನಕ್ಕೆ ಮನೆ ತಾಯಿಗೆ ಆಗುತ್ತಿತ್ತು, ಬೇರೆ ಯಾವುದೇ ಆದಾಯ ಇರಲಿಲ್ಲ.
ಅವಳೇನೋ ಟೈಲರಿಂಗ್ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು 2 ಮಕ್ಳನ್ನ ಸಾಕೊಂಡು ಇದ್ದಾಳೆ, ನೀವು ಅಲ್ಲಿಗೂ ಹೋಗ್ಬಿಟ್ಟಿಲ್ಲ.
ಇಲ್ಲ ಫೀಸ್ ಎಲ್ಲ ನಾವೇ ಕಟ್ತಾ ಇದೀವಿ ಸ್ವಾಮಿ. Otherwise with 100 rupees earning, how can she pursue her BE education? They deny it, but the fact is that this person was paying the entire fee. Fees ಎಲ್ಲ ಇವನೇ ಕೊಡ್ತಾ ಇದ್ದ, ಇಲ್ಲ ಅಂದ್ರೆ BE ಎಲ್ಲಿ ಓದೋದು?
ದಾಖಲೆ ತೋರಿಸಿ, 2.5 ವರ್ಷದಿಂದ ಬೇರೆ ಇದ್ರಲ್ಲ, ಮಕ್ಳು ಫೀಸ್ ಕಟ್ಟಿದ್ಕೆ ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದೀರಾ ಎವಿಡೆನ್ಸ್? ಸ್ಟೋರಿ ಹೇಳ್ಬೇಡಿ, ಏನಾದ್ರು ಇದ್ರೆ ಕೊಡಿ, ವಿಲ್ ಬಿಲೀವ್ ಇಟ್. ಬಿಲ್ ಸ್ಕೂಲ್ ಫೀ ಕಟ್ಟಿದ್ಕೆ ಅದಕ್ಕೆ ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಏನಾದ್ರು ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಅಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ
ಇಲ್ಲದೆ
ಏನ್ ಮಾಡ್ತೀವಿ?
ನನ್ನ ತಂದೆ ನನ್ನ ಅಮ್ಮನ ಬಿಟ್ಟು ಹೋಗಿ ಸುಮಾರು 2 3 ವರ್ಷಗಳಾಗಿತ್ತು.
ಅದೇ 2.5 3 ವರ್ಷಗಳಾಗಿತ್ತು. ಘಟನೆ ಆದಕ್ಕೆ ಸುಮಾರು 2 ವರ್ಷಗಳ ಹಿಂದೆ ನನ್ನ ತಂದೆ ನನ್ನ ಅಮ್ಮನನ್ನು ಬಿಟ್ಟು ಹೋಗಿದ್ದರು. ನನ್ನ ತಂದೆ ಹೆಸರಿನಲ್ಲಿ ಒಂದು ಅಂಗಡಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ, ಅಲ್ಲೇ ಇರುತ್ತಿದ್ದರು. ನಾವು ಹೊಸಪೇಟೆಯಿಂದ ಹರಿಹರಕ್ಕೆ ಬಂದು ಸುಮಾರು 8 ವರ್ಷಗಳಾಗಿರುತ್ತದೆ. ಹೊಸಪೇಟೆಯಲ್ಲಿ ನಮ್ಮ ತಂದೆಯ ಅಣ್ಣ ಅಂದರೆ ದೊಡ್ಡಪ್ಪನಿಗೆ ಸೇರಿದ ಟೈಲರಿಂಗ್ ಅಂಗಡಿ ಇರುತ್ತದೆ. ಇದು ಅಮರ್ ಟೈಲರ್ಸ್ ಎನ್ನುವುದು ಸರಿ ಇದೆ. ಇದು ಹೊಸಪೇಟೆಯಲ್ಲಿ ಬಹಳ ಹೆಸರಾಂತ ಅಂಗಡಿ ಎನ್ನುವುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಹೆಸರನ್ನೇ ನನ್ನ ತಮ್ಮನಿಗೆ ಇಟ್ಟಿರುತ್ತಾರೆ ಎನ್ನುವುದು ಸರಿ ಇದೆ. ನನ್ನ ತಂದೆ ವೃತ್ತಿಯಲ್ಲಿ ಸರಿ ಅಲ್ಲ, ಟೈಲರ್, ಎಕ್ಸ್ಪರ್ಟ್ ಟೈಲರ್ ಅಂತ. ಎಕ್ಸಿಬಿಟ್ P1 ಯಾವ್ದು ಮೇಡಮ್? ಕಂಪ್ಲೇಂಟ್ ಎಕ್ಸಿಬಿಟ್ P1 is the ಮಾಜರ್. ಅಮರತ್ ಮಾಜರು, ಜಪ್ತು ಮಂಚನಾಮೆ, ಪೊಲೀಸ್ ನೋಟಿಸ್. P7 is the complaint. ಯಾರು ಕೊಟ್ಟಿದ್ದಿ ಕಂಪ್ಲೇಂಟ್?
ಬ್ರದರ್
ಅವನ್ ಬಂದು ಹೇಳ್ತಾನೆ. ಇದೆಯಲ್ಲ ಸಮಯದಲ್ಲಿ ನಿಮ್ಮ ಮಾವ ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ನಿಮ್ಮ ಅಕ್ಕನಿಗೆ ಸುಳ್ಳು ಆದರಗಿತ್ತಿ ಅಂತ ಅವಶ್ಯವಾಗಿ ಬೈಯುತ್ತಾ ಒಂದು ಬ್ಲೇಡ್ ಮತ್ತು ಮಚ್ಚಿನಿಂದ ಬಲವಾಗಿ ಹೊಡೆದು ವ್ಯಕ್ತಪಡಿಸಿರುತ್ತಾನೆ. ನಾನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿ ಲೀನಮ್ಮ ಹಾಗೂ ಅಲ್ಲಿದ್ದ ಪ್ರಭಾವತಿ, ಬಸವರಾಜ ಮತ್ತು ಇತರೆ ಅವರು ಸೇರಿ ಜಗಳ ಬಿಡಿಸಿದೆವು. ನಿಮ್ಮ ಮಾವ ಓಡಿ ಹೋಗಿರುತ್ತಾನೆ. ಇದು ಇನ್ಸಿಡೆಂಟ್ ಅಟ್ ವಾಟ್ ಟೈಮ್? 11 ಗಂಟೆ ಅಂತಿದೆ. 11 ಗಂಟೆ 12ವರೆಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವ್ರು ಅವತ್ತೇ. Within span of 1.5 hours, complaint was lodged. P7, P8 FIR. Exhibit P10. ಇದು ಕಾಂಪನ್ಸೇಷನ್ 1.5 ಲಕ್ಷ ಫಂಡ್ ಇದೆ.
50
15 ಏನಾಗುತ್ತೆ ಕೆಳಗೆ ಕೊಟ್ಟು 30 ಹಾಕ್ಬಿಟ್ಟು 326. ಹ್ಮ್ 307. Case for 307. Though it is missing in the evidence of PW1, but the other evidence including
ಇಲ್ಲ PW1 intention was never specific ಅವ್ರ ಅಣ್ಣ ಬರೀತಾರೆ.
3 injuries all over the body, neck, ಮುಖ ಎಲ್ಲ ಏಟ್ ಆಗಿದೆ.
ಸಾಯಿಸೋರು
both are living separately. ಮತ್ತೆ ಯಾಕೆ ಹೋಗ್ಬೇಕಿತ್ತು? ಸರಿ, if she is not having good chastity, they are living separately from last 2.5 years, 3 years. What made him to go and make an attack on her? ಮಕ್ಕಳಿಬ್ರು ಆಕೆ ಜೊತೆಲೇ ಇದ್ದಾರೆ.
ಹೌದು.
ಪಾಪ ಆಕೆ ಏನೋ ಟೈಲರಿಂಗ್ ಮಾಡ್ಕೊಂಡು ಆ ಮಕ್ಳನ್ನ ಸಾಕೊಂಡಿದ್ದಾಳೆ, ಇವನ್ ಯಾಕೆ ಅಲ್ಲಿ ಹೋಗಿ ಅಸಾಲ್ಟ್ ಮಾಡ್ಬೇಕಿತ್ತು? ಅವ್ನ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ನೋಡಿ ಅವ್ನು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿದಾನೆ.
ಅಲ್ಲ ಅಣ್ಣ ಹೇಳಿದಾನ, ಅಣ್ಣಂಗೆ
ಅಣ್ಣನ ಹೇಳಿದಾನೆ.
ಅಲ್ಲ ಅಣ್ಣಂಗೇನು
ಯಾರು
ಗೊತ್ತಿಲ್ಲ.
ಹೇಳಿದ್ರು ಅಂದ್ರೆ ಕೊಲೆ ಮಾಡ್ಬೇಕು ಅಂತ ನಿಮ್ಮ ಗಂಡ ಬಂದು ಹೊಡೆದ ಅಂತ, ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ನಿಮ್ಮ ಅಕ್ಕನಿಗೆ ಬೈದ ಅಂತ ಹೇಳಿ. ಅದು ಏನು ವಿತಿನ್ ಸ್ಪ್ಯಾನ್ ಆಫ್ 1.5 hours ಇನ್ಸಿಡೆಂಟ್ ವಾಸ್ ನರೇಟೆಡ್ ಬಿಫೋರ್ ದಿ ಪೊಲೀಸ್. ಇನ್ಸಿಡೆಂಟ್ ಅವತ್ತೇ ತಾನೆ?
ಹೌದು ಸರ್,
ಕಂಪ್ಲೇಂಟ್ ಅವತ್ತೇ,
ಅವತ್ತು ಅರೆಸ್ಟ್ ಅವತ್ತು.
6:26 ಬೆಳಗ್ಗೆ ನಾನು ನನ್ನ ಮನೆ ಹತ್ತಿರ ಇರುವಾಗ ಅರೆಸ್ಟ್ ಅವತ್ತೇನಾ?
ಹೌದು.
ಮತ್ತೆ ಎವ್ರಿಥಿಂಗ್. ಹೇಳಿ, ಕಣ್ ಬೇರೆ ಹೋಗಿದೆ, ಅವಳು ಹೆಂಗ್ ಜೀವನ ಮಾಡಂಗೂ ಇಲ್ಲ ಈಗ, ಪಾಪ ಮಕ್ಳನ್ನ ಹೆಂಗ್ ಸಾಕ್ಬೇಕು?
ಅಲ್ಲ ಸಾಯಿಸೋ ಉದ್ದೇಶ ಇದಿದ್ರೆ ಅಲ್ಲೆಲ್ಲ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ, ವೈಟಲ್ ಪಾರ್ಟ್ಸ್ ಏನೋ ಮಾಡ್ತಾ ಇಲ್ಲ.
ರೇಜರ್
ಬ್ಲೇಡ್
1, 2 and 3 were stained with O group blood. ಅದು ಕೂಡ ಇದೆ. 1, 2 and 3 ರೇಜರು, ಮಚ್ಚು, ನೈಟಿ ಮೂರಲ್ಲೂ ಇದೆ ಬ್ಲಡ್. ರಿಕವರಿ ವಿಟ್ನೆಸ್ ಯಾರು ಮೇಡಮ್? ಇದನ್ನ ಮಚ್ಚು ಏನೋ ರಿಕವರಿ ಮಾಡಿದಾರ ಅವನ ಕಡೆಯಿಂದ? ಫೋಟೋ ಇದೆ.
Yes, PW2.
ಫೋಟೋ ಒಂದು ಹಾಕಿದೆ.
PW2 ನ
2 and 7.
PW2 and 7 ಎಲ್ಲ ಇದೆ ಅಲ್ಲ. PW1 is the spot major witness. PW2 ಕಾಂಪೌಂಡ್ ನ ಒಳಗಡೆ ಒಂದು ಚಾಕು ಮತ್ತು ಮಚ್ಚನ್ನು ಪೊಲೀಸರಿಗೆ ತೆಗೆದುಕೊಟ್ಟಿರುತ್ತಾರೆ. P3 major, he also supported. ನಾನು ಐರಣಿ ಮಠದ ಕಾಂಪೌಂಡ್ ಕೆಲಸಕ್ಕೆ ಹೋಗಿದ್ದೆ, ಅಲ್ಲಿ ಕೆಲಸವನ್ನು ಕರೆದುಕೊಂಡು ಬರಲು ಹೋಗಿದ್ದನು. ಪೊಲೀಸ್ ನಿಶಾನೆ ಸಮಾಜದಲ್ಲಿ ಏನು ಬರೆದುಕೊಂಡು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದ ಸರಿ ಇದೆ. ನಾನು ಕೆಲಸಕ್ಕೆ ಹೋಗಿದ್ದೇನು, ಪೊಲೀಸರೇ ಮಾಲುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಬಂದಿರ್ತಾನೆ ಸರಿ ಇಲ್ಲ. ಸಾಕ್ಷಿ ಸಮೂಹದಲ್ಲಿ ಆರೋಪಿ ಮಾಲುಗಳನ್ನು ಕೊಟ್ಟಿರುತ್ತಾರೆ ಎಂದು ಇದರಲ್ಲಿ ಬರೆದುಕೊಂಡಿರುತ್ತಾರೆ.
Except PW13 ಉಳಿದಿರಲ್ಲ ಎಲ್ಲರೂ
ಎಲ್ಲ ಸಪೋರ್ಟ್ ಮಾಡೋರು.
PW1 ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಸಹಿ ಮಾಡಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಮಾಜರ್.
ಆಮೇಲೆ ಸರ್ ನೆಕ್ ಇಂಜುರಿ ಸ್ವಲ್ಪ ಡೀಪ್ ಹೋಗಿದ್ರೆ ಔಟೇ ಸರ್.
ಅಷ್ಟೇ.
ನಾನು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಸಹಿ ಮಾಡಿದ್ದೆ.
ಇಂಜುರಿ ಏನಾದ್ರು ಡೀಪ್ ಆಗಿದ್ರೆ ಮುಗಿದೋಗಿತ್ತು.
302.
ಇಲ್ಲ ಅವರು ಏನು ಗೆರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಅಂದ್ರೆ ಹಿಂಗ್ ಹೋಗಿರುತ್ತೆ. ದಟ್ ಈಸ್ ವೈ ಇಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಅಸ್ ಸಿಂಪಲ್.
ನೋಡ್ರಿ 307ಗೆ ಇಂಜುರಿ ಆಗ್ಲೇಬೇಕು ಅಂತನೂ ಇಲ್ಲ. ಇಂಟೆನ್ಷನ್ ಮಸ್ಟ್ ಬಿ ಗ್ಯಾದರ್.
ಅಲ್ಲ ಕರೆಕ್ಟ್, ಇಂಟೆನ್ಷನ್ ಇದ್ದಿದ್ರೆ ಅವನು ಇಲ್ಲೆಲ್ಲ ಮಾಡ್ತಾ ಇಲ್ಲ, ಎಲ್ಲ ವೈಟಲ್ ಪಾರ್ಟ್ ಹೊಡಿತಾ ಇದ್ದ. ಎರಡು ಕೈಯಲ್ಲಿ ಎರಡು ಇದೆ.
ಎಲ್ಲಕ್ಕೂ ಹೊಡೆದವನಲ್ಲ, ಇನ್ನೇನಾಗ ಕೇಳಿ ನೋಡಿ. ಯು ಸಿ ದಿ ಎವಿಡೆನ್ಸ್ ಆಫ್ ದಿ ಡಾಕ್ಟರ್ PW11. ಕಟ್ ಲ್ಯಾಸರೇಟೆಡ್ wound over the
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅದಕ್ಕೆ ಕನ್ಕ್ಲೂಷನ್ ಬರ್ತಾರೆ.
ಎಲ್ಲ ಎರಡೂ ಕೈಗೂ ಏಟ್ ಬಿದ್ದಿದೆ. He tried to ward off the injuries.
ಮತ್ತೆ ಡೆಮ್ನರ್ ಕೂಡ ಕ್ಲಿಯರ್ ಆಗಿ ರೆಕಾರ್ಡ್ ಆಗಿದೆ.
ಲೈನ್ ಕೈ ಏನೋ ಇಟ್ಟಿರ್ತಾರೆ, ಆ ಕೈಗೆ ಇಂಜುರಿ ಆಗಿದೆ.
ವ್ಯಕ್ತಿಯು ಕೆಳಕ್ಕೆ ಬಿದ್ದಾಗ ಚೂಪಾದ ಭಾಗ ಕಣ್ಣಿಗೆ ಚುಚ್ಚಿದರೆ ನಿಂತ ನಿಮ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆ ತರದ ಇಂಜುರಿ ಆಗುತ್ತೆ ಅಂತ. Recovery, everything. Good. Life.
ಇವಾಗ 60 ವರ್ಷ ಆಗಿದೆ ಸರ್. Intention was never to kill her.
What is his age?
Now he is aged about 60 years.
60. 46. Into incident ಆಗಿರೋದು ಯಾವಾಗ? 2016. 46 ಆದ್ರೆ ಈಗ 2026. 56.
58. ಅಲ್ಲ ಅಲ್ಲಿ ಕಡಿಮೆ ತೋರಿಸಿದ್ದಾರೆ ಇದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್.
ಏನ್ ಮಾಡ್ಬೇಕು? ಲೈಫ್ ಕೊಡ್ಬೇಕಾ ಕಡಿಮೆ ಮಾಡ್ಬೇಕು? ಕಡಿಮೆ ಆದ್ರೆ ಫೈನ್. ಕಣ್ಣು ಹೋಗಿದೆ ಎಷ್ಟು ನೀವೇ ಹೇಳಿ. ಕಣ್ಣು ಹೋಗಿದೆ, ಆಕೆ 2 ಮಕ್ಳು ಬೇರೆ ಇದ್ದಾರೆ.
In ಮಿಕ್ಕಿ ಟರ್ಮ್ ಸೆಂಟೆನ್ಸ್ ಸರ್ವ್ ಮಾಡುದು. Anyhow, he has to serve another 2 or 3 or 2.5 years. Let him serve.
ನಿಮ್ ಪ್ರಕಾರ ಈಗ 1.5 ವರ್ಷ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
1.5 ವರ್ಷ ಆಗಿದೆ.
ಇನ್ನ
ನಿಮ್ ಪ್ರಕಾರ 4 ವರ್ಷ ಆಗ್ಬೇಕಾ?
ನಿಮ್ 3 ವರ್ಷ ಹಾಕಿರೋದು ಅವ್ರು.
3 ವರ್ಷ
ಅಲ್ವಾ?
ಇನ್ನು 1.5 ವರ್ಷ.
1.5 ಹಾಕಿದ್ರೆ 1.5 ಉಳಿಯುತ್ತೆ.
1.5 ಆದ್ರೂ ಇರ್ಲಿ ಅವನಷ್ಟು.
ಇರ್ಲಿ, ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳಿ?
ಅಲ್ಲಪ್ಪ ಏನೂ ಇಲ್ಲ ಸ್ವಾಮಿ.
25 ಲಕ್ಷ ಕೊಡಿ ಕಂಪನ್ಸೇಷನ್. ಕಣ್ಣು ಹೋಗಿದೆ.
ಕರೆಕ್ಟ್, ಅವನಿಗೆ ಏನೂ ಇಲ್ಲ.
ಇಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ ನಿಮ್ದೊಂದು ಕಣ್ ತೆಗಿ.
ಅದು ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು, ಬಟ್ ದುಡ್ಡು ಕೊಡಕ್ಕಾಗಲ್ಲ. ಅದು ಬೇಕಾದ್ರೆ ಆಗ್ಬೋದು, ದುಡ್ಡಂತೂ ಅವ್ರ ಹತ್ರ ಇಲ್ಲ.
ಏನ್ ಮಾಡ್ಬೇಕು?
ಇದು I am doing this as a pro bono. This case also I am doing as a pro bono.
Pro bono ಆಗ್ಲಿ ಪರವಾಗಿಲ್ಲ, ಒಳ್ಳೇದು. ಮಕ್ಳಿಗೆ ಪುಣ್ಯ ಬರುತ್ತೆ. ಹೇಳಿ.
I don't think he has anything to pay. He has no capacity, otherwise I would have suggested it.
ಟೈಲರ್ ರೀ, ನೀವೇ ಸಜೆಸ್ಟ್ ಮಾಡಿರೋದು. ಟೈಲರಿಂಗ್ ಈಸ್ ವೆರಿ ಏನೋ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಟೈಲರ್ ಅಂತ. ಫೇಮಸ್ ಟೈಲರ್. ಇವಾಗ ಎಷ್ಟು ಒಂದು ಪ್ಯಾಂಟ್ ಹೊಲಿಯಕ್ಕೆ ಟೈಲರ್ಗೆ?
1,500 ರೂಪಾಯಿ. 1,500.
ಪ್ಯಾಂಟ್ ಹೊಲಿಯಕ್ಕೆ
1,500.
ಶರ್ಟ್ ಪ್ಯಾಂಟ್ ಅಂದ್ರೆ 1,500.
ಶರ್ಟ್ ಪ್ಯಾಂಟ್ ಅಂದ್ರೆ 2,500.
2,500.
ಅಲ್ಲ, now he is not doing that job also. Now he is not doing that job. ಅವರೇ ಹೇಳ್ತಾರೆ ಏನೋ ಅವನೇನು ಕೆಲಸ ಮಾಡ್ತಾ ಇರ್ಲಿಲ್ಲ ಅಂತ.
ಆಯ್ತು. Third, the appellant counsel and also appellant counsel in both the matters, and these 2 appeals are filed by the state as well as the accused. The trial court convicted the accused for the offence punishment section 498A and sentenced to undergo for a period of 2 years with fine of ₹5,000. And also for the offence punishment section 326 for a period of 3 years with fine of ₹30,000. And acquitted the accused for the offence punishment section 307. And then state has filed the criminal appeal number 104 of 2018 against the order of acquittal. And the accused filed criminal appeal. Accused has filed criminal appeal 1686 of 2017 against the conviction. The factual matrix of case of the prosecution is that the complainant is the brother of the victim and he is only a son to his father, and his father is having 3 daughters. Among them, the second daughter is injured Manjula, who married the accused around 20 years back and having 2 children. And they lived happily for some time. Around 3 to 4 years back, the accused started suspecting her fidelity and picked up quarrel for silly reasons and used to abuse and assault her. And on the particular date of incident, he assaulted her with the razor blade and machete. The complainant came to know all these facts from her sister as well as neighbors. It is also the averment in the complaint that her sister about 2 years back came to brother's house, Hariara, and was staying with him by doing tailoring work along with her 2 children. The accused frequently visiting their house was picking up quarrel with her sister. That on 6/6/2016, the complainant came to know from one Nagaraja Swami that accused around 11 a.m. came and assaulted her by means of razor blade on her neck of her left jaw, below left eye, right cheek, and eye, and caused bleeding injuries. And he said incident was witnessed by the neighbors, and they pacified the quarrel, and accused ran away from the spot and shifted the injured to the government hospital at Haryana. The complainant along with his mother visited the hospital and noticed that accused had assaulted her sister on 4 to 5 parts of the body by using razor and chopper. Also caused grievous injuries, and the injuries was not in a and as a result he was not in a condition to speak. The accused with an intention to commit murder of Manjula, PW5, assaulted her with deadly weapons. Based on the complaint, case was registered for the offence punishment in 498A and 307 of IPC, and police after the investigation filed the charge sheet for the offence punishment in 498A and 307 of IPC. The accused did not plead guilty and claims trial, and hence prosecution examined PW 1 to 13 and exhibit P 1 to 17 as marked, and MOs 1 to 4 are also marked. The accused was subjected to 313 statement, and the accused not pled any defense evidence. The trial court, having appreciated both oral and documentary evidence, since all the witnesses have supported the case of prosecution except the PW 13 and believed the version of the prosecution. However, not convicted the accused for the offence punishment of 307 but invoked section 326 of IPC. Being agreed by the acquittal for the offence punishment from 307, the criminal appeal number 104 of 2017-18 is filed by the state. The counsel appearing for the state, that is additional SPP, would submit that the evidence of PW2 was not properly considered by the trial court, and PW5 is the injured witness who deposed that accused came prepared with deadly weapon with an intention to commit murder, that is razor blade and chopper, and caused the injuries on the vital part of the neck as well as on the face. And also it is the contention of the counsel that when he aimed to commit the murder, the victim PW5 warded off those blows. As a result, she has sustained injury to both the palms. And the same is lost sight of by the trial court, and even the witnesses who have witnessed this incident and also the accused, when the PW5 came out from the house, they also witnessed the assault made by the accused, and the same is spoken by PW6, PW8, and PW9 is also deposed before the court that repeatedly the accused was assaulting the mother. The counsel also submits that the evidence of the doctor PW1 is very clear that injury is caused on the victim by using the weapons which were seized. The counsel also submits that recovery was made at the instance of the accused, and the recovery witness also supported the case of the prosecution. And all these materials were not considered by the trial court. The counsel appearing for the accused also filed the appeal in criminal appeal number 1686 of 2017. The counsel would vehemently contend in his appeal that the trial court committed an error in convicting the accused, even for the offence punishment 498A and 326. Learned judge failed to notice primarily admitted facts in the present case, which would establish that the accused has been falsely implicated in the case. The eyewitness admitted the victim at 11:45 a.m. And according to the prosecution, eyewitnesses witnessed the incident that accused ran away after witnessing the eyewitnesses. That is at 11 to 11:30 a.m. But incident was taken place at 11 to 11:30. The complainant, having received the information, goes to the hospital and see the victim, and then go to the police station and lodge the complaint. The complaint was lodged at 12:30. And the distance between the incident place and the police station is about hardly 3/4 kilometer. It is also contended that the learned judge has completely lost sight of the said facts into consideration. And when the said fact was confronted to the IO, he has categorically deposed that police identified accused on the basis of identification of the eyewitness. From the chronology of the events, it appears to be almost perfect case for conviction of the accused, and the said reasoning given by the trial court is erroneous. And police apprehended the accused on 6/6/2016 at about 2 p.m. when the accused got down from the bus. It is also contended that evidence of PW1 complainant was self-contradicting, and the evidence of prosecution is untrustworthy. The alleged eyewitness CW8 has not supported the case of prosecution. Regarding nature of injuries and also injuries and the evidence of doctor are contradictory to each other. The accused has been roped in the matter only in order to humiliate and harass him. And the very appreciation of the evidence by the trial court in coming to the conclusion that he committed an offence under 326 and 498A is erroneous. The counsel appearing for the state in support of the appeal would vehemently contend that evidence of PW5, who is the victim, and also the evidence of doctor who has been examined as PW11 is very clear that injuries could be caused by using the MO 123. The counsel also submits that recovery is made at the instance of the accused and recovery witness PW.
PW2 and 7.
PW2 and 7 have supported the case of prosecution for recovery, and nothing is elicited to dispute the evidence of these witnesses. The counsel also would submit that the doctor evidence PW11 is very clear that he had inflicted the injury by using the razor as well as machete, and these weapons could cause the injuries found on the injured. The counsel also would submit that the eyewitness is PW6, 8, and both of them have supported the case of the prosecution that when they heard hue and cry of the victim, they rushed to the spot and found the injured came out from the house, and even accused assaulted her. And having noticed the presence of eyewitnesses, accused ran away from the spot. And in the evidence of these witnesses also nothing is elicited with regard to these PW6 and 8 were not there at the spot. The other witness is PW9, who is the daughter of the accused and also the victim. And she also deposes before the court with regard to the accused was assaulting for trivial matters on the mother. And whenever food was not proper, he used to make her to stand outside the house in the night. And both of them were also sit along with the mother. And when she came back to house on that day, people are gathered near the house and informed about the incident, and immediately she rushed to the hospital. Mother was not having any conscience and found the injuries all over the face and also on the neck. And after treating her eye, she regained the conscience after 3-4 days. In an inquiry, mother revealed that her father made an attempt to take away her life. In the cross-examination of this witness also, counsel would submit that nothing is elicited with regard to the harassment and also the assault. The counsel also brought to notice of this court the evidence of the doctor and contend that even in the complaint itself, it is specifically stated that with an intention to take away the life, assault was made. The complaint was also lodged immediately within a span of 1.5 hours of the incident, that too by her brother. The counsel would submit that though not specifically deposed before the court by PW5 that with an intention to take away the life, the court has to take note of circumstances under which an incident was taken place, and also he went with weapon, razor and machete and inflicted the injury on the vital part. And also medical evidence is very clear that they had sustained injury to both the palm. And hence it is a bit case to invoke section 307 of IPC. The counsel appearing for the accused would submit that though it is stated in the complaint, exhibit P7 that with an intention to take away the life, and PW5 who has been examined before the court not stated in clear terms that with an intention to take away the life, injuries are inflicted. And also counsel would submit that though there are several injuries and those injuries on the face and no deep injury on the neck, and hence it is not a clear case of 307 and there must be intention to take away the life. The counsel also would submit that during the course of cross-examination, a suggestion was made to the PW5 that he was having affairs with the two persons, and though it is denied, and the third court not appreciated the material available on record, but committed an error in invoking section 326 and ought to have acquitted the accused and no trustworthy evidence before the court in order to accept the case of prosecution, and hence it requires reappreciation and acquittal. Having heard the appellant counsel and also the counsel appearing for the respondent, since there are two appeals, one is by the state and another by the accused, the point that would arise for our considerations are whether the trial court committed an error in convicting the accused for the offence punishable under section 498A and 326 of IPC. Whether the trial court committed an error in invoking section 326 instead of 307 and committed an error in acquitting the accused for the offence punishable under section 307. What order? Both the points for consideration are taken up together since both are interconnected with each other. Whether there was an intention to take away the life and also to take note of nature of injuries, and hence the evidence of each witnesses were also taken together for consideration. The law was set in motion by lodging the complaint by the complainant, who is none other than the brother of the injured. ಅವನೇನು ಯಾವಾಗ exam ಮಾಡಿದ್ರು? Who has been examined as complainant examine ಮಾಡಿದ್ದಾರೆ madam?
34,
PW4.
Manjunath.
And he categorically deposes before the court that he came to know about the same through PW6. And immediately he rushed to the hospital and lodged the complaint. On perusal of complaint exhibit P7, specific averment is made in the complaint exhibit P7 that he had found the injuries on her neck and also on her hand and also on her face. And also it is averred in the complaint that with an intention to take away the life, he inflicted the injury. And in the complaint itself, he has stated that this incident was witnessed by Nagaraja Swami and also Leelamma, Prabhavati, Basuraju and others. It is also specifically stated that having witnessed the eyewitnesses, he ran away from the spot. And the same is stated in the complaint within 1.5 hours of the incident, that is exhibit P7. The FIR is also registered in terms of exhibit P8 and law was set in motion by registering the case. The wound certificate, which is marked as exhibit P10, is very clear regarding nature of injuries are concerned, and injured was taken to the hospital at 11:30 a.m. within a span of 30 minutes of the incident and found the injuries total 7 in number. The evidence of PW1 is that the evidence of PW5, who is the injured. In her evidence, he says that accused is her husband. Her marriage was solemnized 23 years ago, having 2 children who are aged about 13 years and 14 years. And at the time of the incident, she was residing along with her brother Manjunatha, who is examined as PW4. And both accused and herself were not residing together. And when she was residing along with him, he was abusing in a filthy language and used to demand money. And she was also doing tailoring work. From the date of the incident, she is not doing any work. And it is also her evidence that when she was alone in the house, accused came with a razor blade and machu and abused in a filthy language and inflicted injury with razor blade on the left ear. As a result, she sustained cut injury. When she tried to ward off the blows, accused held her hair and inflicted injury near the neck and also on the cheek and hands. As a result, she has sustained bleeding injury. The court also noticed the injury mark on the face. And also it is her evidence that using the chopper assaulted above the neck and also on the backside of the head
Head and
shoulder. This incident was witnessed by Nagaraj Swami, Leelavati, Prabhavati. They came and rescued her and immediately taken her to in an auto rickshaw. It is also her evidence that as a result of injury inflicted on her right eye, she is unable to see. The court also noticed the same and recorded in the deposition itself, and also identifies MO 1 and 2. This witness was subjected to cross-examination. And in the admission, very clear that earlier husband and children were living at Harihara in a rented house. And also lived at Hospeta 13 to 14 years. And due to the difference between them, they are living separately from last 2.5 years. In the cross-examination, also she has narrated with regard to the incident and abuse made by the accused. And she was sitting on the sewing machine when the accused came and started assaulting her. But cannot tell which hand was used. And she observed the razor blade. And also admits that when the incident takes place and hue and cry, people will gather. And also the government hospital near the house. And categorically deposes that when she tried to escape from the clutches of the accused, he held her hair and inflicted the injury. In the cross-examination also, which stood the same by narrating how an incident was taken place. And even he has stated that Nagaraj Swami, PW6, who is an eyewitness also, shifted her to the hospital. And the evidence of PW6 eyewitness, PW6 also says that having heard the hue and cry, he rushed to the spot and noticed the accused, and the accused ran away from the spot. And then he shifted the injured to the hospital in an auto rickshaw. The evidence of PW7, PW8, Prabhavati, also reiterates the evidence of PW6 and found the injuries. And also accused was assaulting her. And at that time, the injured was on the floor. And blood was oozing from her neck. And the PW6 shifted her to the hospital. And she also identifies MO 1 and 2. This witness was also subjected to cross-examination. And in the cross-examination, illustrated that the PW6 house and also her house are neighboring houses. And also admits that there is an auto stand near the place of the incident. And hospital also at the distance of half a kilometer. And also, if any incident is taken place, people will gather. But she says voluntarily that more people were not there. Only 4 people came out from their house and witnessed this incident. It is suggested that he had not seen the accused earlier, but the same was denied. But he categorically says that on the date of the incident itself, he witnessed the accused and denied the suggestion that not seen the accused earlier. The evidence of PW8 is also corroborates with the evidence of PW5 and PW6. The other witness is PW9 is the daughter. She used to deposes with regard to causing of harassment and meeting the cruelty against her mother And she came to know about the incident when she came back to the house, and an inquiry revealed the same. And also she says that having regained the conscience by her mother, she revealed that with an intention to take away the life he assaulted. The other witness is PW11, who is the crucial witness, that is medical evidence, and doctor in his evidence says that issued the wound certificate and also stated there were 6 injuries in extract ಮಾಡ್ಕೊಳ್ಳಿ madam, PW11 ಅಲ್ಲಿ. And also identify signature in exhibit P10 and says 7th injury is in respect of her eye, and also she lost the vision in respect of her right eye, and the same is a grievous injury, and say injury number 1 to 6 are the simple in nature. And also given the report that those injuries could be caused if razor blade was used in terms of exhibit P11. This witness was subjected to cross examination, and in the cross examination answer is elicited that if MO2 was used with the tip of the MO2, injury could be deep. And also witness volunteers that if the said weapon was used and dragged, the nature of injuries caused and showed in the wound certificate could be caused. It is illustrated that he did not mention the opinion of the doctor. And also it is illustrated that if any person falls on the hard surface with sharp edged weapon, the nature of injury which was caused to the eye could be caused. The other witnesses are also supported in the case of prosecution except the witness PW13. PW13 is
Basuraj. He's also a neighbor and eyewitness.
who is also a neighboring witness, but he did not support the case of the prosecution, and it is the case of the prosecution that he also witnessed the incident. Having reassessed both oral and documentary evidence, it is very clear that incident was taken place on 6/6/2016 at around 11 a.m. and injured was shifted to the hospital by PW6 within a span of half an hour. And also the government hospital is very near the place of incident, that is at 11:30, and Dr. PW11 treated the injured. The injuries is very clear that cut lacerated wound over the left mandibular, left maxillary, right cheek, lateral angle of the right eye 8 centimeter, and cut lacerated wound over anterior neck left side 3 in number, and there are 3 injuries on the neck running 3 centimeters each, and right side 2 centimeter in number with avulsed edge 3 centimeter. The cut lacerated wound also found on the right hand 4 centimeter into 2 centimeter on the palm, and also in respect of left hand also over palm 4 centimeters, and hence these two injuries number 5 and 6 clearly discloses that at the time of when the attempt was made by the injured to ward off the blows, she had sustained injuries to both the palms of left hand and right hand. The injuries found on the anterior neck left side 3 in number 3 centimeters each and right side 2 in number is very clear that injuries on the neck. That is also a vital part of human. And other injuries also on the face, mandibular region, maxillary area, and also right cheek. And court also, while recording the evidence of PW5, noticed the injury marks on the face and also on the neck, and so also taken note of loss of vision of the right eye of the victim. And having considered the evidence of PW5 and also the PW11, within a span of half an hour, injured was treated by the doctor PW11 and also issued the wound certificate. And court also take note of nature of injuries 1 to 6 are simple in nature, but the injury on the right eye is grievous in nature and also lost the vision of the right eye. And no doubt trial court comes to the conclusion